Good morning. I hope you had a good evening, a good night, and a good morning. We proceed with our session today. It is the turn of the discussants to say 5 minutes of their thoughts, and then we will open the discussion to questions and answers and comments. I have been warned 2 times this morning that time is very important. So without wasting any further time, I would like to call Ms. Yasmin Chuben, who was formerly Rwandan National Public Prosecutor's Office, in that office, to say a few words in 5 minutes.
Thank you, Mr. Registrar. Good morning to all. It's lovely to be back in Arusha with all of you, and I'd like to add my thank you to the committee for their invitation. As Mr. Bongani just said, after serving as prosecution counsel at the ICTR, I worked with the International Crimes Unit of Rwanda's National Public Prosecution Authority, advising on the pre-trial stages of the 11 BIS transferred cases. I was with Mr. Mutangana at Kigali Airport when, following the 11 BIS decisions in appellate process, the planes carrying Mr. Uwikindi and Mr. Munyagishari landed in Kigali. Now, we heard a lot about cooperation between the ICTR and Rwanda yesterday. Today, I'll briefly touch upon a few of the realities on the ground in Rwanda in the early days of the 11 BIS transferred cases, in the hope that they may be instructive as lessons learned. My remarks center on the Uwinkindi, Munyagishari, and Mugesera cases. The first 2 were 11 BIS transfer cases, and the third, the Mugesera case, was sent from Canada to Rwanda, and Rwanda voluntarily assured the protections of the transfer law. I suggest that while the impact of the 11 BIS litigation in the pretrial phase of these cases has generally had and continues to have a very positive impact on Rwanda's justice system, there were also some hurdles in the early days. But I'll start with a few of the most significant positive impacts, some of which were discussed by yesterday's panelists. As mentioned by Mr. Karagisa and Mr. Mutangana, the 11 BIS litigation and the rejections of the initial applications led to extensive legal reforms in Rwanda. Some of the most significant of these were the abolition of the death penalty, guarantees of detention conditions that meet international standards, a new witness protection program, the inclusion of the right to confront witnesses, access to defense counsel of one's own choosing through legal aid guarantees, and immunity for defense counsel and witnesses. Now, while some of these legal reforms were limited to the transfer law cases, the 11 BIS litigation also led to broader reforms affecting the Rwanda justice system generally. For example, significant amendments were enacted to Rwanda's Code of Criminal Procedure and Rwanda's Genocide Ideology Law. So while Rwanda now has a 2-tiered justice system, the 11 BIS cases impacted the country's criminal justice system as a whole. This, in my view, is one of the most significant legacies of the 11 BIS transfer process, if not the ICTR as a whole. A second positive impact has been the increased cooperation between Rwanda and the ICTR. There was discussion yesterday of the relationship having been mixed over time, with periods of ebbs and flows. Currently, the relationship is at its most cooperative. The 11 BIS cases have led to constant dialogue, and this dialogue fosters mutual cooperation. A third positive impact is the fact that following the first 11 BIS transfers, Canada and various European jurisdictions have now also extradited Rwandan cases for trial in Rwanda. And the last positive impact I'll mention today is the fact that Rwanda is now at the forefront of domestic prosecution of international crimes. Few other countries have litigated as many such cases in their domestic systems. In fact, Rwanda's East African neighbors are now looking to Rwanda for advice on how to set up specialized international crime units in their prosecution services and judiciary, just as Rwanda has. For example, in the 2012-2013 period, delegations from the ministries of Uganda and Kenya traveled to Rwanda for meetings to seek such advice. Now I'd like to turn to some of the more difficult aspects that resulted in the transfer cases, and I'm told I only have 1 minute, so I'll focus on one. As Mr. Ahmed discussed the monitoring system yesterday, while this arrangement is now fully understood, accepted, and successful, it was initially difficult on a number of levels. When the arrangements with third parties fell apart, the monitoring duties remained with the ICTR and the MICT, and this arrangement was initially not viewed as fully independent. It was also difficult to accept the discrepancy between the scrutiny on the cases transferred to Rwanda versus those that had been transferred to France in 2007, and that were still in the investigative pretrial phases. The French cases were making slow progress and were not being monitored in the same rigorous manner. This has since been remedied, and both the cases in France and Rwanda are being monitored identically. Also, before the monitoring arrangements were normalized, the ICTR and MINC sent half a dozen different monitors in the course of about 2 years to monitor 2 cases. This constant turnaround was not ideal in terms of continuity of the relationship, but again, this has now been regularized. And I'm told I'm out of time, so I'll stop there.
Well, you know, in every country, lawyers self-regulate, and this is an example of self-regulation. Thank you very much, Ms. Chuben. I'd like to go to our next speaker, Ian Edwards, from the STL Defense. The floor is yours, sir.
Thank you, Mr. Registrar. I'll try to self-regulate as successfully as Yasmin has done. Thank you also to the organisers of this conference for inviting me to share a few thoughts. And I'll say at the outset that my thoughts will be a little less positive than those we've heard so far in respect of transfers and referrals to Rwanda. Obviously, these are numerous and complex issues, and I can't do them justice in the 5 short minutes that I have. I'm going to touch on one point in particular that I think is of fundamental importance in the context of the availability of a fair trial to a person accused of genocide in Rwanda. Let me start by saying what I think is uncontroversial. It is uncontroversial that a person, as a matter of principle, who is charged with a serious crime in a given country should, where possible, be tried in that country before judges of that country and in view of the population of that country. It is important for the individual victims of that person's crimes as alleged, but also to the population as a whole. This is preferable, but it is not always possible. It is not possible if minimum fair trial standards cannot be guaranteed. It was not possible in 2008 at the conclusion of the first tranche of prosecution requests for referral to Rwanda from the ICTR. And in my view, it was not possible in June 2011 when the Uwinkindi decision was handed down by the referral chamber. And I regret that it is still not possible today. With respect to the referral chamber in Uwinkindi and to Her Honour Judge Ari, who I see in the audience today, I disagree fundamentally with the conclusions reached. It is my view that Jean Uwinkindi and the other accused persons referred to Rwanda and extradited from third countries cannot have a fair trial in Rwanda. Certainly there is political will that these persons be tried before the High Court in Rwanda. There is no doubt about that at all. But there is one fundamental problem that I'll touch on in the short time I have, and that relates to the independence of the judiciary in Rwanda. Certainly the judiciary in Rwanda has made enormous strides in recent years. It has become more professional and better trained. In cases in which the government of Rwanda has no interest, in other words, in criminal cases that are ordinary criminal cases, I am fairly sure that accused persons can have a trial that meet minimum international standards of fair trial. But in cases in which the government does have an interest, there exists evidence that pressure is or may well be brought to bear on the judges in such cases to reach the verdict that they know is expected of them. And in the context of a genocide case, in the context of political cases, the verdict that is expected is that guilty verdicts are brought. Human Rights Watch produced a magisterial report in 2009 called Law and Reality. If you're not familiar with it, I would urge you to read it and familiarize yourself with it. It cited a significant amount of evidence from a range of well-placed sources, including judges themselves, that supports this suggestion. It's a report that is of some age now, perhaps, but the fact remains that the executive that was comfortable and prepared, the evidence suggests, to bring pressure to bear on the judiciary is the same executive that exists today. It is an authoritarian executive that has an iron grip on Rwandan society, that admits of no meaningful dissent, and that shows of every indication of remaining in power for the foreseeable future. And no one in this room should be in the slightest bit surprised when nothing changes after the next presidential elections in 2017. To quote from the English High Court in the few seconds I have remaining in the case of Virginia and others in 2009, the question whether a court is independent and impartial cannot be answered without considering the qualities of the political frame in which it is located. If the political regime is autocratic, betrays an intolerance of dissent, and entertains scant regard for the rule of law, the judicial arm of the state may be infected by the same vices. I know I'm out of time. There's obviously a great deal more to be said about this important subject, but I will self-regulate. Thank you.
Thank you very much, Mr. Edwards. Without further ado, I would like to ask the Registrar of the STL, Mr. Daryl Mundis, to present his, to make his presentation. Sorry. Thank you.
Thank you very much, Mr. Registrar, and I echo my colleagues' gratitude for the invitation to be with you for this very interesting conference. I'm going to talk to you this morning in the few minutes that I have about the Special Tribunal for Lebanon and cooperation issues. And in doing so, the issues that we face, I think, are very similar to the issues faced by other tribunals in many respects, but in other respects, we've got some peculiarities based on the way the Special Tribunal for Lebanon was established. And so I think it's important at the outset that I just briefly touch on the way by which the Special Tribunal for Lebanon was established. Following the attack that killed Prime Minister Rafik Hariri and 21 other individuals, the United Nations was asked by the government of Lebanon to assist, and a fact-finding commission, which ultimately evolved into an international investigation commission known as UNIC, was established in order to assist the Lebanese with the investigation. Over time, as that investigation uncovered some evidence, there was further calls for the establishment of a tribunal, and the government of Lebanon engaged the United Nations and an agreement was negotiated between the United Nations and the government of Lebanon for the establishment of a tribunal. Unfortunately, that agreement was never put to the Lebanese parliament for a vote. However, the government of Lebanon then asked the United Nations to put the agreement into effect, notwithstanding the fact that it had not been approved by the Lebanese parliament. As a result of that, the Security Council adopted Resolution 1757, putting into effect the terms of the agreement between the government of Lebanon and the United Nations. And it was on the basis of this Security Council decision that the Special Tribunal for Lebanon came into existence. It's important to understand this because the agreement, the terms of the agreement which the Security Council put into effect, as a document that was negotiated between the UN and the government of Lebanon, has certain limitations to it that are inherent in an agreement between one state and the United Nations. And the most fundamental of those goes to the fact that obviously the government of Lebanon and the United Nations, in effect a bilateral agreement, could not bind other states to the terms of or the cooperation regime that was set up within the tribunal statute. And so we have this fundamental issue here where the government of Lebanon has an obligation to cooperate with the Special Tribunal for Lebanon. No other state does, unless that state enters into a cooperation agreement with the tribunal. And I'll talk about that in just a moment, assuming I have enough time to get there. The other important aspect of this is that in our relationship with states, the rules of the tribunal puts a great degree of responsibility on the president of the tribunal. That much of his authority can and in fact is delegated to the registry, to the registrar, to myself, in order to adopt and to pursue and negotiate cooperation agreements and other types of agreements. There's one other fundamental difference between the Special Tribunal for Lebanon and the ad hoc tribunals such as the ICTR, ICTY, or the MICT, and that is that we have a high degree of cooperation with states for the purpose of funding. Lebanon has an obligation, again, under the statute and the agreement, to provide 49% of the tribunal's budget. The remaining 51% of the budget, I must go out and fundraise through voluntary donations from a number of states. And so I spend a considerable part of my time engaging with states, seeking donations from states, seeking to build the political will that will allow us to gather the necessary funding in order to operate. So there's a high degree of cooperation, voluntary cooperation from states with respect to funding where necessary and as required. Let me talk just briefly then about the cooperation regime. As I indicated, we have an obligation, or Lebanon has an obligation to cooperate under the statute. Other states we have to go out and negotiate cooperation agreements with. And unfortunately, we have not had a high degree of success with that. We have no formal cooperation agreements with any states. What we do have, however, are MOUs, Memoranda of Understanding, with 4 states that will provide us with cooperation and assistance on an ad hoc basis. So we are able to go out and get assistance from a certain number of states by way of ad hoc agreements. We can also get and have been successful in obtaining some degree of cooperation from states in the absence of a formal cooperation agreement. Of course, these are not binding, and so if states don't agree to cooperate with us other than Lebanon, the hands of the judges and the parties are really tied. So I see I'm also out of time, but I'm happy to answer any further questions during the Q&A session if anyone has any further questions.
Thank you very much, Registrar Mundis. And last but certainly not least, the legal officer from the Office of Legal Counsel, Philomena Cleobury. Would you please take the floor?
Thank you very much, Registrar Majola, and I would also like to thank the committee for having invited me to address you today. I've looked at this issue through the lens of an examination of the evolution of the mandates of the international and UN-assisted criminal tribunals. I think there are dual trends which are discernible in international criminal justice in the 2 decades since the ICTR's establishment. First, there can be no doubt that in those 20 years, we have seen an increased focus on the need to ensure accountability in the face of atrocities. However, with regard to the jurisdiction that's conferred upon the international criminal tribunals, we've seen a sharpening in focus and perhaps a tightening of the parameters. The paper that I've prepared for the colloquium examines the material, personal and temporal jurisdiction conferred upon each of the ICTY, ICTR, SCSL, ECCC and STL, and identifies that a narrower jurisdiction has been conferred upon each subsequent tribunal. And I think in this trend, we can identify an increasing emphasis on the importance of complementarity and the need to work with national legal systems. In the time available this morning, I'm just going to focus on a few features of the tribunal's jurisdiction which evidence this trend. With regard to the personal jurisdiction of the ICTY, the statute did not indicate that did not include a threshold limiting prosecutions to the leadership echelons or to those most responsible. The tribunal, under Articles 1 and 6 of its statute, has jurisdiction over all natural persons responsible for serious violations of IHL within its jurisdiction. However, as the work of the ICTY progressed, the focus did indeed shift towards the leadership echelons, with the Security Council in Resolution 1503 of 2003 endorsing the completion strategy in the strongest terms, which highlighted that the tribunal would concentrate on the prosecution and trial of the most senior leaders suspected of being most responsible for crimes within the ICTY's jurisdiction. And this resolution had echoed an earlier resolution of the Council, 1329 of 2000. Concomitant with this focus on the application of the finite resources of the international criminal tribunals to prosecuting higher level offenders, we can see the shift towards complementarity. The ICTY referred cases which it was not able to prosecute, referred to as Category 2 cases, to domestic prosecutors, and we've also heard obviously lots of discussion about the ICTR's practice in referring cases as well. The personal jurisdiction of the later tribunals is more restricted still. By the time of the establishment of the SCSL, the drafters of the statute did focus the personal jurisdiction on those who played a leadership role in the conflict. And the personal jurisdiction of the ECCC is limited to the senior leaders of Democratic Kampuchea and those who were most responsible for crimes within the ECCC's jurisdiction. The group of experts who reported prior to the establishment of the ECCC identified practical considerations relevant to this issue, including the feasibility of trying large numbers of defendants and the impact on national reconciliation. So this therefore brings us back to the principle of complementarity and the importance of both cooperation between the international criminal tribunals and domestic prosecutorial authorities, and of national prosecutors bringing cases involving serious international crimes themselves. There can be no denying that the resources of the international criminal tribunals, particularly those which rely on voluntary funding, are indeed finite. I would submit that an examination of the jurisdiction of the tribunals and the narrowing of that jurisdiction demonstrates that accountability for serious international crimes requires that the principle of complementarity operate effectively, particularly with regards to the cooperation of domestic justice mechanisms and international and regional courts. Thank you very much.
Thank you. I'd like us to give a round of applause to the discussants for their successful management of the time, thereby giving us ample time to ask and answer questions. And I'd like to immediately move to the question and answer session. And I'd like to appeal to all of us to do our best to answer, to make short and direct questions. Double-barreled questions are permitted, but if we could take them in the next round, I'd be pleased. So just one single question, because I know there will be so many questions coming. If you could just ask one question, and we've got quite a number of speakers here who have to answer questions, so it will take time. So can I open it to questions and comments? And would you please identify yourself before you ask your question? Thank you.
Yes, thank you, Chair. My name is Filberto Mayot Mariam, Prosecutor General, South Sudan. I actually had two questions, but I will limit myself to one, as directed by the Chair. My question goes to Mr. Anis. ICTR referred some cases to Rwanda to be handled by the National Public Prosecution Authority and Rwanda judicial authorities on the basis that Rwanda introduced legal and institutional reforms meeting institutional standards. Now the question is, why then sending monitors to go and monitor proceedings undertaken by Rwandan prosecutorial and judicial authorities, considering that monitors did not have power, or they were not to interfere or make any suggestions as to what should be done. Thank you.
Thank you very much. Next question. I'll take a couple of questions before I ask. Yes, sir.
Je vous remercie. Je suis Yaya Boiro, juge à la Cour de justice de la CEDEAO. Ma question s'adresse personnellement à M. Ali Sireba. Au cours de son exposé, M. Ali Sireba a fait ressortir que les chambres africaines extraordinaires ont un caractère supranational et qu'à ce titre, deux principes directeurs gouvernent leur fonctionnement, à savoir le principe de la primauté et le principe de la subsidiarité. Alors, au cours de son exposé, monsieur le procureur Bakefal, vous avez fait dire que l'instruction du dossier qui se trouve au niveau de ces chambres est presque terminée. Cependant, ils sont bloqués par le fait que le Tchad refusait de mettre à leur disposition deux personnes potentiellement poursuivies. Alors, par application de ces principes que je viens d'évoquer, est-ce que les chambres extraordinaires africaines ne pourraient pas demander au Tchad de se dessaisir du dossier? Donc c'était ma première question. La deuxième est subsidiaire, c'était par rapport au fonds alloué. Nous avons cru savoir que...
can I intervene, please? I had asked that for this round we ask one question. Thank you.
Je vous remercie.
To take the next question, please. Yes, sir.
Bernd Borchardt, former head of ULEX Kosovo. We heard some rather critical remarks from Ian about the credibility Rwandan courts have for him. There are different views in the room on that. But we also heard the analysis, or a very nice, comprehensive description of the hybrid courts. And I was wondering, well, is this the way forward? We in Kosovo tried to go that way, have a local majority and just one international judge on the bench to give courts higher levels of acceptance in the local population.
Thank you very much. There are no more questions? Well, I'd like to ask Anis, after that, Sir Ali Ba and Mr. Edwards to comment. Thank you.
Thank you for your question, Mr. Prosecutor General. I think this answer was provided directly in the referral decision as to why monitors were being sent. The referral decision mentioned that the 11 bis, the Rule 11 bis, has a provision of revocation at the request of the defense. And the revocation will be permissible if the defense can satisfy the bench that fair trial standards are no longer applicable or the accused's rights of fair trial are being prejudiced. And to observe the ongoing enjoyment of fair trial rights by the accused, of course, the accused could come back, but the referral decision said that we will send independent monitors for us to be continuously informed that fair trial rights are indeed being observed. So the answer to the question is that it is within the provisions of Rule 11 bis that once transferred, the case can be subject of revocation if those fair trial standards are no longer being observed. I hope I've answered that question.
Oui. Merci, M. Boireau. Le temps qui nous était imparti hier était un peu court. C'est peut-être pour cela que je ne me suis pas très bien fait comprendre. Je n'ai pas énoncé que la compétence des chambres était marquée par les principes de primauté et de subsidiarité. Primauté, oui. Subsidiarité, c'est la CPI. Parce que les juridictions ad hoc, lorsqu'elles sont créées, cela procède toujours d'un constat que les juridictions nationales traînent quelques déficiences, soit l'effondrement du système judiciaire, soit l'incapacité technique de rechercher les fugitifs, soit l'impossibilité de garantir des procès impartiaux et équitables. C'est pour cela que si vous regardez l'article 8 du statut du TPIR, l'article 9 du statut du TPIY, l'article 8 du statut du tribunal pour la Sierra Leone et l'article 18 alinéa 2 du statut des chambres africaines extraordinaires, le principe c'est la compétence concurrente, mais lorsque les juridictions ad hoc décident de se saisir d'une affaire, la juridiction nationale doit se dessaisir. Et cela à tous les stades de la procédure. L'article 18 alinéa 2 du statut des chambres africaines dit ceci: les chambres peuvent solliciter tout transfert de poursuite pénale et dans ce cadre valider les procès-verbaux et tout élément de preuve établi par les autorités compétentes des États requis. Dans le cas qui nous occupe, le Tchad refuse de livrer les co-inculpés à tort. Parce qu'il ne peut pas opposer les règles de droit interne comme quoi on extrade pas ses nationaux. C'est inopérant dans le cadre quand on est en face des juridictions internationales. Et également, comme le Tchad est un État de l'Union africaine qui a conclu un accord avec le Sénégal, cet accord-là engage le Tchad. Donc le Tchad devait respecter le statut du tribunal qui est annexé à l'accord signé entre l'UA et le Sénégal. Il ne le fait pas, c'est une épreuve de force, on n'y peut rien. Ben, on verra s'il y aura une solution politique ou s'il y aura une solution juridique. Mais pour le moment, c'est une épreuve de force, c'est une pure épreuve de force. Mais en droit, la solution du Tchad n'est pas défendable. En droit, elle n'est pas défendable. Mais ce qui marque le principe de la compétence des juridictions ad hoc et des juridictions hybrides, c'est le principe de primauté. Parce qu'elles sont créées spécialement pour juger ces crimes-là. Certes, elles ne peuvent pas connaître de toutes les affaires, donc il y a une compétence concurrente. Mais lorsqu'elles décident de se saisir d'une affaire, la juridiction nationale doit se dessaisir.
Thank you for that round of questions and answers. I would like to open to, oh, sorry, yes, my apologies to you. Yes.
Thank you. Thank you for the question. It's right to say that relatively recent reforms in the Rwandan legislation does provide for the possibility of an international judge sitting on the bench of, I believe, any criminal case, but certainly those transferred from the ICTR and those transferred by way of extradition requests from third countries. To date, no international judge has, in fact, ever been appointed to a bench trying an extradition case or a referred case. That's not to say it couldn't happen in the future, but it hasn't happened so far. And there's already been 2 referrals from the ICTR and a number of extraditions. To be honest, it's my feeling that there is no appetite amongst the Rwandan judiciaries to have a foreign judge sitting on such a bench. And in any event, unless the law were to be changed to allow for, instead of verdicts being returned by a majority of the bench to verdicts being returned by a unanimous bench only, it wouldn't address the problem of pressure being brought to bear on the majority of a 3-judge bench in the way that I explained a few moments ago, in the way that there is evidence to suggest, evidence that exists to suggest has certainly happened in the past and may well continue occurring. If 2 Rwandan judges can convict, there's no need to bring pressure to bear on an international judge in circumstances where it wouldn't work anyway, of course. I don't want to go for too long in my response to your question, but I focused on the question of the independence of the judiciary. The presence of an international judge sitting on a bench trying a genocide case in Rwanda still wouldn't address other serious concerns that many commentators have about fair trial rights in Rwanda, specifically the inability of the defense to call defense witnesses under the same conditions as prosecution witnesses can be called. But that may be a topic for another question.
I will open it up for further questions. Please remember to identify yourself. Yes, sir.
Bonjour, monsieur le greffier. Bonjour, chers confrères. Xavier Jean Keita, je suis le conseil principal du Bureau de la Défense à la Cour pénale internationale. Merci. Je vous prie de m'excuser. Je voudrais d'abord féliciter mes confrères et panélistes pour la franchise de leurs propos. Une réunion d'un tel niveau suppose que l'on ne pratique pas la langue de bois. Au moment où on parle de coopération entre le Rwanda ou la communauté internationale, les Nations Unies, qu'est-ce qu'il est fait exactement pour ce que je considère comme être un scandale ou notre faillite internationale lorsque des acquittés traînent dans cette ville et ne rentrent pas chez eux ou n'ont pas une vie décente que peut réserver la justice pénale internationale parce qu'ils sont tout simplement acquittés. N'est-ce pas une faillite internationale de notre part?
This one is working.
Je vous remercie, monsieur le greffier. Je suis Nuhun Diallo, le greffier adjoint de la Cour africaine des droits de l'homme et des peuples ici à Arusha. Ma question s'adresse à monsieur Ba à propos du fonctionnement des tribunaux hybrides. C'est que je voulais soulever la question de l'indépendance de la magistrature. J'ai compris que dans les tribunaux hybrides, souvent, il y a des magistrats qui sont nommés par le gouvernement concerné, tandis que des magistrats sont nommés au plan international. Alors, nous savons très bien que dans beaucoup de pays, la question de l'indépendance de la magistrature se pose, comme on vient de voir les questions soulevées tout de suite. Alors, est-ce qu'il n'y a pas un risque sur le fonctionnement d'un tribunal hybride quand il s'agit des magistrats nommés par le gouvernement concerné? Est-ce qu'il n'y a pas un risque d'influence? Je vous remercie.
Thank you. Yes, sir.
Thank you, Mr. Chair. I'm David Baxter Bakivinga, Senior State Attorney with the Directorate of Public Prosecutions, Uganda. This goes to Ian Edward. In light of the lack or perceived lack of independence of the judiciary, are you suggesting that this is a case of Victor's justice, given that the present authority in Rwanda were on the other side of the divide during the conflict? And one comment, are we seeing the redefinition of the genocide that occurred in Rwanda? Because in the early years, we used to hear that it was a genocide against the Tutsi and moderate Hutu, but in the address of the Prosecutor General yesterday, he was referring to it as a Tutsi genocide. How does that impact on the legacy of the tribunal? Thank you.
Thank you, Chairman. My name is Jacob Ondari, Deputy DPP from Kenya. My question is also directed to Edwards. I get the impression from him that there cannot be standards anywhere other than either the ICTR or ICC. I believe the President sent Anis to Rwanda to observe and see if the minimum standards are complied with. And I believe Anis reported back to the President. The President has not taken steps either to revoke the referral, which means to me that the standards or the trials meet minimum standards. We can have the best of standards, but we have minimum standards. We cannot have similar standards all over the world. Whether it's the ICC or ICTR, the standards may not be exactly the same. Now the question is his fears merely theoretical or speculative? Or does he have hard facts of what he purports?
There is a gentleman just behind you, and then we will take the answers.
Thank you. So Dov Jacobs from Leiden University. I'd like to challenge maybe one of the premises of the panel, which is fair trial rights. Because I tend to be defense-oriented, but just wondering, for the sake of conversation, this is an international criminal tribunal, it's not a human rights court. I'd like to relate the conversation we're having with Rule 11 bis with the conversation we're having at the ICC at the moment with complementarity, and whether assessing the capacity of a state to try a case should also depend on the evaluation of fair trial, and there have been some decisions which are ambiguous, but I'm just wondering if this is the role of an international tribunal and if it can adequately fill it, or that should be left to other bodies and organizations to deal with human rights. Thank you.
Thank you very much. After taking these questions, perhaps we should pause to hear what responses we can get. And I would like to offer Mr. Edwards the opportunity, because a lot of the questions seem to have gone his way.
May I first make some comments? Is it possible for Edwards?
I will give you after.
Well, there's a surprise. Can I just first address my friend Xavier Jean's question about the scandal of acquitted persons not being able to leave Arusha, stuck in a safe house a few kilometers from here with nowhere to go. I agree, it is an absolute scandal, and it's a scandal not limited to acquitted persons. It's a scandal that also applies in the context of those who have been convicted but who have served their sentences and still have nowhere to go. It's true to say that there have been some acquitted persons who, through the incredibly hard work of their counsel, who represented them at the ICTR, have been able to be relocated. And in particular, I turn to my friend, Maître François Roux, whose client, Mr. Bagarishima, was able to return, I think, to France through his exceptional efforts. Other lawyers, of course, have tried very hard to have their clients relocated to safe third countries. The problem is there is no political will in many, many countries around the world to host these acquitted. Pressure is brought to bear from the Security Council, from the prosecutor of this tribunal, from the president of this tribunal during their remarks to the Security Council, and nothing gets done. And it's difficult to know how third countries can be forced to take acquitted persons. I don't think legally they can. Politically, pressure can be brought to bear. So far, that has borne absolutely no fruit at all, and I agree that it's an absolute scandal. The question regarding my views about a lack of an independent judiciary in Rwanda is this: does this amount to victors' justice? I wouldn't go that far. I'm not saying that the judiciary, all things being equal, would not be able to render fair judgments, even in politically sensitive cases such as genocide cases. As I think I made clear a moment ago, the judiciary in Rwanda has developed enormously in recent years, and it is largely a very professional body. The problem lies with the executive, and the pressure that the evidence suggests it has been brought to bear and may well still be being brought to bear in politically sensitive cases. You then went on to ask whether the reference to the Tutsi genocide, how does that impact on the legacy of the tribunal? I'm not going to answer that question. and I'm not going to answer that question for a very good reason. I do travel to Rwanda. I don't want to find myself being arrested for genocide minimization by answering a question like that. And I say that with only half of my tongue in cheek. It's happened in the past. I don't want it to happen again, and I don't want it to happen to me. Another question was, yes, I was also asked if I believe that the only fair standards are those as practiced before the ICTR or the ICC. Well, I don't accept that at all. I don't hold up the ICTR or the ICC as paragons of virtue in terms of providing fair trial to accused persons. What I would say, I agree that the test under Rule 11 bis is that minimum international fair trial standards be observed in Rwanda. But those are minimum international standards, minimum universal international standards. Mr. Muhumuza yesterday said in a well-worn refrain that the Rwandan judiciary is always held to a higher standard than others. In other words, you're always picking on us, the Rwandans, and our judiciary. That's not true. Critics simply ask that the Rwandan judiciary, the Rwandan authorities generally, maintain the same fair standards of trial as are maintained everywhere else in the world. They are held to exactly the same standards as any other system in the world. And so I don't accept the premises of the question, I'm afraid. Whether my fears are theoretical or speculative, I've only dealt with the issue of the independence of the judiciary. There are plenty of other reasons why I think that accused persons charged with politically sensitive cases, and particularly cases of genocide, can't receive a fair trial. And I've already mentioned the issue of defense witnesses. But there is evidence to suggest, as I've already said, that pressure has been brought on judges by this executive, this very same executive that's in power today, on the judiciary in the past. And there is absolutely no reason to believe that the situation will be any different today.
Thank you. Thank you, Mr. Edwards. There was a question directed to Mr. Siriali Ba. Yes, would you please answer that one?
Merci. Vous avez raison, Monsieur Diallo. La question de la nomination et des critères d'avancement des juges est importante pour sauvegarder leur indépendance. Mais dans tous les tribunaux que j'ai mentionnés, tous les tribunaux hybrides, il est clairement énoncé dans les statuts que les juges et les procureurs, et même les procureurs, exercent leurs fonctions en toute indépendance. Ce qui n'est pas le cas dans les juridictions internes, où souvent les procureurs sont soumis à l'autorité hiérarchique du ministre de la Justice et peut-être du gouvernement. Mais dans tous ces tribunaux que j'ai cités, il est clairement énoncé dans les statuts que les juges et les procureurs exercent leurs fonctions en toute indépendance. Et devant les chambres extraordinaires africaines, les juges et les procureurs au sein des chambres extraordinaires africaines sont nommés par le président de la Commission de l'Union africaine. Ils ne sont pas nommés par le gouvernement sénégalais. Les présidents de cours d'assises sont étrangers, des Africains non sénégalais et non tchadiens. Les autres juges sont des juges sénégalais. mais tous sont nommés par le président de la Commission de l'Union africaine. Si vous prenez les chambres extraordinaires cambodgiennes, en première instance, c'est 5 juges, mais les décisions se prennent soit par consensus à l'unanimité, soit s'il faut aller au vote, à une majorité de 4 sur 5. Donc forcément, un juge international y participe. Devant la chambre d'appel, c'est 7 juges, mais c'est une majorité de 5 sur 7. Et comme il y a 3 juges internationaux, forcément un juge international y aura pris part. En Sierra Leone, il y a plus de juges internationaux que de juges sierra-léonais. C'était 2 juges internationaux pour un sierra-léonais. Au Liban, il n'y a que 4 juges libanais sur 11 juges. Donc les juges internationaux sont en plus grand nombre. Et dans tous ces tribunaux, il est clairement dit que les juges et les procureurs exercent leurs fonctions en toute indépendance. On a évoqué le cas du Rwanda. Moi, j'aimerais savoir au Rwanda qui nomme les juges et de qui dépend leur avancement. Si tout cela dépend de l'autorité politique, il faut peut-être revoir ça un peu et essayer de leur accorder un statut spécial. Parce que quand on attend son avancement et sa promotion de l'autorité politique, même s'il est énoncé quelque part qu'on exerce ses fonctions en toute indépendance, tous les hommes ne sont pas également indépendants. Il y en a qui sont un peu servent dans leur esprit et qui peuvent avoir tendance à vouloir accommoder ou faire plaisir à l'autorité politique. Donc les critères de choix et de nomination et d'avancement sont importants.
Thank you, Sireba. There was the last question asking whether some of the issues should not be the concern of the international tribunals. I wonder who would like to take that question. Richard, thank you.
Thank you, Bongani. I think it's been held here by the trial and appeal chambers that the court is the primary guarantor of fair trial rights, and they feature not only in the referral proceedings but in extradition proceedings, where one of the major issues raised by objectors is that an accused will not receive a fair trial where it is proposed to extradite or refer his case. So in that context, I believe, yes, it might be a human rights issue, but it's a fair trial issue, and as long as a court is the primary guarantor of fair trial rights, I think both the international tribunals and domestic courts faced with that question are in a position to determine the issue. But at a broader level, we don't live in utopia. The reality is that miscarriages of justice are a feature of any jurisdiction. You only have to go to the statistical annex to the annual report of the European Court, and in the column on fair trial right violations, you'd be surprised. There are hundreds. The question becomes whether there are avenues for remedy or redress. Now, in the case of referrals by the tribunal, the ultimate is a revocation. But before we get to that, the accused has to avail him or herself of local, appellate or review remedies. On the issue of independence of the judiciary, it was one that was heavily contested, both at the ICTR and no doubt in many European jurisdictions in extradition proceedings, most of which went up to the European Court, and in the case of Ahori Jeze, it went up to the Grand Chamber of the European Court of Human Rights. I don't think this is the appropriate forum to question the independence of the judiciary in circumstances where, you know, the appeals chamber here and the European Court have ruled that the judges in Rwanda are independent. Let's give referral and extradition a chance. In the case of ICTR, there are safeguards, monitoring and revocation. And I don't think, you know, the ICTR would shy, or the MICT would shy away from revoking a referral if it was satisfied that there were gross violations. In passing, I'd just like to refer to one of the most heavily contested extraditions, that of Abu Qatada to Jordan. You know, one following the press at the time, the executive and judiciary in Jordan was so vilified that, you know, I was surprised when he was recently acquitted, you know, of the crime. So I think let's give Rwanda a chance. The ICTR and MICT appeals chambers, the European Court have found that the judiciary is independent, and we have robust safeguards for the enjoyment of the rights of Owinkendi and Munyagishari and others. Thank you.
Mr. Mutangana has asked to make a brief comment also, and I've acceded to the request. Please.
Thank you. I just want to make a few comments regarding the fair trial issues, especially as raised by Mr. Edwards. I think that the recognition by the International Criminal Tribunal to transfer cases for trial before the Rwandan courts is a step in realization of all the achievements recorded for many years. Because when we entered the reforms, nobody forced us to go into the reforms, and we are not envisaging the transfer of any case, because when we had the constitution in 2003, as I mentioned yesterday, it came up with new structures of the courts, and so a lot of laws had to change to conform with the constitution. At that time, there was no any application, I think, by the prosecutor here to have a case transferred to Rwanda. Neither had Rwanda requested such, because that is early 2000. But as time went on, it was necessary that we go into the reforms that would eventually actually lead us to be where we are today, with the cases transferred to Rwanda and extraditions going on in different European countries. I would also like to say that also the decision by the European Court on Human Rights to accord extradition to Rwanda, for particularly 3 cases, I think, Ahorugeze, Bandora, and who else? And Mbarushimana, who recently came to Rwanda. This was to affirm the commitments that a fair trial is possible in Rwanda, generally looking into the context of human rights in criminal proceedings as well. Well, as my colleague said, ICTR is not a human rights court, though much as it may look into human rights issues, but I think when Mr. Edwards alleges that fair trial is not possible in Rwanda, I think I would personally say this is not true. And he hasn't been appearing before the Rwandan courts in the case of Owinkendi. I think he appeared probably here, but maybe he will come. He's welcome, but he's going to see for himself. And so I would say that I don't think there is any pressure that would be put on any Rwandan judge or any investigator with regard to any case, because these two, I don't see any other institution in this world better than the ICTR and the European Court to accept such a transfer and extradition and get satisfied of the circumstances back home. To sum up, I think what my colleagues said yesterday who have been involved in the proceedings, Mr. Karejesa has been involved in the proceedings here. 11Bs, Ms. Atika was involved with witness protection matters, and Mr. Anis has been involved in the monitoring processes until now. I don't think there is any alarming report as to issues related to the fair trial that would, at this moment, amount to revocation. Maybe, as Mr. Karejesa says, I think a chance has to be given to the national jurisdiction to do the job that has been assigned. Thank you so much.
Thank you, Mutangana, Mr. Mutangana. We have run out of time. We're supposed to stop at 8:30 or 9:45 according to the program. I would take one or two comments, and then they would like to rearrange the furniture here, and so they've asked us to give them that time. Judge Array? No.
Mr. Edwards again, let some other person ask first.
All right, he has had a chance. Let's see, Chief Tagu. Please introduce yourself.
I'll be very brief indeed.
Thank you.
I'm extremely surprised when we try to put human rights in respect of fair trials and the criminal process in different compartments. I think the lines are becoming very, very blurred. You look at the mandate of the Security Council now to the Human Rights Committee, human rights to investigate cases in the Congo, Sri Lanka, other places. They ask them to investigate human rights violations and criminal offenses that have been perpetrated. In respect of the specific case of the fair trial right, they are found in Article 14 of the International Covenant on Civil and Political Rights, and they're imported into the statute of the different courts. So sincerely, I wonder how we can put them in different compartments any longer.
Thank you, Chief. Dr. Maron?
Thank you, Mr. Registrar. I'll try to be very brief. Just to raise the point about kind of the shift we have seen over the past 20 years from the time that Rwanda essentially voted against Resolution 955 to today, that it is asking and has gone through a whole range of legal and institutional reforms in order to actually try serious international crimes. I think that what that speaks to, Mr. Chair, is the fact that we now live in an era of multi-level governance, especially over issues of international crimes. In other words, these are crimes over which various fora, various jurisdictions could exercise control. And that's why we have principle of concurrent jurisdiction in our statutes. I just wonder, based on Rwanda's experience and the reforms that it has undertaken over the years, maybe Richard can take this on, maybe Mr. Mutangana can take this on, what do you think are the lessons that other countries who may have to deal with similar crimes, Guinea, Uganda, South Sudan maybe, what are the lessons that these countries, in your view, should or could learn from Rwanda's experience? Thank you.
Thank you for that question. We have 2 minutes left, and I would rather use those to answer the questions that have been raised. Chief Tagu, I thought that you made a wonderful comment that we don't have to respond to, and I'd like to thank you. But the last question is pertinent, and I wonder who would try to answer that one.
For Dr. Maron's question and lessons that countries who may have to deal with such crimes should learn from, for example, from Rwanda, I just want to briefly look at what we have done in the past 15 years and so, not only with regard to the classic prosecution of crimes in the courts, but also you have to remember that we have dealt with the genocide in the traditional courts, Gacaca courts. These are normally the courts that emanated from the thoughts of the Rwandan people, who thought that it would be easier to handle these cases before a village-level court with the involvement of everyone to ensure that justice rendered is not only addressing the issue of justice per se, but also looking at the issues of reconciliation and speeding up of the trials. We like to call them back home, homegrown solutions. So I think homegrown solutions, given situations in different countries, can also work like that before they come up to these kind of major prosecutions like the ones we are dealing with. Because it was very evident that Gacaca could work, and we believe it worked, despite its own challenges and despite the critics about it. But we believe as Rwandans that it worked on so many cases, millions of cases, or hundreds of thousands of cases. So I think some countries have to also first look into, rather than having classic prosecutions, also issues of reconciliation are very important, especially in the domain of the judiciary, as well as we did with Gacaca courts back home. So there are a lot of lessons to learn. For me, I think that for countries that are coming out of conflicts and there are emerging crimes that have been committed and possible prosecutions and investigations, I think there is a need to look into homegrown ideas, reconciliation issues, and then come up with justice at the end of it. So I don't know whether any of my colleagues here would love to go on that.
I wouldn't give them that chance. Thank you. Mr. Edwards, I think it's time now to wrap up and go, because when you speak now, you might provoke other, you know, and I do not know whether we should go that route. Maybe we should talk over tea now. You know, I think so. I know that you want to call, but I think the organizers want the whole back and so on, and what you'll say will require that we talk a bit more. What remains for me is to thank you for listening to my panel, but also to thank them for the wonderful presentations that they have made. It has been a big panel, but it's been worth it. We have had a lot that would be difficult to summarize within a minute, but I know that everything is being recorded and it will appear in the report. I see now that it is time for tea, and I'd like to warmly invite you to tea so that the discussions can carry on there, and that we should be back here at 10 o'clock, because the next discussion, again on fair trial, will start, and I suspect the discussion may carry on in that session. Thank you very much.
Thank you. It is a great pleasure for me to be here today with so many practitioners from international courts as we discuss the legacy of the ICTR. I would like to commend the ICTR for organizing such an important conference, and I do thank the organizers for giving me the opportunity to moderate this distinguished panel on international fair trial and detention standards. We have a double topic today: international fair trial standards and international detention standards. Before we begin, I wanted to share with you some brief thoughts on these two topics. Fair trials. International fair trial standards, with respect to them, the ICTR and its sister institutions, the ICTY, were and still are pioneers among international courts. Together, they have made a colossal contribution to the practical development of procedural law, fleshing out theoretical and abstract rights into applicable courtroom standards and practices. In creating such standards, the tribunals drew on principles enshrined in the International Covenant on Civil and Political Rights, the European Convention on Human Rights, their own statutes, and of course a number of other treaties, as well as state practice. The tribunals became and remain touchstones for best practices in terms of protecting the fundamental rights of individuals accused of the most serious of crimes. Specific best practices adopted by the tribunals include, to mention just a few, is scrupulously guaranteeing the presumption of innocence, the right to be informed of charges, and the burden of proof which is borne by the prosecution, requiring disclosure of relevant information to defendants, guaranteeing the right to a reasoned opinion and to judges who are and are seen to be impartial, provision of adequate resources and facilities for the preparation of defense. The tribunal's commitment to fair trial rights remains extremely strong, and even in the course of completion strategy, where there is heavy pressure on the resources, the tribunals have made clear that they are committed to maintaining the highest standards of procedural justice, detention. Our second important topic involves international standards of detention, along with fair trial rights, maintaining the highest human rights standards in detention facilities is both essential to the tribunal's credibility and a field in which they have made excellent contributions. Outside the reviews of these detention centers have confirmed that their organizations, rights afforded to detainees, and attention to health and welfare are exemplary. I also note that some concern for administrative process aspects evident in our trials is also present in detention centers. If detainees are dissatisfied with a decision by the detention administration, they may petition the president of the mechanism for reversal of specific decisions or policies. I also note that the tribunal's detention centers are regularly visited and evaluated by the International Committee of the Red Cross, which provides confidential reports detailing their evaluation against international standards, and I can assure you we take these reports very seriously indeed. I will now turn to our panel. As you know, panelists will deliver presentations not exceeding 10 minutes. They can deliver presentations which are shorter than that, after which discussants will deliver 5-minute presentations. Following these remarks, I expect we will have a short discussion between panelists and questions from the audience. I will give the floor to the panelists following the very neutral alphabetical order, and I will start therefore with Mr. Pascal Besnier on my immediate right, who currently works in the registry of the ICTR. He has served, as you know, as acting registrar and at the Defense Council. Monsieur Besnier.
Thank you, Mr. President. Je vais parler en français, parce que c'est une belle langue qui n'est pas assez utilisée. Et je devais parler aujourd'hui du procès équitable devant le TPIR. Mais en fait, je vais vous parler d'autre chose. Je voudrais vous parler de la migration des gnous. Vous savez, ces grands animaux en Tanzanie qui sont à quelques kilomètres d'ici, qui sont magnifiques, qui ne connaissent pas de frontières, qui vont d'un endroit à un autre, d'un point d'eau à un autre, et qui voyagent librement, qui vont au Kenya, qui vont en Zambie, qui ne connaissent pas de privation de liberté. Ces animaux, ils ont une vie que certains êtres humains n'ont pas, à Arusha. Et je veux parler de la question des acquittés devant le tribunal pénal international. Ceux-là n'ont pas le droit d'aller et de venir. Ils n'ont pas le droit de franchir les frontières. Ils n'ont pas le droit d'aller dans ces points d'eau qui sont à l'extérieur du périmètre de la ville d'Arusha. Je voudrais vous poser une question. Savez-vous quelle est la différence entre une personne acquittée et une personne condamnée? Il y en a très peu. Notre ami Elie Sodjuré va vous expliquer dans un instant que les conditions de détention, aussi bien à Arusha que sur les lieux de détention au Mali et au Bénin, sont excellentes. Et il a raison. Ils ont le confort, ils ont de quoi se distraire, nourriture suffisante, la santé, mais ils n'ont pas la liberté. Les acquittés qui sont aujourd'hui à Arusha sont dans les mêmes conditions. Ils n'ont pas de difficultés physiques ni pratiques, mais ils n'ont pas cette liberté d'aller et de venir. Et surtout, ils n'ont pas la liberté la plus fondamentale telle qu'elle a été prévue dans la Convention européenne des droits de l'homme, à l'article 8, qui est celle de rejoindre leur famille, de mener une vie normale avec leurs enfants et leurs épouses. La liberté de rejoindre sa famille est un droit fondamental qui est consacré non seulement par la Convention européenne des droits de l'homme, mais par les droits nationaux. Pour prendre le cas de la France, toute personne qui a une épouse ou des enfants de nationalité française a le droit le plus absolu de rejoindre cette famille. Ce droit est dénié aujourd'hui aux personnes acquittées. Alors, deux questions essentielles en ce qui concerne les acquittés. La première question, c'est pourquoi est-ce qu'ils ne retournent pas au Rwanda? C'est la question que tout le monde se pose. Et la deuxième question, c'est pourquoi ne sont-ils pas accueillis dans les pays dans lesquels réside leur famille? Je crois que la réponse à la première question, elle est également incluse dans la seconde question. Pourquoi est-ce qu'ils ne retournent pas au Rwanda? Bon, il y a deux raisons, une subjective et une objective. La raison subjective, c'est que les personnes qui ont été acquittées, on parle aujourd'hui de 8 personnes à Arusha. 8 personnes ont été acquittées et sont toujours à Arusha, sur un total de 14 personnes. Par conséquent, plus de la moitié des personnes acquittées sont toujours à Arusha, dans une safe house. Pourquoi ne rentrent-ils pas au Rwanda? Eh bien, parce qu'ils expriment des craintes, en particulier la crainte d'être jugés pour d'autres faits ou sur d'autres charges par les autorités rwandaises. C'est une question subjective. C'est la façon dont eux-mêmes perçoivent cette situation. Ce n'est pas une question objective, je ne vais pas me prononcer là-dessus. C'est une question totalement subjective. Et la raison objective, qui est à mon avis la raison principale, c'est qu'ils n'ont rien au Rwanda. Leur famille a émigré depuis les années 90 en France, en Belgique, au Canada ou au Royaume-Uni. Ils sont devenus français, belges, canadiens ou anglais. Ils ont fait des enfants qui sont nés de parents français sur le territoire français. Leur famille a fait des enfants. Ils ont aujourd'hui des petits-enfants qui sont français. Si vous prenez une personne comme Prosper Mugiraneza, qui a été acquitté définitivement par la Chambre d'appel l'année dernière, s'il n'avait pas été arrêté par le tribunal, il serait aujourd'hui tout aussi français que moi. Il vivrait normalement auprès de sa famille française. Et donc, ils ne veulent pas rentrer au Rwanda parce qu'ils n'ont personne pour prendre soin d'eux. dans ce pays, leur famille en totalité a quitté le pays. Ils y seraient pratiquement des inconnus. Donc la raison pour laquelle ils veulent partir en France, en Belgique, au Canada, etc., n'est pas simplement pour une raison de confort, parce qu'ils pensent qu'ils auront une vie plus agréable dans un pays occidental, mais c'est parce que les seules personnes qui peuvent prendre soin d'eux sont en France, ou en Belgique, ou au Canada. Pourquoi est-ce que les États d'accueil ne veulent pas accueillir les acquittés? D'abord, et c'est là où je m'adresse particulièrement aux juristes dans cette salle, les États, certains d'entre eux, en tout cas la France, je vais me concentrer sur la France, ont des doutes sur la portée des acquittements qui ont été prononcés par le tribunal. Ils estiment, à tort, que ces acquittements sont dus à des erreurs de procédure. Ils estiment que le procureur a probablement oublié ou négligé de soulever un élément important. Ils estiment que la Chambre d'appel a fait un travail qui consiste seulement à vérifier l'intégrité de la procédure et ne s'est jamais prononcé sur le fond du droit. Ils ont cette opinion et ils l'écrivent dans les jugements qui sont rendus par les juridictions françaises. Ils écrivent, pour refuser l'accueil des personnes acquittées, que le tribunal pénal international pour le Rwanda se base uniquement sur des preuves circonstancielles. La France ne sait pas ce que c'est qu'une preuve circonstancielle. C'est une notion qui lui est totalement inconnue. Et ils écrivent que les acquittements ne sont pas des acquittements gravés dans le marbre. Je rappelle quand même que pour le procès Mugenzi Mugiraneza, il a fallu 400 jours d'audience, 399 jours d'audience pour le procès et une pour le procès en appel, et que 171 témoins ont été entendus au cours du procès. Ce ne sont donc pas des procès qui ont négligé l'essentiel. Ce sont des procès qui sont allés au fond des choses. Et ça, il faut l'expliquer aux Français, il faut l'expliquer aux Belges, il faut l'expliquer aux Canadiens, il faut l'expliquer aux Anglais. Il faut le dire, que les acquittements sont des acquittements définitifs qui ont soulevé chaque pierre et derrière laquelle on a regardé tous les témoins. Les Français ou d'autres pays soulèvent également des questions bilatérales. Alors ça, c'est curieux parce que les Français pensent que s'ils prennent des acquittés du TPIR, ils vont avoir des problèmes avec les Rwandais. Et les Rwandais nous disent exactement le contraire. Ça leur est égal. Ils sont des gens libres, aussi bien pour nous que pour les Rwandais, que pour les gens qui participent à leur relocalisation. Donc il faut également clarifier cette question bilatérale. Et enfin, les Français ou d'autres pays, plus la Belgique. J'avoue que la Belgique a fait des efforts plus qu'aucun autre pays n'en a fait jusqu'à présent. Mais en ce qui concerne la France, elle soulève la question de l'ordre public, en estimant que la simple présence d'un acquitté rwandais constituerait un trouble à l'ordre public sur le territoire. Parce qu'il y a la diaspora du Rwanda et que les victimes verraient d'un mauvais œil un ministre du gouvernement Kambanda s'installer comme un voisin à côté de chez lui. Là aussi, je pense qu'il y a un travail de pédagogie à faire. Des acquittés ont déjà été relocalisés en France et en Belgique. Et ils n'ont pas causé le moindre trouble à l'ordre public français. J'en termine en disant que ce ne sont pas les seules solutions. Nous travaillons sur ces questions depuis plusieurs années. Ça a commencé avec Adama Dieng et on continue à travailler sous la direction de l'actuel greffier. Ça n'est pas terminé. Le mécanisme prendra certainement sa part du fardeau et nous l'aiderons, nous tâcherons de lui donner l'impulsion nécessaire. Je leur souhaite bonne chance. Je souhaite bonne chance aux acquittés et je vous remercie de bien vouloir diffuser cette parole là où vous le pouvez. Merci.
Besnier for focusing on this question of people acquitted or who have completed serving their sentences. I do think that we have in this area a human rights deficit. We cannot create, we, the international community, cannot create international criminal tribunals without reflecting a little bit about the fate of those people for after they are released. In every speech to the General Assembly and often in the Security Council, I appeal to membership to try and take at least one of those people. We are not talking about hundreds. We are talking a very limited number, and yet our efforts and efforts made by my predecessors and colleagues, the president of the ICTR, for example, and the registrar of the ICTR have not accomplished much. We will now turn to our second speaker. Elisa Jurg is an operation officer at the United Nations detention at the UNDF and has previously served as a UN security officer and as a police officer in Nigeria. I turn to you, 10 minutes.
Thank you, Mr. President. Good morning, ladies and gentlemen. My presentation is on application or implementation of the International Minimum Standard for treatment of prisoners at UNDF. The United Nations has for several years explored various ways of safeguarding human rights of accused persons by formulating rules to ensure humane and efficient operation of the penal institution. The origin of the rules can be traced back to the standard minimum rules for the treatment of prisoners adopted by the first United Nations Congress on Prevention of Crime and Treatment of Offenders held in Geneva, 1955. These rules have been brought to bear in formulation of policies at the United Nations detention facility to ensure best practice in detention management. The UNDF was established on 26th of May, 1996. Its main objective is to ensure general welfare, safety, security, and while undergoing trial for war crimes allegedly committed in Rwanda in 1994. Since its inception, the UNDF has admitted a total of 81 detainees. Today, the number has dropped to 13. This is because some are presently serving their sentences in third country, some have been acquitted, some transferred to the jurisdiction of Rwanda, and 3 died in hospital while still undergoing a trial. To fulfill the requirement of the United Nations minimum standard for the treatment of prisoners, the following amenities and procedures are put in place at UNDF. Each detainee is accommodated in a self-contained cell. Self-contained cell in the sense that the cell has a toilet, a shower with cold and warm water. Each detainee has immediate access to medical care, laundry, gym, library, computer room without internet. Without internet. Food prepared by qualified cooks under the supervision of a dietitian. Bearing in mind the fact that poor food quality is a common cause of discontent and sometimes riots in prison, the UNDF has put in place a nutrition committee comprising detainee compound leaders, 1 dietitian, and 1 cook. In addition to the computer room, detainees are allowed to purchase personal laptops. One of the lessons learned in this regard is that the introduction of personal laptop marked the beginning of new challenges to security, as this afforded some detainees opportunity to smuggle in modems ostensibly as mere flash disk. These are usually confiscated if found during our periodic search or in the course of search during usually conducted when detainees are returning from outside, when they go out for medical checkups or they are returning from court or they have just received their visitors. Detainees are allowed to be visited by lawyers, representative of various religious denominations for the purpose of worship, English language teacher for the purpose of education, family and friends. Closely related to this issue of visit is the introduction of the privilege of conjugal visits since the month of May 2008. As our experience has shown in this connection, or as part of lesson learned, the introduction of conjugal visit has some positive effect, positive psychological effect on the behavior of detainees, as some of the detainees who have hitherto been unruly in the detention facility suddenly change their attitude to be quite amenable to discipline. As a disciplinary measure, corporal punishment or the use of isolation is not allowed at UNDF. Rather, punishment such as confiscation of the offending material or suspension of telephone calls to family and friends may be imposed. Detainees, as the President earlier mentioned, have right of appeal against punishment. Inspection visits. Apart from visits by the registrar of the tribunal, the International Committee of Red Cross, ICRC, also visits the detention facility at regular intervals for inspection of the condition of detention. The recent ICRC visit was from 23 to 24th of September 2014. It is remarkable to note that with this approach to detention management, UNDF has not recorded a single incident of prison riot, jailbreak, or suicide. Training of officers as a legacy. One of the activities of UNDF that stands out as a legacy is the propagation of the international minimum standard for the treatment of prisoners through on-the-job training. The training often involves auxiliary training programs designed to ensure enhancement of the international minimum standard for the treatment of prisoners. These auxiliary programs include stress management, first aid, firefighting skills, etc. As of January 2014, approximately 550 Tanzania prison officers have benefited from these training programs. Others who have benefited from this training are prison officers from third countries that are party to agreement for enforcement of ICTR sentences, that is, countries like Benin and Mali. In summary, it can be said that the lesson learned from the implementation of the international minimum standard is that respect for human rights of detainees promotes orderliness in prison environment and a greater sense of professionalism in prison management. Thank you.
Thank you very much. I would like to draw your attention, if I may, very briefly, to another aspect of humane conditions of detention. Of course, our focus is detention centers managed by the United Nations, by us, and for which we are responsible. But I would like you to know that when a question comes up, whether to transfer someone for trial in national jurisdictions under paragraph 11b, we routinely inquire not only into fair trial standards, but also we try to make sure that humane conditions of detention will be provided. Our next speaker is Peter Robinson, a very prominent attorney who has served in key defense roles in both the ICTR and the ICTY. Peter.
Thank you, Mr. President. May I have your permission to approach the podium so I can operate my PowerPoint? Yes. Thank you.
Permission that does not change the 10 minutes, mind you.
Thank you very much. Okay, it's wonderful to be back in Arusha with everyone, old and dear friends, and sights that I remember, smells and sounds. I'm going to be very brief, and I hope you'll find something interesting and useful about my presentation on disclosure. So I'll tell you, first of all, the 5 truths about disclosure at the ICTR. The first one is disclosure was crucial. That's because most of these cases at the ICTR turned on credibility. It's a fact of common knowledge that there was a genocide in Rwanda, and the issues of the person's individual criminal responsibility were paramount. And those issues often turned on testimony of alleged eyewitnesses. And to find out what those witnesses had said about those same events on previous occasions, what other people had said, consistent or inconsistent, was critical for the judges in order to determine whether what was being alleged against the accused was true. And that could only be accomplished with full disclosure so that the judges had the most complete information available to them when they made that decision. Truth number 2, false testimony was given at ICTR trials. Rwandans came to this tribunal and testified to what was in their self-interest. Sometimes that self-interest was motivated by money, sometimes by the belief of reward, sometimes by the belief of what the government would want them to do, sometimes by loyalty to the accused, sometimes for political reasons. But many lies were told in trials in this tribunal, which also made disclosure crucial. Truth number 3, ICTR prosecutors frequently violated their disclosure obligations. This is well documented in almost every trial, in almost every judgment or case at the ICTR, and I will simply add that I don't believe it was due to dishonesty. Truth number 4, ICTR accused frequently violated protective measures. Information was shared at the UN detention facility. That's how we actually learned of most of the disclosure violations. Truth number 5, ICTR judges weren't tough enough on disclosure issues. The ICTR judges looked to prejudice to the accused when deciding whether to enforce disclosure regimes. And they were very reluctant to exclude any evidence for a violation of those regimes. Unfortunately, this focus on remedial measures rather than on sanctions caused the violations to go unpunished. It was very difficult to show prejudice in a case. You receive a witness statement in the middle of a person's testimony. You have the statement. Maybe if you had that statement before you started your cross-examination, you could have shaken that witness, you could have shown him to be completely untruthful, and judges from the get-go would have been skeptical, dubious, the demeanor of the witness would have changed, and the outcome of whether that witness was believed would be completely different. That's all speculative. it's very difficult to show. So by requiring and focusing on prejudice, judges were finding that an accused could not show that he was prejudiced and therefore provided no remedy for the disclosure violations. Disclosure violations, though, were not offenses against the accused, but they were offenses against the administration of justice, just like disclosing the identity of a protected witness or by filing frivolous motions, none of which required a showing of prejudice or bad faith. And unfortunately, I believe that this resulted in the lack of curtailment of disclosure violations at the ICTR, which continued throughout its life. The judges' jurisprudence that they made about disclosure was wonderful. The language in the decisions couldn't have been better. The right to, or the obligation of disclosure is as important as the right to prosecute. The appeals chamber warned the prosecution in strongest terms in several judgments, as did trial chambers. But in fact, the enforcement was lacking and the violations continued. Now, I could tell you a lot about the jurisprudence of disclosure. I spent a lot of time litigating that here at the ICTR, but instead I'm going to give you a little gift. I kept actually summaries of all of the decisions of ICTR cases from the beginning until today as a discipline for myself, actually, to read those decisions, to write something down so I could find later and cite back to the judges their jurisprudence on behalf of my client. And I've kept that up, and it's now run some 700 pages. It's organized by article or rule of the statute. And if you looked, for example, under Rule 68, you would find different topics under which decisions have been made. If you click on the table of contents to the page, let's say, for alibi, you'll find a small summary of the case about alibi and disclosure, and a footnote, and the footnote gives you the citation to the case decision and the paragraph in which that's cited. You can get all this at my website. If you click on Research Tools, you can have it for free, and I would urge you to use it, because I think for those of you that are researching the jurisprudence, it's a pretty good tool. Okay, well, this was disclosure at Nuremberg. Really, this is an actual picture of OTP in Nuremberg. This is disclosure at the ICTR. This will be disclosure in the future. And the last question I'd like to address is, what is the legacy of the ICTR when we start dealing with terabytes of information? And my bottom line is that the legacy of the ICTR is that the rules were great, the jurisprudence was great. None of that needs to be changed. But what needs to be changed is the attitude that disclosure violations are somehow to be not taken as seriously as other violations of fair trial rights. And I hope that in the future, the tribunals will build upon what the ICTR did and bring disclosure into the 21st century. Thank you very much.
Peter, before you disappear, what in your view would be a measured, reasonable, but effective remedy to violations of disclosure?
Thank you, President Morona. I think it would depend on the situation. I think the very first thing should be that if witness statements, not all witness statements have been disclosed, that the witness cannot be called. And therefore, prosecutor would know that if he fails in his obligation, and a defense lawyer also, you fail in your obligation to disclose all of the statements of your witnesses, you don't call that witness. And believe me, I tell you as an advocate that I would be there with my team making damn sure that every witness statement was disclosed. And secondly, for other violations, I also think that there should be sanctions, warnings under Rule 46, and if it repeats, there should be sanctions against the individual who's responsible for the violation.
Thank you very much. Please do take your seat. Our next speaker is James Stewart, who, as you all know, is the Deputy Prosecutor of the International Criminal Court. He has also served in various roles at the ICTR-TPIR, including as Chief of Prosecutions and as Chief of the Appeals and Legal Advisory Section. Mr. Stewart.
Thank you, Judge Marone. I won't comment on some of the observations that my friend Peter made. Maybe we'll have a chance to speak about that later. Let me speak about fair trial rights, but from the prosecution perspective. And I would like to start by saying that the concept of fair trial rights transcends the scope of the rights of accused persons to encompass the interests of victims and witnesses, the right of the prosecutor to fairness, and societal interest in fair trials. My focus today, however, will be on the prosecutor's role in securing a fair trial for the accused, even though I'm going to say a word or two about the other interests I just mentioned. The prosecutor, and I agree with Peter wholeheartedly on this point, the prosecutor plays a vital role in protecting the right of the accused to a fair trial and in contributing to the ability of the trial chamber to conduct a trial that is both fair and expeditious. An obvious point is failure to make disclosure slows everything down, and I'll be coming to that in just a moment. Now, my frame of reference, of course, is the Rome Statute of the International Criminal Court, and I'm assuming that the jurisdiction of the ICC is properly engaged. As you know, the ICC is a court of last resort, and issues of jurisdiction and admissibility have to be determined before the prosecutor can properly intervene in any situation. A number of provisions in the Rome Statute and rules of procedure and evidence serve to guarantee fair trial rights. And a key provision is Article 64, Subarticle 2, which requires the trial chamber to ensure that a trial is fair and expeditious and is conducted with full respect for the rights of the accused and due regard for the protection of victims and witnesses. What is a fair trial? It's been said that a fair trial implies balance. As a legal concept, fairness is fundamental to the very idea of justice. Fairness of the proceedings includes respect for the procedural rights of the prosecutor, the defense, and victims. The Rome Statute directs the prosecutor in the exercise of her duties and powers of investigation to establish the truth by extending the investigation to cover all facts and evidence relevant to the assessment of whether there is criminal responsibility under the statute. And in doing so, she is to investigate incriminating and exonerating circumstances equally. Such an approach is a reflection of the qualities of impartiality and independence that the prosecution must display. However, the prosecutor is not neutral. She is a party to the proceedings. As an advocate in what is essentially a hard-fought adversarial proceeding, her counsel, like any other advocates, are entitled to advance their position forcefully and effectively. After all, the ICC was established to help put an end to impunity for the most serious crimes of international concern through effective prosecution. Nevertheless, the prosecutor, while conducting her case firmly and pressing it to its legitimate strength, must do so fairly. As Judge Shahabuddin of the ICTR Appeals Chamber observed, the prosecutor is not required to be neutral in a case. She is a party, but she is not, of course, partisan. While a prosecution must be conducted vigorously, there is room for the injunction that prosecuting counsel ought to bear themselves in the character of ministers of justice, assisting in the administration of justice. Ultimately, the role of the prosecutor is to assist the chamber to discover the truth in a judicial setting. Clearly, then, the prosecutor has a vital role to play in relation to the guarantee of a fair trial for an accused. She's not simply bent upon securing a conviction by any means. The most fundamental right of an accused is the right to be presumed innocent. The burden is upon the prosecution to displace the presumption of innocence by proving the guilt of the accused beyond a reasonable doubt. The Rome Statute is careful to guard against the reversal of the onus of proof. An accused on trial at the ICC has the right to know the charges, have the assistance of counsel, challenge the prosecution evidence, present defense evidence, understand the proceedings and evidence, and remain silent, among other rights. All of these rights go to protecting the ability of the accused to make full answer in defense to the charges against him or her. However, the right to make full answer in defense cannot be effectively exercised unless the prosecution fulfills its obligations to the accused under the Rome Statute. To enable the effective exercise of most of the rights I've just mentioned, timely disclosure by the prosecution is essential. And you can see the emphasis that Peter has placed upon disclosure. Disclosure is an obligation that accords with the prosecutor's responsibility to investigate all facts and evidence relevant to the assessment of criminal responsibility, and to investigate incriminating and exonerating circumstances equally. It's also fundamental to a fair trial. It's one of the most onerous duties that the prosecution has. Its competent and timely discharge contributes immeasurably to the ability of the trial chamber to ensure that the trial is fair and expeditious. Indeed, from the perspective of the prosecutor as advocate, efficient discharge of disclosure obligations inspires trust on the part of the trial chamber, and trust is essential to effective advocacy. It also demonstrates competence and mastery of the case. Moreover, it inspires confidence in the prosecution on the part of the defense. And this can help in the management of a long and difficult trial, even in the context of hard-fought adversarial proceedings. The obligation to disclose is a broad one, encompassing, of course, the evidence the prosecution intends to use in its case, but also evidence and information that may be helpful to the defense or affect the credibility of prosecution evidence. As Peter has mentioned, at ICTY and ICTR, the obligation of the prosecution to disclose information helpful to the defense was not considered to be a secondary one, but, quote, as important as the obligation to prosecute, unquote. The same is true at the ICC. There are certain restrictions on disclosure relating to security needs of victims and witnesses, national security concerns, public interest considerations, and the confidentiality of internal work product. But the ICC disclosure regime is fundamental to the guarantee of a fair trial. And it's difficult to imagine how a trial chamber could ensure that a trial is fair and expeditious without the full cooperation of the prosecution in matters of disclosure. I'm going to leave it there for the moment. I've treated these issues in much more detail in the paper that I was required to produce to be here. The security and well-being of victims and witnesses is a preoccupation of the ICC. And chambers may order various protective measures for victims and witnesses, and the court has an active Victims and Witnesses Unit, or VWU, set up in the registry. The prosecutor, too, has obligations respecting the security of victims and witnesses, and she must be sensitive to the needs of especially vulnerable witnesses, such as children and the victims of sexual trauma. Thus, the prosecution must sometimes balance the security needs of victims and witnesses against its disclosure obligations to the defense, and may seek the assistance of the chambers in this regard. The prosecutor is also entitled to fairness. At trial, the prosecution must be granted the genuine ability to present its case and to be apprised of and comment on the observations and evidence submitted to the court that might influence its decision. This, too, is fundamental. It's been said that the prosecution has the burden of telling an entire story, of putting together a coherent narrative and proving every necessary element of the crimes charged beyond reasonable doubt. In particular, therefore, the prosecutor must have the ability to tender her evidence free of outside hindrance or interference with witnesses. Indeed, the obligation of states parties to cooperate with the ICC and to assist the prosecutor in her investigations and prosecutions serves to protect the right of the prosecutor to exercise her powers and fulfill her mandate under the Rome Statute. The defense also has certain obligations of disclosure to the prosecution respecting the defense of alibi, any defense relying on mental disorder or impairment, or any novel defense based in law. And all of these provisions serve fair trial interests and the ability of the trial chamber to determine the truth. Just a word on the interest of the international community in fair trials. The states parties had as an objective in establishing the ICC to punish the perpetrators of the most serious crimes of concern to the international community as a whole, since such atrocities shock the conscience of humanity and pose a threat to the peace, security, and well-being of the world. There is thus a strong societal interest in a trial on the merits of cases that come before the ICC. In light of what I've been saying, however, a trial on the merits means a fair trial on the merits. Fair trials have an intrinsic value, since they ensure outcomes that have credibility and enhanced respect for the rule of law. A fair process serves the truth-finding function of a trial and offers greater assurance that the final judgment will be accurate. In cases where the most serious crimes of concern to humanity are alleged to have been committed, justice must be done and be seen to be done. To conclude, by respecting the rights of the accused to a fair trial, and in being sensitive to the needs of victims and witnesses, the prosecutor, even as she carries out her mandate vigorously and with determination, not only fulfills the letter of the law, but upholds the values that the law enshrines. Thank you.
Much, Mr. Stewart. As we are discussing and often criticizing aspects of present-day due process and fair trials, it is only fair to remember what tremendous progress in this field international criminal justice did since Nuremberg. May I remind you that the famous charter written in London, the Charter of Nuremberg, did not contain provisions even on such elementary matters as burden of proof. Nothing about burden of proof. And the Soviet Union tried to argue in Nuremberg that in fact that burden should rest on the defendants. This was not accepted, this will not surprise you. And although nobody in the beginning of the trial believed that any acquittals will result from this trial of 22 top Nazi leaders, 3 persons were acquitted. And the second point, there was absolutely nothing about the right to appeal. No appeal court, no appeal chamber, and no right to appeal. What you did have is the right to ask a military commission for clemency. And let me tell you just this. Several of the accused and convicted persons, in fact, made requests for clemency, and it took only 2 or 3 days to that commission to reject all of them. So we're really living in a new universe, which is not perfect, but it is so different from what we had during the times of Nuremberg. Our next and last speaker is Nina Tavakoli, who is a criminal barrister in the United Kingdom in London, and who formerly worked in the chamber of the ICTR and in the prosecution of the Special Court for Sierra Leone. Nina.
Thank you, President Maron. Thanks for the Legacy Committee for inviting me here today. I'm going to address my remarks to 2 areas. Firstly, how the ICTR has balanced the right of the accused to be informed of the nature of and cause of the charges against him with the practicalities of prosecuting mass crimes in time of war. And secondly, the use of Rule 50 to amend indictments after confirmation. The right of an accused to be informed in detail and in a timely manner of the nature and cause of the charges against him is one of the most fundamental procedural fair trial rights afforded to any defendant facing criminal prosecution. The ICTR statute and rules mirror the major human rights instruments and guarantee the accused this right. It is clear that in the early years of the ICTR, the indictments were often much less detailed than in later years. But does this mean that their trials were necessarily unfair? If one looks at the case of Akiesu, The indictment charged the accused with sexual violence over a time period of almost 3 months, and it didn't identify any individual victims or specific incidents. However, at no stage did Akiesu raise any objection to the broad date range per se, or the lack of specificity more generally. The conduct of his defence revealed that he had a clear understanding of the nature of the case against him, and so consequently, even if the indictment could have been considered defective, Akiesu never claimed any prejudice to his ability to defend himself. Therefore, the lack of specificity arguably did not render his trial unfair. In another early judgment, in Kayashema and Ruzindana, the trial chamber held proprio moto that charging the accused with the commission of crimes in Bisesero, a large area which spanned 2 communes, between 9th of April and the 30th of June was sufficiently certain to ensure the accused the right to a fair trial. In reaching this decision, the trial chamber expressly recognised the realities of what happened in the spring of 1994, holding that it is not always possible to be precise as to exact events. This is especially true in light of the events that occurred in Rwanda in 1994 and in light of the evidence we've heard from witnesses. So it's clear that in its early days, ICTR trial chambers grappled with this tension at the heart of the issue, the degree of specificity that is practicable for a prosecutor to provide in light of the scale and nature of international crimes that necessarily differentiates them from domestic crimes. Often in times of war, victims are repeatedly attacked, making it extremely difficult for them to recall a specific date or time, or perhaps they come from a culture where little importance is attached to dates, and times are marked, for example, by reference to seasons. In these circumstances, how does a court balance the accused's fundamental right to be informed in detail of the nature of the case against him with the realities of prosecuting? It was, in fact, the ICTY appeals chamber in the case of Kupreskic and the sheer scale exception that grappled this issue head-on, finding that there may be instances where the sheer scale of crimes makes it impracticable to require a high degree of specificity in such matters as the identity of the victims and the dates for the commissions of the crimes. But it must be noted that this is exceptional. Kupreskic was followed by ICTR trial and appeals chambers, thus making it part of the legacy of ICTR. For example, in Rukundo, the appeals chamber held that the allegation that the accused had participated in the killing of refugees from St. Leon Minor Seminary in April and May 1994 was sufficiently precise in light of the trial chamber's findings that abductions were occurring and that Rukundo is involved on at least 4 occasions. However, Kupreskic did lead to some contradictions in the case law at the ICTR, with the cases following it. So, for example, in Takaratimana, the appeals chamber held that the sheer scale exception did not allow the prosecution to limit its allegations to an area as vast as Bisesero, which spanned 2 communes without further detail. This put it in direct contradiction with the trial chamber in Kayashema and Ruzindana, where it held that in the context of a genocide and the nature of the attacks, a similar level of detail regarding location, and in fact the same location, had been sufficient. Now turning just to a few comments on Rule 50 amendments. Kupreskic also emphasised that while the prosecution is expected to know its case before it goes to trial, there are situations where the evidence turns out differently to what was expected, and in those circumstances an indictment may be amended, evidence excluded, or the case adjourned. This was the case, as was mentioned yesterday, in Akiesu. Following the evidence of 2 witnesses about sexual violence, one of whom testified to being raped in Akiesu's presence, the chamber granted the prosecution leave to amend the indictment in the interests of justice a month after the close of the prosecution case to include charges of sexual violence. On appeal, the accused argued that he'd been prejudiced by the late amendment of the indictment. This was rejected by the appeals chamber, who found that the defence was granted a 4-month adjournment following the amendment to defend against the new charges. He did not object to their inclusion when he was arraigned on the new counts, and he had an option to recall the witnesses for cross-examination, and he failed to exercise that right. Now, was this finding consistent with the accused's right to a fair trial? On the one hand, arguably in light of the nature of the evidence, this was perhaps the right decision by the trial chamber. In a conflict where rape was as prevalent as the machete as a means of killing and terrorizing the population, but yet those victims were incredibly reluctant to talk due to fear of rejection by their own communities and shame, it was in the interests of justice that as soon as this evidence came out, these amendments were allowed, provided the defendant's right to be notified was upheld. And I think it was in light of the steps that the trial chamber took. The other view, of course, is that to amend the indictment at the close of the prosecution case is one step too far. The OTP, by its own admission, had had problems with its investigations. In its oral submissions to the trial chamber requesting the motion, they talked about insensitivity in their investigations. And in those circumstances, was it right that the indictment was allowed to be amended due to OTP failures? Whatever one's view on the Akiesu case, over the life of the tribunal, it became increasingly clear that chambers were reluctant to allow the prosecution to amend its indictment as the trial date neared. Now, there are multiple factors that a trial chamber has to take into account in deciding whether or not to allow an indictment to be amended after confirmation. These include the scope of the proposed amendment, the violation of the accused's right to trial without undue delay, the prolonging of pre-trial detention, and the prosecution's diligence in bringing any motion. While the trial chamber must consider the prejudice to the accused, it must also consider the extent to which any prejudice can be mitigated, for example, by delaying the amendment, having an adjournment, or permitting the accused to recall witnesses for cross-examination. However, a review of the case law reveals that often the primary concern of the trial chamber in denying requests for amendment seems to have been delaying the start of the trial. It's unclear why this is, but perhaps it was the effect of completion strategies. And it's questionable whether or not it was in the interests of justice to deny these applications by the prosecutor to amend these indictments primarily on the basis of delay in trials that took several years. Perhaps a more realistic time estimate by the trial chambers about how long these trials will have taken would have assisted. However, there's also the question of whether the accused's fair trial rights can always be guaranteed by granting the defence more time to investigate. Is there a tactical aspect to the right of a fair trial that the defence can strategise their defence on the basis that when they commence investigations, it's likely there will be no additional charges? However, on the other side of the equation, the rights of the accused must be balanced against the public interest in prosecuting the accused for all their alleged criminality. So to conclude, the primary challenge facing the ICTR and the other international tribunals was how to balance the right of the accused to be informed of the nature and charges against him with the realities of prosecuting mass crimes committed during war. This is a highly contentious issue. In the latter years of the tribunal, the defence litigated it incredibly hard. And I think as a consequence, the ICTR has developed a broad body of case law that can hopefully guide any future tribunals in upholding this balance. Thank you.
Thank you very much. Yesterday you had some tea breaks. This morning my masters, using a lovely euphemism, suggested that we have a health break. So we will have a health break of 5 minutes, and please, no longer than that. Thank you.
Ladies and gentlemen, we will reconvene at this moment. Thank you very much. Thank you for joining your seats. Thank you. It is my pleasure to inform you that our group photo is scheduled for 12:30 today.
We will now resume. We will turn to the second part of our discussion, which is discussion by our discussants. They have 5 minutes each, and we will start from Sam Algozin to my immediate left. He's head of the legal section of the Mechanism Office of the Registrar in Arusha, and who has also served in various roles in the ICTR and as a legal aid attorney in the United States. Sam.
Thank you, Mr. President. This morning I'll be brief, as is required. But I just want to touch on one kind of very peculiar issue, and this is the application of early release standards to ICTR detainees, and particularly in light of developments in the jurisprudence on early release under the Mechanism for International Criminal Tribunals. And it's not merely a theoretical question. As Ellis was stating, there are still detainees in the ICTR UNDF, and these detainees whose cases at the ICTR are yet to be completed. Now, in Resolution 1966, Security Council resolution, the mechanism took over various functions of the ICTR, including the enforcement of sentences. And along with the enforcement of sentences comes consideration of petitions for early release, commutation, and pardon from convicted persons. Prior to the mechanism, the ICTR and the ICTY had divergent practices with regard to early release. The ICTR had a practice of permitting applications for early release and determining eligibility after a convicted person served 3/4 of their sentence. The ICTY had a standard of 2/3, and so the ICTY allowed prisoners to bring petitions after serving less of their sentence. Under the mechanism, this has been harmonized, and now for ICTR prisoners, the 2/3 standard applies, as does the same standard continues to apply towards ICTY prisoners. And the basis for this decision was that that all the prisoners under mechanism competence should be treated equally. Now, this raises the question of the applicability of this 2/3 standard and the early release provisions to ICTR detainees housed in UNDF and whose cases continue on appeal. This came before the mechanism in a petition by Innocent Segahutu, who applied to the mechanism for early release while he was still housed in UNDF and pending his appeal in the Military II case. The mechanism indicated that detainees in a position such as Segahutu, that their sentence was yet to be enforced by the mechanism, and that the appeals chamber retained competence to hear any petitions for release. The appropriate relief that Segahutu was instructed to pursue was provisional release from the ICTR appeals chamber. So this, and this is just for consideration, this raises several issues which could impact on detainees' fair trial rights and also their detention conditions. The first is that at the ICTR has never had a practice of provisional release. And therefore, when a detainee who may qualify for early release under the 2/3 standard, but whose appeal is still pending, inevitably a request, even though a request for provisional release is factually based, in reality at the ICTR, it's never been granted. And so the release most likely will not occur. But this is in contrast to the practice at the ICTY. At the ICTY has a very robust practice of early release, allows it, certainly with more frequency than the ICTR. And so, given that the rationale for applying the 2/3 early release standard to all mixed prisoners, in reality, when you look at how the law is applied, thank you, Your Honor, how the law is applied, it may not be applied equally towards all mechanism prisoners, ICTR and ICTY. The last point is that this could potentially impact upon detainees' right to appeal. Currently, jurisprudence at the ICTR, ICTY, and the mechanism says that if a detainee, even housed in UNDF, does not have an appeal pending, that they can request early release. However, if you're sitting in the same facility and you have an appeal pending, you cannot apply for early release, and you have to go to the ICTR appeals chamber. This could potentially impact a detainee's right to appeal, as their exercise of the right means that they will remain detained. So I just raised those minor issues for consideration, and thank you for your time.
Thank you very much. Of course, this was not the only area in which the MICT attempted to harmonize the practices of the ICTY and the ICTR, and I think in many practice directions, for example, we issued guidance which leads to a similar harmonization of procedures. Thank you very much for that. And now we turn to Claire Duffy, who has served as head of the International Bar Association's office at The Hague, and previously served as an advisor to the Vice President of the ICTR and as appeals counsel in the ICTR office of the prosecutor. Claire.
Thank you, President Meron. Good morning, everyone, and thank you to the organisers for the invitation to be part of this symposium. It's an honour to be among friends and back in Arusha. We've already heard the panellists discuss specific aspects of the fair trial rights legacy of the ICTR. Yesterday and earlier this morning, we saw a number of fair trial rights issues raised during the panel discussing the relationship between domestic prosecutions of international crimes and the ICTR. And for those who attended the prosecutors' colloquium, we also spent 2 days looking at the challenges, including the fair trial rights challenges of prosecuting international crimes at home. I'd like to hone in on this space in my brief intervention today. Part of the legacy of the ICTR, and in my view, invariably a positive legacy, were the benchmarks set by it and the ICTY in its Rule 11 bis referral jurisprudence. Specifically, Rule 11 bis requires a referral bench to satisfy itself that a given accused will receive a fair trial in the courts of the referral state, and that the death penalty will not be imposed or carried out. We know that substantive issues arising under this part of the rule in respect of Rwanda, for example, led to the denial of referral in the first instance in a number of cases. Some examples of those issues were real concerns about defence witnesses being available to testify without fear of reprisals or prosecution, and the imposition of solitary confinement on accused persons. As we know, and as we heard from Mr. Jean Bosco Mutangana and this morning from Yasmin Chubin, an intense period of legislative and other reforms was entered into so that ultimately applications to refer cases to Rwanda could be granted. And as we heard from Anis Ahmed, the trials are monitored by the chambers of the ICTR. My lament today is how this important standard setting, and I am by no means saying these standards are themselves perfect, for the prosecution of international crimes at home, especially given the attention around international criminal cases, has not been passed on to the Permanent International Criminal Court. And I'm specifically referring to the recent decision affirmed on appeal to defer jurisdiction to the Libyan domestic judicial system in lieu of the ICC in the case against Gaddafi's alleged former spy chief, Abdullah al-Senussi. Of course, for some, this might be explained away by the major distinction between the ad hoc system and the Rome Statute system around primacy of jurisdiction, according to which the ad hoc tribunals enjoy primacy over domestic jurisdictions, whereas the ICC is a court of last resort. But for me, this explanation is insufficient when we consider the standard setting expectations of the ICC and its potential to impact or influence rule of law development in domestic justice systems. I don't have a lot of time to go into the facts of the al-Senussi case, but suffice to say that the ICC chambers and the Office of the Prosecutor have taken, in my opinion, a very restrictive view of what amounts to unwillingness and inability for the purposes of the admissibility provisions of the Rome Statute. In particular, these actors have said that it is not the function and purpose of the ICC to act as some kind of review body for the judicial systems of states. In relation to Libya and to al-Senussi in particular, we're talking about a country where the security situation is very precarious, to say the least, where there have been numerous assassinations of judges, prosecutors, lawyers, journalists and politicians, and where al-Senussi himself has had no access to counsel for extremely lengthy periods, has been held in incommunicado detention, has alleged torture, and on numerous occasions been interrogated in the absence of a lawyer, just to name a few of the due process concerns raised in his case. And in fact, earlier this year, when I asked one Libyan judge whether he was concerned about the Libyan judicial system's ability to try al-Senussi, he told me that he thought, while they had the laws and system necessary to do this, that no judge would be free not to convict those on trial. I realise I'm running out of time. I just want to recognise a few tensions in this discussion before I conclude. You don't need to delve very far into the negotiating history of the Rome Statute to see that the way that the appeals chamber and perhaps the Office of the Prosecutor have interpreted these admissibility provisions were perhaps giving effect to the state's party's intention. But there is one legal reason that I think raises the question of the prosecutor still having ongoing obligations, and that's that she may submit a request for a review of the decision when he or she is fully satisfied that the new facts have arisen, which negate the basis on which the case has previously been found inadmissible. There are also issues in my lengthier paper around the prosecutor's code of conduct and the obligations therein. In conclusion, I'm definitely not suggesting that the court or the OTP as part of it is responsible for the due process standards in domestic systems, nor that it's a development agency. But at the same time, there must be some remote responsibility over those it has taken control of in the first instance. At the very least, to use its offices to send the message that the proceedings it has deferred are being closely followed, including for fair trial reasons. In a recent interview on BBC's Hard Talk, former ICC prosecutor Luis Moreno Ocampo championed the ICC, including because of the so-called shadow effect it has on situation countries before it and wider to promote the rule of law observance. Thank you.
Thank you very much. In speaking of referrals to national jurisdictions, we really should think of referrals in the broader context of future challenges to international criminal justice. With all the seminal and precedent-making importance of international criminal tribunals and courts, we must always remember that our capacity to prosecute many perpetrators of atrocity is, of course, limited, extremely limited. And the challenge of the future is really for national jurisdictions to take over and to prosecute perpetrators of atrocities either committed on their own territory or elsewhere. And the challenge for the international community and the tribunals as a whole is to make sure that national jurisdictions will maintain the same high standards of fairness in trial that we have established in a very seminal way. Now, our last discussant is Marina Fakhouri. She's the focal point addressing issues of detention at international tribunals with the ICRC. She has played various roles in that organizations since 2007, after working on humanitarian affairs matters since 2002 in the Balkans, in Angola, and in South Sudan. Ms. Marina.
Thank you, President Meron, ladies and gentlemen. On behalf of the International Committee of the Red Cross, it gives me great pleasure to address you today on issues of international detention standards. Indeed, as mentioned by members of the panel, the ICRC has been the monitoring body for persons detained under the authority of the ICTR since 1996, and as inspecting body for ICTR convicted persons since 2002 with the first visit to Mali. Indeed, the ICRC has conducted over 31 visits to the United Nations detention facility here in Arusha over the years, and over 10 visits to persons convicted by the ICTR serving their sentences in foreign enforcement states. The ICRC conducts its visits to the tribunal detainees the same way it conducts its visits to all persons deprived of their liberty. Its action, its detention action, its attention to maintaining the humanitarian, independent, and neutral and impartial way of its work is not at all compromised in its way of monitoring the tribunal detainees. However, there is quite a difference with international detention, which the ICTR has found itself as one of the first of the international tribunals, along with the ICTY, having to actually apply in practice these international detention standards without much precedence to go by before. In ordinary judicial proceedings, the location of criminal trial and subsequent detention, if appropriate, is usually determined by the place of the alleged crimes commission or the nationality of the country of residence of the alleged perpetrator. By contrast, defendants tried by the international judges at the ICTR are detained both prior and during their trial in Arusha, Tanzania, and upon conviction, if convicted, are transferred to an enforcement state. Neither the place of their initial detention nor conviction necessarily holds any link to their history, to their personal history. This brings along a number of humanitarian concerns that the ICRC has noted over the years, which is typically linked to the sui generis nature of this detention. Indeed, this is an element that goes above and beyond the deprivation of liberty, which is caused by the administrative functioning of an international justice system. And it is a responsibility of all of the authorities in charge of their detention to mitigate the related hardships to the greatest extent possible. As one of these first tribunals to start applying these detention standards, the ICRC has accompanied it through thick and thin, faced with challenges which are both within the ICTR's control and outside of it, and has appreciated the attention given by the ICTR over the years to its recommendations. If one looks at the possible legacy of international detention from the point of view of the ICTR's contribution to date, one can say that it is very much a matter not only for the ICTR but also for the international courts and tribunals in existence today to use the opportunity of lessons learned to see how these practices have been able to be applied over the years and the challenges that have come about, including some raised by my esteemed colleagues on the panel, such as that of how to handle acquitted persons and released persons, and also preparation, the actual preparation for an early release, whether it be at 3/4 or 2/3. We are, of course, as the ICRC, excited to see the new practice of the Special Court of Sierra Leone in conditional release, which will be a more accompanied release. So with this lessons learned exercise, we believe that it can both be, it can be a legacy not only for international tribunals existing and those that may follow to aspire of, in ensuring that the detention reference framework is reflective of best practice and current advances in penal reform. But also, we believe that it's with the ICTR, with the authority it has, and the international character it has to be able to influence, so that such best practice detention standards can then be adopted by domestic, local governments and civil society. Thank you.
Thank you. I would like, before opening the floor for discussions, really to salute the ICRC for the tremendous role it performed in visiting and inspecting our detention facilities at The Hague and here in Arusha, with the neutrality expertise and long tradition of serving the cause of humanity. You've done a terrific job. And people outside of the tribunals perhaps have no idea of the frequency of correspondence between presidents of the tribunals and delegations of the ICRC. We receive very detailed letters, and we regard it as our duty to address every single point which is raised by the ICRC in order to be sure that we, in fact, maintain the highest practices and standards of detention in the world. So thank you, Marina, and thank you, your colleagues. Now, we still have some time for discussion. Perhaps just for a few minutes, let me give priority to my distinguished colleagues on the panel, if they would like to comment, criticize, or praise each other's interventions. Mr. Stewart.
Just thank you very much, President Meron. And just in response to the response that my friend Peter Robinson gave you when you asked for a measure to deal with sanctioning a disclosure violation, I would very respectfully suggest that in the end it's the interest of justice that should predominate, and the examination of whether or not the accused has genuinely suffered prejudice has got to be the inquiry. Otherwise, what you do is impose a regime of, punish the prosecutor or punish the investigators. And what justice do? You don't call a witness because there's been a failure on the part of the prosecutor to disclose a statement? Well, what sort of statement are we talking about? Is something crucial? Is the late disclosure of the statement put the defense in such a position that it really can't defend the case? I mean, in that sort of situation, yes, then you impose a much more serious sanction. But it shouldn't be a sort of a punitive notion, let's give the prosecutor a smack for doing something they shouldn't have done. It should really be, what do the requirements of justice oblige the chamber to do? And in some cases, of course, there will be a loss of evidence simply because the failure of the prosecution to make disclosure has put the defense in an impossible position and created an imbalance and therefore a potential unfairness in the trial that has to be addressed. But it should be the interests of justice. That's my comment.
Thank you. I see Peter does not ask for a right of reply. Or does he?
Well, I don't think so. I'll give more opportunities for the people to ask questions, and maybe I'll have a chance to reply in the context of it.
The floor is now open for questions, discussions. Questions should, of course, be addressed to the panelists or the discussants, not to the moderator.
Yes, I think I address my question to Ms. Pascal Besnier, and it relates to acquitted persons. Over the years, with every acquittal, the government of Rwanda has always protested. Indeed, my client was acquitted by the appeals chamber on the 11th of February this year, Major Nzune Meye. After that, the representative of Rwanda at the Security Council not only criticized the acquittal, but attacked the presiding judge. I dispatched my co-counsel, Beth Lyons, to the Security Council. She followed the proceedings. And shortly after that, we protested to all the members of the Security Council about that unwarranted attack. Now, you said that there was this unwillingness by member states to take some of these acquitted persons. Among these states is France, where my client was arrested. With these unwarranted attacks by the representative of Rwanda to the Security Council, don't you think that it has an effect of discouraging those countries that may be willing to take in these accused persons? And two, what effect does it have on the ability of the Rwandan courts to which this the referral will be made to acquit? If the ICTR has acquitted, if persons were acquitted by the ICTR and the representative of Rwanda and the Security Council attack the judges, is it possible for Rwandan judges to acquit in trials conducted in Rwanda if the persons are found to be innocent? The next question is about the question of compensation. The appeals chamber held in the case of Samanza in an interlocutory appeal which are filed, and also in the case of Jean Bosco Barawiza, that if they were acquitted, they were entitled to compensation. In fact, it is not in the statute, but that was the decision of the appeals chamber. What effort have you made in respect of Nzune Meye, for example, and some of the people spent almost 15 years, and they were acquitted at the end of their trials, and in respect to compensation?
Thank you. And I would urge persons who will ask questions in the remaining time to be very brief and perhaps limit themselves to one question each. Monsieur Besnier, would you like to answer before we go?
Yes, certainly.
Thank you, Chief Taku. You are addressing a member of the registry, not a judge. And your question is political and legal and administrative. Here at the registry, we only deal with administrative issues. But it is true that there have been protests from the officials in Rwanda against these acquittals. And this doesn't help. It's absolutely true. This doesn't help the resolution of the issue. On the other hand, the officials have confirmed that they have no concern with these acquitted persons returning either to Rwanda or to any other country of their choice. It's the official position of Rwanda, and we have no reason to doubt of this genuine opinion. But more important is the fact that these protests from officials in Rwanda are amplified in the countries of like France and Belgium, the targeted countries for relocation. They are amplified by the diaspora, by the people who have been victims and who stay in these countries. And foreign countries like France are more concerned with the political trouble that would result in the relocation of one acquitted persons vis-à-vis their own political opinion, not Rwanda. Now, regarding the compensation, this is a purely legal matter, and it has already been addressed in Zigira Nerazo, for instance. And I think that here we should re-examine, well, the defense counsel, the lawyers, should re-examine their options. I think that the appeals chamber has not closed the door. It has only rejected one request on legal basis, but this is your job to find other basis. Thank you.
Thank you. Your turn.
Je vous remercie, Monsieur le Président. Ma question va également à Monsieur Besnier concernant les personnes acquittées. C'est un dossier que je connais bien pour l'avoir géré avant de quitter le tribunal. Alors, comme a dit Besnier, c'est une question humaine. C'est très difficile de voir des gens de cet âge-là chaque jour. Moi, je les voyais chaque jour, soit dans mon bureau, soit dans leur safe house, de voir des gens. Et parmi ces personnes, il y a quand même des personnes âgées qui ont 70 ans ou plus et qui sont malades et qui n'ont aucune option pour l'avenir pour rejoindre leur famille. Ma question est la suivante, parce que je me suis toujours posé, je me suis toujours demandé, est-ce que le fait que dans les textes de ICTR, il n'y a rien qui soit légalement prévu pour les acquitter, est-ce que ce n'est pas de là que vient le problème? Parce que dès qu'une personne est acquittée, c'est terminé, ni la Chambre ni le greffe n'ont plus rien à faire. Parce qu'ici, il faut même saluer l'ancien greffier, parce que quand il y a eu les premiers acquittés en 2004, il n'y avait même pas de budget prévu pour les acquitter. Donc, il faut saluer ici que le greffier ait pu trouver une solution, même pour les héberger, pour leur sécurité, pour leur nourriture. Donc, je me demande, est-ce que l'origine de l'erreur n'est pas au niveau des textes? Je vous remercie.
Oui, merci. Je me suis moi-même souvent posé la question et j'avoue que j'ai répondu non. Il n'était pas possible à l'origine de prévoir cette situation. On pouvait évidemment prévoir qu'il y aurait des acquittements, mais on ne pouvait pas traiter cette question avant, sur le plan légal. Pourquoi? Parce qu'il y a deux dispositions qui s'appliquent. La première disposition, c'est non bis in idem. Elle existe dans le statut. Vous ne pouvez pas rejuger une personne qui a déjà été jugée par le TPIR. Et par conséquent, cette disposition était suffisante pour protéger les droits des personnes acquittées. C'est l'acte fondateur qui protège contre de nouvelles poursuites, que ce soit au Rwanda ou ailleurs, les personnes acquittées. Et deuxièmement, c'est une question de droits nationaux. Il y a des règles dans tous les droits nationaux, dans tous les codes de l'immigration, qui obligent les pays à prendre des gens qui remplissent les critères. Et ces règles-là, elles existaient déjà bien avant la création du statut en 1995. Il suffit de les appliquer. C'est parce que les États les appliquent de mauvaise foi qu'on a cette situation. S'ils les appliquaient de bonne foi, ils seraient déjà tous rentrés chez eux. Donc ma réponse à ta question, nous, c'est non. Merci.
Thank you. This is a question directed towards both James and Peter relating to disclosure. Might it not be said that had the trial chamber taken a rather more robust approach in respect of sanctions for disclosure violations, this may have had, rather than simply being a slap, a slap for the prosecution for their failures, it would have had rather more a salutary effect in terms of encouraging the prosecution to take a more robust and thorough approach themselves to their disclosure obligations.
Mr. Stewart, Mr. Robinson, who goes first?
Peter's let me go first, Judge Marin. I'll just speak about the ICC. I would say that we have had some, in the past, some very bad disclosure oversights, if I can put it that way. There's never been a finding of bad faith, but there has certainly been findings that were very critical of the disclosure failures. We take these very, very seriously, and I would suggest we have a vigorous system of disclosure, and if we face a difficulty, it's simply managing the huge amount of information and material that we've got, and also respecting the protective measures, which require very onerous and time-consuming redactions of statements and materials, and re-redactions of statements and materials as we, in a sense, lift redactions going toward trial. But I think the important thing that you're putting your emphasis on is the people on the prosecution side have got to subscribe to the values that the disclosure regime protects. And if you've got that kind of discipline on the side of the prosecution, then you're going to have a good application of the disclosure rules. It's a matter of legal culture, and it's a legal culture that we're working very hard to develop at the ICC. In the early days, as a senior trial attorney at the ICTR, the issue that I confronted, which is quite frightening, was the protection of my witnesses. And so I believe we were rigorous in our disclosure, in discharging our disclosure obligations to the defense in those early days. But one of the difficulties we had was holding back and disclosing sort of as we came up to each chunk of the trial. It was not a very happy or satisfactory situation, but we did try, I believe, to meet our disclosure obligations. And although we certainly received the odd complaint, I think generally speaking, in those early trials, it worked. But I can only speak about those early days and my situation today. Peter.
Thank you, Mr. Robinson.
I think the bottom line is that there has to be a strong incentive on the parties to make disclosure, and that has to be backed up by action when they don't do it. And you know, I actually discussed many times with my client, and what should we do? What should we ask for when there were disclosure violations? The prosecutor in my case, Don Webster, was someone I had great respect for. He worked very hard. He was very honest. And I didn't want him to be in trouble particularly. And it didn't help my client really for him to be in trouble. What we really wanted was the material, and we wanted to have it in a time in which it was effectively being able to be used for us. So we preferred really that there be remedies such as exclusion of evidence rather than some personal sanction against people that I respected. But when you have neither, then you have impunity, and that's why there has to be some sanction to be able to make the system work. Thank you.
Thank you. I think there was a question. Yes. There.
Thank you, Mr. President. I just want to share some personal thoughts in relation to the universal basic standards as alluded to by the speaker. I have spent the last year advising several African states, including my country, Nigeria, on establishing an international crimes chamber within our jurisdiction, and haven't succeeded in having the domestication of the ICC statute and other instruments domesticated. One major challenge that I have had is convincing the government of the standards that are applicable to detainees. And our situation is peculiar in the sense that we are a country where several heads of state have actually been through our prison system. And their position simply is that if the prisons are good enough for presidents, then they must be good enough for any Boko Haram or JTF detainee. So that's a peculiar problem that we have faced in our situation. Thank you.
Thank you. I take it that this was a statement, as you said, not a question. Marina, you'd like to say something about it? No. Next question. Their hand there. Yes, please.
James.
Louder, please.
My question is directed to Peter and James because I have worked both of them, and currently also I'm working on disclosure issues in OTP. And I was in Karmera case also there. And in spite of having, let's say, 1 million pages of evidence, even though we have our best intention and we know the rules and we give some disclosures to Peter, tomorrow Peter again will come and say one more disclosure violation. And then, even if we give the whole OTP database to him, then again, he says, no, you failed to record something. So whether ICC has learned some lesson from him and ICTR experiences and how they want to put, because ICC is still in the beginning of phases, only trial phases. After the exculpatory evidence will create a lot of problem. And what I'm working now on these issues. Thank you.
Thank you. I take it not a question, but a comment. Yes, Professor Jacobs.
Thank you. I won't argue now with James Stewart because I have a profound philosophical difference with him on the fair trial rights of the prosecution. But my question is for Nina on the notice of charges. And I'd like to know if she can reflect more on the question of modes of liability. But it's not just the events. And I think that in that respect, unfortunately, there hasn't been much legacy of the ad hoc tribunals at the ICC, despite attempt to have a more robust confirmation of charges. The Regulation 55 issue has created kind of free-for-all in terms of charging and modes of liability. I mean, there are examples, but in the Kenya cases, OTP got the chamber to notify that any mode of liability might be used in the trial, despite the fact that some of them had been confirmed. So there's really two questions. One is, what was the practice here? And two is, do you share my concern that at the ICC they haven't learned anything? Thank you.
I can't answer your question about the ICC. I'm not aware of that case law, unfortunately. In respect of the ICTR, off the top of my head, it's a bit problematic. But there are obviously, there's notice, with 6.1 or 6.3, different levels of specificity required. So depending how close the accused was to the location, how senior he was in the event, if he personally committed the crimes, then you have to be very specific. You have to name the victim and so on. And you have to state, in terms of modes of liability, the prosecutor in the early days charged all modes of liability, and the case law moved on to say that the prosecutor should only charge those modes of liability on which they intend to rely. And there have been cases where the chamber has directed the prosecutor to remove those modes of liability that the rest of the indictment makes clear are not actually relied upon. So in that sense, the general sense of being as specific as possible, there are those requirements. Then there's different requirements in respect of 6.1, 6.3. So as I see it, that area has been developed. JCE, there's specific requirements in respect of JCE. So I think it is detailed enough, but as the ICC, I'm afraid I can't assist.
Thank you, the gentleman at the left. And then one more from the right, and I'm afraid that will be it. Yes?
Thank you, sir. My name is Michael Wright from the ECOWAS court. My question is addressed to Pascal and James Stewart. And that concerns the legacy being left behind by the ICTR. The colloquium of prosecutors, as well as this conference, talks about 20 years of challenging impunity. I want to know what is the philosophical legacy being left by, in fact, international criminal justice. For example, I'm talking about is the success of international prosecution the number of convictions? Is it convictions as opposed to fairness, fair trials, and justice? Is justice defined as resulting in convictions? Is the court only concerned about delivering the results that people expect of the forum? How is justice defined? Is it equality and equity, or is it just conviction and conviction? So after the ICT closes its doors, what will be left behind as a memory that they succeeded in obtaining so many convictions, locking so many people up, irrespective of whatever other consequences? Somebody talked about persons acquitted, and the acquittals were challenged. The acquittals were rejected. So is it that once you are charged, then you are presumed guilty and you must prove your innocence? I want to know what the philosophical legacy that this court is leaving behind. Thank you.
Thank you. I will take one or two, perhaps, questions, and then there will be one round of answers, and then you will have time for lunch. Monsieur Roux.
Oui, merci Monsieur le Président. François Roux, chef du bureau de la défense au tribunal spécial pour le Liban et ancien avocat au TPIR, notamment avocat de Baghili-Shema. Un témoignage et une question. Baghili-Shema a en effet été le premier acquitté par le tribunal pour le Rwanda et le premier qui a eu les difficultés à être relocalisé en France. Pour aller dans le sens de ce que Pascal a dit tout à l'heure, quand je m'adressais à l'époque aux autorités françaises, on a commencé par me dire « oui, il a bien été jugé en appel, mais pas encore en cour de cassation ». Il a fallu que je leur explique qu'il n'y avait pas de cour suprême au-dessus de la cour d'appel. Ensuite, on m'a dit « oui, mais d'après le texte, le procureur peut demander la révision du procès ». Je leur ai dit « ça m'étonnerait beaucoup que ça se fasse ». Bref, nous avons fini par obtenir son accueil en France, plus par des relations personnelles, et je dois ici saluer la mémoire de l'ambassadeur Stéphane Hessel, qui avait fait beaucoup. Et ma question est la suivante aujourd'hui. Qu'est-ce que les citoyens français qui sont dans cette salle et les citoyens belges peuvent-ils faire pour aider le greffe auprès de leur propre gouvernement?
Thank you. The last question.
Thank you.
Briefly, please, because we are running out of time.
I will be very brief. I'm Dr. Bizimungu Casimir. I'm one of the acquitted people, one of the people who were acquitted by the ICTR. I followed very carefully the presentation of Mr. Pascal Besnier. It was very excellent. I know that the registrar or the registrars at the ICTR have done a great work of trying to get people relocated. They and their staff are doing a wonderful job with very few results, but they work hard on this. Now, my question is it possible to see their efforts supported further by people like the UN Secretary General or even the Security Council, just to boost their efforts so that probably they may get better results? That is my question. Is that possible? Thanks very much.
Thanks. Panelists, let me reassure you that the presidents of the tribunals have been time and time again raising this question in both the General Assembly and the Security Council to encourage states to take some people to their own countries. So far, despite all our efforts, our success has been very mitigated. Monsieur Besnier, would you like to start, or I will?
Yes, I think we can combine the questions posed by François and Dr. Bizimungu on the way forward. President Mose learned me two very important things in life. First, he learned me that short-sleeve shirts are more comfortable than long-sleeve shirts in Africa. And second, he taught me that when you have a bad news to deliver to somebody, you'd better have a big smile on your face. It's easier. And so I think that on the way forward, we should continue, visit our governments, our stakeholders, and keep smiling at them and ask gently why they don't want to take more acquitted persons, why they don't want to relocate, to make more efforts to relocate them. And also one more possibility is to support the acquitted persons in their trials, in their legal actions that they undertake against decisions, administrative decisions in Belgium, France, etc. We can provide them, and somebody like François and people in France and Belgium are extremely helpful in these endeavors. Thank you.
Mr. Stewart, I knew I could count on you.
Thank you, President Meron, for that vote of confidence. What is justice? The question and the legacy of the ICTR, the question asked by Judge Wright. As a prosecutor, I don't prosecute anyone unless I believe that they're guilty, and I'm seeking a conviction. That's the purpose of prosecuting. I think it's profoundly wrong to prosecute someone if you don't have the evidence against them for any reason that falls outside of what is a proper administration of justice. So going into a prosecution, of course, one expects or hopes that the outcome will be positive in the sense of a conviction. But to get there, you have to do so fairly. Otherwise, the process has no credibility. That is a profoundly important value. And therefore, you have to honor your obligations to the accused, to victims and witnesses, and ultimately to the trial chamber. And in the end of the day, you know, the witnesses may not come through for you. The defense may do a very good job uncovering problems with the prosecution evidence that you weren't even aware of, and you can have an acquittal. That happens. And in my view, if a trial chamber is left with a reasonable doubt, and I haven't discharged the burden on the prosecution to establish the guilt of the accused beyond a reasonable doubt, well, that happens. And I think, frankly, if you look at the record of the ICTR, it's a very respectable and honorable record in that regard. And I certainly hope that will be the case where I'm working now, at the International Criminal Court.
Marina?
It's just a brief comment on regarding the eventuality of somebody being acquitted and ultimately also following this on for early release, whether it be at the stage whilst the person is still in the UNDF or later on. One can't emphasize more the impact of preparation. That person should be effectively afforded rehabilitation measures, eventual reinsertion measures to help in advance prepare for their life outside. And in the case that the ICTR faces, such reinsertion measures will also have to take into account the necessary lobbying to try and find a durable solution for these persons. So I would pass to state that there is a role for the registry and for the detention staff in this to ensure that due preparation is taken.
Thank you, Marina. Anyone else? If not, I think that given the great quality of our panelists, it's only fair that we will hear a real strong round of applause. The session has ended.
Ladies and gentlemen, you're kindly invited to take your seats. Thank you. At this time, it is my pleasure to introduce our fifth panel that will deal with the theme of capacity building, outreach, and administration of an international tribunal as part of the legacy. And we have the honor to have this afternoon as moderator, Mr. Adama Dieng, Special Advisor to the United Nations Secretary General on the Prevention of Genocide. Mr. Dieng, you have the floor.
Thank you, Hassan. Je voudrais d'abord remercier le leadership du TPIR pour m'avoir donné l'opportunité de retourner à Arusha. Et je dois dire que c'est déjà dans l'avion qui m'a mené d'Amsterdam à Kilimandjaro que j'ai ressenti les premières émotions lorsque, au hasard de mes mouvements, le juge président Eric Moss m'a reconnu. Il était assis à côté de Mandiaye. Ça a été pour moi un moment de très forte émotion. Et hier, le procureur Diallo parlait des 3 mousquetaires. Tant il est vrai que le président Moss, Hassan Diallo, le procureur, et moi-même, nous avons constitué ce qui était plus qu'une équipe de dirigeants du TPIR. Nous étions véritablement une famille unie malgré les difficultés. Mais je crois qu'aujourd'hui, lorsque nous jetons un regard par le rétroviseur, nous pouvons dire que nous sommes fiers d'avoir accompli notre devoir et nous souhaitons un franc succès à notre frère Hassan Diallo qui poursuit encore le combat aussi bien au sein du TPIR qu'au sein du mécanisme résiduel. Ceci dit, vous me permettrez, avant de donner la parole aux panélistes, de saluer la mémoire des pionniers aujourd'hui disparus. Et je voudrais à présent avoir une pensée pieuse pour le président Laïti Kama, qui nous manque énormément. Et je voudrais aussi saluer la mémoire de maître Louis Edmond Petiti, avocat au barreau de Paris, avec qui j'avais accompli un voyage à New York au moment de l'adoption des statuts portant création du TPIR. Je me souviens à l'époque, nous nous étions battus pour que le trial in absentia soit considéré dans ce statut. Nous nous étions battus pour que la civil law soit pleinement utilisée. Ce fut peine perdue. Mais je dois dire qu'au fil des années, les juges ont su utiliser des artifices qui ont permis d'inoculer un tantinet de droit civil dans nos règles de procédure et de preuve. Je voudrais aussi dire un grand merci aux pionniers qui étaient dans l'ombre et dont certains sont encore au TPIR. Ils ne sont plus très nombreux. Je pense notamment à ceux qui étaient là en 1995, Rosette Muzingo, Jessie Demeza, Bokarsi, et bien entendu, il y a Amusuga qui a certes quitté, mais qui étaient les piliers. Ces 2 hommes et ces 2 femmes, nous leur devons beaucoup parce qu'ils sont témoins des difficultés que ce tribunal a rencontrées au moment de sa naissance. Je dois dire aussi une chose qui certainement sera reprise par Sarah Kilemi. C'est le rôle extrêmement important que le personnel des services administratifs a eu à accomplir. Et leur dédication, leur dévouement à la mission qui nous est confiée mérite d'être salué. Et je dois ici d'ailleurs utiliser à mon compte et pour démontrer l'importance du rôle qu'ils ont joué, le motto d'un de nos jeunes collègues, Atsa à Togo, qui est maintenant le responsable de Africa Conference and Events, et qui dit « When your passion becomes your profession, life is a celebration ». Je crois que ce motto de Atsa est véritablement ce qui a également poussé le personnel du TPIR au cours de ces 20 dernières années. Si vous me permettez, je vais rapidement donc vous introduire les panélistes. La liste est très impressionnante. Et tous ces panélistes que vous avez en face de vous ont accompli véritablement des prouesses dans leurs domaines respectifs. Et c'est pourquoi je n'aurai pas besoin de lire leur profil. Je suis sûr que cela prendrait plus qu'une session si je devais dire ce que chacun d'entre eux a pu accomplir. La plupart d'entre eux, vous les connaissez, vous avez pu travailler avec eux, et je voudrais donc simplement et brièvement dire qu'à ma gauche, vous avez Mandiaye Nyang, Mandiaye qui est juge à la chambre d'appel TPIR-TPY à La Haye. Il a au préalable travaillé comme senior legal advisor au TPIR, et également il a été représentant résident de UNODC à Pretoria, en Afrique du Sud. Le juge Nyang a publié beaucoup d'articles sur des questions relevantes au droit international, au droit criminel, et j'en passe. Et il a été également un professeur visiteur dans plusieurs universités de par le monde. À ma droite, mon jeune frère, John Hawking, John du TPY et du MICT, qui a été au préalable, comme vous le savez, il a occupé des fonctions éminentes dans son pays natal, l'Australie, où il a accompli ses études avant de les poursuivre au Royaume-Uni. Sarah Kilemi, donc la seule femme de ce panel. Sarah is the Director of Administration at the ICTR. She's in charge of policy development and strategic planning. She has over 25 years of progressive experience holding senior positions in the United Nations and private sectors. She holds a Doctor of Philosophy PhD degree in Development Economics from Aachen Technical University in Germany, and she's a certified public accountant, CPA. We have also another lady in this panel as a discussant, that's Viviane Dietrich. Viviane is a postgraduate researcher at the London School of Economics and Political Science, and after undergraduate studies at Sciences Po Paris and Wellesley College, she received a double master degree from Sciences Po and LSE. Ronan Amusuga, who is currently coordinator, head of the Secretariat of the United Nations International Commission of Inquiry on the Central African Republic. From 1993 to 2013, he has served in various capacities within the United Nations. Most recently, Amusuga served as Senior Legal Advisor, Chief of External Relations and Strategic Planning, and spokesperson of ICTR from 2003 to 2013. Don Deya is the CEO of the Pan-African Lawyers Union. He is an advocate of the High Court of Kenya and was previously the CEO of the East African Law Society. And among other things, he chairs the executive committees, the Center for Citizens' Participation in the African Union, CCPAU, and of the International Coalition for the Responsibility to Protect, ICTR-TPIR, respectively. We have also Jonas Mutvaza. Jonas, who is currently program officer, librarian at the Mechanism for International Criminal Tribunals. And before joining MICT, Murzawa was chief librarian, legal library and reference unit at the ICTR. He holds an advanced degree in library science combined with a DS in engineering documentaire and a postgraduate certificate in archive studies. So I think I have gone, and then we have our friends from IBUCA. IBUCA, an organization with which we have had a very close relation and sometimes with height and down, but at the end we became very close friends. So I welcome Naftal, who is representing IBUCA in this panel. So with this and without further ado, I will invite John Hawking for his presentation. And I do remind all the panelists that they have between 8 to 10 minutes. I do know that it is too short time for the wealth of knowledge you have about the issue we are debating, but unfortunately we have to go by the rules, and these rules have been applied strictly from the beginning, and I expect you to observe those rules and to not embarrass me to cut you after 10 minutes. Without further ado, John, you have the floor.
Thank you. Thank you very much, Adama. Good afternoon. The ICTR, 20 years and $2 billion for 93 indicted. It wasn't worth it. an aloof institution, distant from people's lives. No peace without justice, they say, but justice has not brought peace. We've all heard these criticisms, but was the ICTR really not worth the investment? Has the ICTR really not touched people's lives? And will justice never bring peace? I am mandated to protect and promote the legacy of the ICTR as one of the three principles of the mechanism. So where do I stand on each of these three questions? The first question, was the ICTR worth the investment? Today, it's trite to say that computers have transformed the world we live in. They impact everyone's daily life. Yet just a few decades ago, the first computers were mechanically cumbersome, very slow and very expensive. They were viewed with skepticism or at best indifference. We are only at the dawn of modern international criminal justice. Trials at the ICTR and at the other international criminal courts, like these early computers, have at times been saluted with indifference or criticised for being cumbersome, slow and expensive. Yet these trials are transforming the world we live in. The ICTR and ICTY have opened an era in which the most heinous crimes that shock deeply the conscience of all of us human beings no longer go unpunished. Demanding accountability for those crimes is now as normal as browsing a web page. Neither was imaginable 20 years ago. So why, after the creation of a permanent criminal court, a 100% enforcement rate for those most responsible for the Balkan Wars, and with heads of state facing trial, why is the end of impunity still a nebulous concept? Why is it often put in question? Because the fight against impunity is not perfect, and maybe it never will be. But this is not a reason to give up on this ideal. Just because all murderers are not caught and all murders are not prevented, would we consider living in a country that did not criminalise murder? What we must do is to continue to reach for this ideal by perfecting our tools. This is what the ICTR has done. This is what the mechanism continues to do. So, for instance, as the ICTR clears its dockets, domestic courts are increasingly prosecuting international crimes. Our job is to light their way with our years of experience and wealth of information. Similarly, as we harnessed ICTR and ICTY best practices to create the lean and efficient institution that is the mechanism, we stand ready to share our know-how with other courts and offer a model of international justice which is not only fair but also economic and expeditious. The second question, has the ICTR touched people's lives? Let me tell you the stories of two women. One was born in a middle-income family in the late 1940s in Rwanda. Unlike many other girls of her time, she could study, travel, and dedicate her life to public service. She rose through the ranks and eventually became the Minister of Family and Women's Development. Yet in April 1994, she wore a military shirt on top of her Kitange skirt and repeatedly ordered the brutal rapes of Tutsi women, an ICTR trial chamber has found. A woman who shaped her own future denied it to other women. A figure who once brought hope to many shattered it. Pauline Nira Masuhuko is now an elderly lady. She has spent the last 17 years at the detention centre of the ICTR as she awaits the final verdict on her actions. The second woman, I'll call her Josephine, was in her early 20s when she was violently gang raped during the genocide, like too many girls of her time. After surviving the rapes, any hope she may have harboured for a future was shattered when the first signs of HIV/AIDS appeared. In 2009, she arrived at the ICTR Witness Office in Kigali, a fleeting figure, 35 kilos she weighed, holding a small child. I met her last August. Her weight has doubled. She now weighs 70 kilograms. Her child is not HIV positive, and she receives daily counselling from the MICT, from the mechanism. Today she has hope, and she is rebuilding her future, a future which 20 years ago appeared denied to her. The ICTR changed these two lives, as it has changed the lives of countless others, like the ever-expanding ripples from a stone tossed in the water. The creation of the ICTR has spread its long-lasting fruits far beyond those directly touched by its work. The ICTR ripple effect has reached to the shores of the Niger in Mali and to an inlet of the Gulf of Guinea in Benin, where local prisoners benefit from enhanced conditions of detention, thanks to years of support and training by the ICTR. Today, the MICT builds on this ICTR best practice and, working closely with the governments enforcing ICTR sentences, has made the detention of domestic inmates both healthier and safer. The ICTR ripple effect has also reached domestic courts. On a continent where witness protection was a novel concept, the ICTR witness services have been a model for the start-up of similar programs in Rwanda, in Kenya, and in Tanzania. The mechanism continues to bolster these efforts. And the ICTR ripple effect has reached deep into the homes of thousands of Rwandans through capacity building activities and information centres, and through its clinic, now inherited by the mechanism, which, as in the fitting words of the Rwandan Minister of Justice, has a multiplier effect beyond its immediate beneficiaries. The third question: will justice ever bring peace? Even if lives have indeed been touched, will the legacy of the ICTR still resonate with future generations? Will it help foster sustainable peace? Will it prevent us from relapsing into ever new spirals of hatred and violence? We have a compelling and powerful tool which we can shape ideas and determine the approach of future generations. The real-life images recorded in millions of pages, thousands of videos, and hundreds of pictures which tell the story of what happened in 1994. These are enshrined in the archives of the ICTR, which the MICT will safeguard, and in the Gacaca archives, which I had the honour to visit in August. The unparalleled documentation of a 10-year toil which tried almost 2 million genocide cases. The genocide was fueled by persuasive words of hatred which moved neighbours to kill neighbours and lifted machetes to cut bones rather than grass. While the propaganda was inflaming Rwanda, outside the country indifference prevailed. Nearly 1 million died in 100 days. It is our obligation to use these archives to propagate peace rather than hatred, to inspire action rather than indifference. At a time when information spreads across continents in a tweet, the stereotypical image of the inaccessible archives relegated to cold basements has no residence in the mechanism. We must, and we will, take the voice of the victims out of the courts and conference rooms. We must bring it closer to people's homes and to their hearts. Only by making aware the unaware and involve the uninvolved, only then will we cement the culture of the end of impunity that the ICTR has bequeathed upon us. Thank you, Adama. Thank you all. Happy birthday, ICTR.
Thank you. Thank you very much, John. You set the tone, 10 minutes plus 10 seconds. So I hope the next one will beat you by reducing those 10 seconds. So I give the floor to Roland Amusuga. So you have a challenge.
Thank you so much, Mr. Dieng. I'm very humbled by your kind words. Good afternoon, distinguished guests. I would like first to thank the organizers for inviting me here to this symposium. This has enabled me to renew, before its closure, my vows with ICTR and Rwanda, which share with me 19 years of my humble life. Thank you, Rwanda. Thank you, ICTR. Allow me now to take my 10 minutes to be a storyteller to you. I love story. I would like also to tell you the story of a wonderful program of the ICTR known as Outreach. Indeed, let us imagine for a second ICTR being a brand new vehicle that was manufactured by the Security Council in '94 in the aftermath of the Rwandan genocide to bring justice to the victims and the perpetrators. And that vehicle was put on a far remotely road network of Arusha. For those who have been here at the beginning could remember what it looks like being in Arusha in 1995-96. And that vehicle was tasked with the job of contributing to the national reconciliation process through the justice dispensation here in Arusha. The second task was to help restore and maintain peace and security, not only to Rwanda, but to the Great Lakes region, to Africa, and to the world. I would like you to remember that from '94 to 2000, that vehicle was quite invisible on the public road because it did not have any horn or any high beam. That could have helped people to know what it was doing. And it gave the time for critics to paint ICTR in the way they wanted. It took us almost a few years to get some leaders to establish from 2000 to 2014 a program which became the horn and the high beam of ICTR. And that program is Outreach, and it has helped shed the light on the key legacy of the tribunal. That is the story that I wanted to tell you about. But the story is very short. What lessons should we learn from ICTR Outreach? There are two categories of lessons. First, lessons from the ICTR diplomatic outreach. A masterful key was developed by a man who is sharing this panel, Adama Dieng. That tool was part of a three-step bold strategy that ICTR designed to ensure that it reached out to its stakeholders. And one of the masterful key was the introduction of the concept of the Friends of ICTR. That concept helped us to break through, to build up relationship and develop a network with those who counted, those who were paying the bills, and those who can influence decisions about ICTR in their respective cities. Thanks to the ICTR, the Friends of ICTR, we were able to break through to rally support from the Western countries that had embassies in Dar es Salaam. We reached out also to the African Union, to the regional blocs, and thanks to the President, first, Madame Pile, seconded by President Meus, and Adama Dieng, Mr. Boubacar Diallo, they all took their baton and made sure that ICTR story is known to everybody. That was a breakthrough. Diplomatically, we were able to rally support from member states to provide us with support that helped us to conclude agreement with member states because nobody wanted to receive ICTR prisoners in their prisons. I remember, and here I will recall the story that we lived through, Jean Pelé Fomete and myself, where we went to negotiate the agreement on enforcement of sentence. And we had 2 hours live debate on TV in the Republic of Benin, where people were concerned to know whether we were coming to bring the disease called genocide in their prisons. They called me and they said, your name sounds familiar to us. Sir, would you dare to come people here and bring disease to our people? Because genocide in Rwanda will come here through those prisoners and they will spread the disease in the population, in prisons, and then they will commit the same thing. It shows you how far we came where those people accepted to host our prisoners. That was a breakthrough. We managed through the outreach program, through the diplomatic outreach, to rally support to facilitate the witness protection program that we have designed at that time. That is a key success. The other lessons to learn from outreach is the capacity building program and the flagship program that is known to be Umusanzo Center. Nowadays, everybody in Rwanda know what is Umusanzo. Because Umusanzo was the window of Rwanda, of ICTR in Rwanda, that helped the grassroots population of Rwanda to understand what was happening. As you remember, we are so far away. That vehicle was so far away on the road of Arusha. And people down in the village in Rwanda could not know what we were doing. But thanks to some good donors, we were able to establish in 2000 this Umusanzo Center that received more than 100 people a day, helped train people, and we got sponsors from Germany, and then we were able to establish 10 mini Umusanzos throughout Rwanda. That is the legacy of the tribunal to the people at the grassroots level in Rwanda. We have trained through our capacity building so many judicial sectors in East Africa. Not only in East Africa, we went beyond to West Africa. We reached out to the ECOWAS court. We receive them here, we provide them training. We help to design the Witness Protection Act of many countries. Our judges were able to share their knowledge. Outreach was conceived as a series of knowledge-sharing projects that ICTR was proud of to design. And this is the mark of ICTR, the hallmark of the successful tenure of the leadership that presided over what has happened in this country. We know that Arusha is the cradle where international criminal justice in Africa has taken root. Arusha will be remembered as a place where the best instrument that mankind has ever designed was born. Arusha, ICTR are really the baby for the next century. Thank you so much, Mr. Dieng.
Roland, I'm sorry I did not follow the time you spent speaking to us. It was so passionate to listen to you. So now I invite the next speaker, Sarah Kilemi.
Thank you, Mr. Dieng, and welcome back to Arusha. and also welcome Karibuni, all of you to Arusha, those who went and those who came back. For me, today is like Christmas. And the reason for that is when you have the families get together. It's like all my family have come back. I've seen them come, I've seen them go, and now today I'm happy to be here with you. Mr. Chair, if you allow me, I will speak from the podium because I want to manage my PowerPoint. And my time starts counting when I get to the podium. Thank you very much. Administration is not an easy term. And to be told to stand here and talk about administration is really a challenge. But it's a challenge that ICTR has known from the beginning up to where we are. And we have known how to cover those challenges. If you ask anybody about administration, they'll tell you it is everything and anything that goes wrong. They will also tell you it is everything and anything that has gone right, but we don't know who did it or who made it go the way it went. Just like we are here, we don't know the people who are in the back office, those who are working so hard to make sure that we succeed. So in ICTR, we have 3 organs, and that's the chambers and the office of the prosecutor and the registry. Administration is part of registry. The beginning and the end of ICTR, the beginning started with Resolution 955, you all know about it, and our marching orders started with Resolution 1503. But then when we knew that we are really closing, it was Resolution 1966, when we knew we have to leave. The governing rules are very clear for the judiciary system, and for judges and the president, they normally report to the Security Council. The UN rules and the regulations govern the rest of us, and we report to the Secretary General. So you can imagine how difficult it is. You don't even have the single reporting line, but you still have to manage. Clarity on the status of the personnel of ICTR has never been known. Up to today, we don't know whether we belong to the UN Secretariat, whether we belong to the field missions of DPKO, or whether we belong to offices away from headquarters. Nobody knows who we are, and up to today, it has never been resolved. Now, what are the linkages between administration and the substantive mandate of ICTR? First of all, you have to ask yourself, what is administration? And quickly, I put that for you so that as we speak, at the back of your mind, you know what administration is. We have finance, we have human resource, we have medical services, supply, building, maintenance, those generators that don't work, they belong to us. Electricity not working belongs to us. Anybody who has been hit by a car on the road or driving badly belongs to us. Internal administration of justice, oversight bodies, counseling, and career development, all that belongs to us. Now, what that means, all of you belong to administration, and all of you are administrators. Now, we have a serious setback in ICTR, which did not start today. It started from the day ICTR was established. And that is what we have been calling like filling a broken jar. Is attracting and retaining staff. And that's why I said today is like Christmas, because the ones whom we have been unable to retain have come back. Now, why is this the issue? I'm sure all the panel members will talk here about it. It is lack of attractiveness of Kigali and Arusha. Not now, is when we started. Now, the ad hoc nature of the tribunal meant that people had to be told you are going to work with a finite organization. It has 1 year or 2 years. Those people looking to work in that institution must be people who are looking for jobs. Must be people who are either not able to get a job somewhere else, they are unemployed, and they want to go and work for 1 year, or those just wanting to go on a safari because they have heard there is a place called Arusha near Kilimanjaro. Now, also we had, of course, the setting and the whole of giving the seat to Arusha, I'm not sure was well thought of. Arusha is not the capital. So we have to travel 8 hours in a bus to go to Dar es Salaam to get a permit for a staff member to come and work in Arusha. That by itself takes a long time. So there is also the poor and advanced planning of the administrative services. There was the guilt from the international community of not done anything about the genocide. So when they set the tribunal, it was to go like yesterday. Nobody thought of where are the resources. How do we recruit? How do we administer them? So that made sure that people were being brought from anywhere quickly to come and work in the tribunal, and that has continued being a problem. Of course, the UN, you all know about the UN. The red tapes in the UN, nobody needs to be explained about that. To recruit takes almost 1 year. Now that was not taken into account. Now we have lack of clarity, as I said. We don't know where we belong. Contractual status has continued being a problem up to today. We can only give contract for 1 year or 2 years to the maximum. Now this, of course, anybody who has a stable family, they need to move them. They need to come to Arusha. They would not be attracted or to go to Kigali. Now uncertainty of the continued employment is a problem. We have the judicial calendar, which we cannot really predict with certainty whether what is indicated there will actually take place. Now this has led also to voluntary separations where people say, I came here for 1 year, I didn't expect to be here for 2 years. And then after 1 year, you realize you have another 1 year. Maybe you kept your holding on your other assignments, hoping 1 year you will go back. You realize 2 years you are there. You end up saying, I better go away. Now, the big challenge is we were told now you have to complete. Downsizing is a very sweet term of saying close this business and go away. So we were told start downsizing. So we started asking ourselves, who will go first? Who do we tell you are the one going first and who will go last? First of all, there is no official UN downsizing or retention policy. ICTR and the ICTY had to develop one. They had to come up with the methodology of deciding how do we tell the staff members, you are not required, you have to go away. Now we embarked through the leadership of Mr. Dieng to develop our own unique criteria for ICTR. It went through 5 phases. One is the psychological preparation of the staff for life after the tribunal. I remember the prosecutor always reminding the staff member there is life after the tribunal. Prepare yourself, Wongo. Then we had to establish the retention criteria using the consultative process where all staff members were involved. Then we had to come up with a building consensus. And here, for many of you, you hear the Lake Manyara Accord. It has become such a popular term that even in UNDT, when they have cases from DFS, they refer to Arusha Lake Manyara Accord. This is where we came up with the criteria agreed by everybody of this is how we'll go when the time comes for going. Now, we had to make it work. And the way to make it work is empower program managers to be able to apply it. We also had to communicate a lot and support all those who are downsized. How do we support those who are downsized? We'll look at it, but more details are in the paper which I have provided. We also learned one size does not fit all. Even with this retention criteria we developed, we realized OTP has to make it within the framework of the retention criteria, have also to tailor it to address the needs of OTP. Chambers and to do the same. The language and to do the same, and administration and to do the same. I've talked about the Lake Manyara, how we came with it. This is the goal, was to come with this understanding which everybody embraced. Now, we had also to know that there will be life after ICTR. In ICTR, Mr. Ndieng reminded me, we have to manage with a human face. These are individuals we are dealing with. Without them, there is no tribunal. We have to prepare them to live. So we decided that what we'll do, we'll have the Career Resource Center, which is going to train our staff members on how to do applications, how to do interviews, and how to prepare themselves for life after ICTR. We also had to train them on how to do their own businesses, be self-employed. And today I'm happy, one of the people providing services here as a private contractor is our former staff member of ICTR, and he is seated there. He was in AVU. I feel so proud because we gave him the skills to be self-employed, and today he is employing somebody else. Counseling, we also provided. Mental and physical well-being, we also had to provide. We have a gym where we tell people after working so hard, go ahead and jump there, do aerobics, so that you don't collapse and die, thinking about the closure. So that has helped. We also we've decided to assist the Tanzanians and the Rwandese who work with us, the ones we call local staff, by having the job fair. Job fair is where we have brought employers from all over the UN, brought them to Arusha and told them, these are the people you have, sample the ones you want to take.
I'm sorry, Sarah, the timekeeper has just informed me that you exceeded
I
your
didn't
time
see
by
her.
3 minutes.
I have 3 minutes, or 2.
Exceeded by 3 minutes. I give you 2 minutes as an exception, simply because...
Okay, I'm in the last one. We have not only been contributing to having the tribunal meet the mandate, but we have also contributed to the legacy of bringing Arusha and Kigali to where they are today. The salaries these staff pay, the rent they pay, the education they pay goes to contributing to what Kigali and Arusha are today. That is the statistics you see there. Arusha and Kigali today have become cities. When we came, they were towns. People were coming here only for exotic tourism, whatever. But today, everybody comes to Arusha because it's the headquarters of a lot of legal institutions, regional and international conferences being held here. We have many lessons that have been learned, but what I can say about ICTR is the achievement that we have recorded so far have contributed to the UN itself now deciding they need to come up with their own retention and downsizing exercise. And they need to also come up with a policy. ICTR and ICTY are sitting in these panels, which will come with a global policy, and to us, we feel that is something we need to be proud of. Finally, we want to say that all of you, are managers in your own rights, and all of you are also administrators. So in ICTR, we have a lot of lessons that each one of you can take home. And we are proud that those who went home, the lessons they learned here will benefit their national institutions and not only the UN. Thank you very much, and I have 1 minute remaining to sit down.
Thank you very much, Sarah. I'm sure the colleagues and friends will pardon me for having been very passionate with you. Indeed, the work of the administration is so important, and I cannot but really once again pay tribute to yourself, but also to the entire administration staff. I mean, staff which is extremely dedicated, and some of them are in this room, and I would like really to congratulate you. I mean, I know some of you staying long hours compared to, if I may remember, among the first security officers who were appointed. One of them was an American citizen. After 24 hours, decided to run, went to his embassy to be repatriated. Because at that time, you know, the situation was not that. And Eric must know one of the first indictments was signed with a candlelight. So now I will give the floor to Naftal, the Executive Secretary of Ibuka. You have 10 minutes, Naftal.
Okay, thank you to moderator, and thanks to ICTR to organize and to invite me in this important meeting, conference. And I would like to talk on this important issue. In my presentation, I would like to focus on the four following elements. Those elements are imbalance between ICTR achievement with regards to justice, judicial work, and outreach capacity building. Second is outreach and capacity building, and we see why is it important. Third is milestones, and finally we see the remaining challenges and way forward. I can say that many achievements by ICTR, but little known by beneficiaries in health of Rwanda. The role of the tribunal in developing international criminal jurisprudence, delivering justice to genocide victims and survivors, and promoting national reconciliation in Rwanda as part of its legacy is now beyond any doubt. The records of the tribunal will be useful for future generations of Rwandans and all peoples on the world, Researchers and historians may find the records useful for refuting genocide ideology because they establish an authentic public historical record against negationism and revisionism. How many ordinary Rwandans can access or simply understand this pool of information gathered by the tribunal? ICTR achieved a lot in terms of achieving its primary objective, prosecuting those most responsible for planning and carrying out the 1994 genocide against the Tutsi. Studies are needed to assess the awareness or impact and the legacy of the tribunal work. Why outreach and capacity building? There is a need for increased outreach activities and continued education about the work of the tribunal in Rwanda in order to contextualize the judicial accomplishments of the ICTR and to combat future genocide ideology after closure of the tribunal. Such interventions are needed to bring knowledge of the tribunal's work to new generation of Rwandans who otherwise may not learn about the trials in Arusha, Tanzania, and their significance in the history of future of Rwanda. If I try to talk on milestones, Umusanzu Center is the flagship outreach initiative of the ICTR in Rwanda. Many other outreach activities such as workshops, trainings, and the dissemination of public information have been taking place, but only few elites people attend such activities. There is a need for outreach program designed to educate ordinary people with minimum or no education at all. The first case referral to Rwanda, as well as other cases transferred to Rwanda, have a significant meaning to victims and Rwandans in general. The problematic of the ICTR archive, the fact that the ICTR will be housed in Tanzania is still controversial to many Rwandans and the victims in particular. We continue to call the Security Council to find an alternative to this issue. Way forward. The tribunal needs to prepare a complete document of the legacy in order to let people know what was done, how it was done, what was accomplished, and what it means for international justice, for Rwanda, and for the genocide victims. In order to preserve this legacy, the ICTR public documents should be made free, accessible via the website, and searchable via internet. Genocide Prevention and Education Center. Continued education on the genocide and its impact must be promoted. Let me conclude on this message given by Rwanda's permanent representative to the UN, who said, "We believe that as the ICTR completes its work, the United Nations and the international community should establish a genocide prevention and education center to serve not only in memory of the genocide's 1 million victims, but also to serve as a center of research and learning about lessons learned from the genocide in Rwanda, and as a center to promote justice, reconciliation, and human rights. Thank you.
I thank very much Naftal, and now our last speaker before the break is Jonas Mutwaza.
Thank you. I will present a paper about the contribution of the ICTR legal library to the trainings of judges, prosecutors, legal officers in Rwanda. But I think also we went out to Rwanda. We conducted the same service out of Rwanda. I think I will present first the ICTR library, which is now currently mixed library. I will also talk about how we come on this program of capacity building. And I will also show some components of the ICTR library capacity building. And we have also realized some achievements. I will just present some benefits from the program. Okay, the library was established in May 1998 by the principals of the ICTR. But at this point, I can also mention that the particularity of the ICTR is that it created small libraries even outside Arusha. And just to help all clients from the ICTR to have access to its materials, but also to have access to the jurisprudence. Is this reason in 2000, they have created the Umsansu Outreach Library. In 2011, we have also established the mini information centers in Mali, in Benin, and also at the UNDF here in Arusha, we have also another small library, just to let people have access to all information they need. And you will see that when I will continue, how, for example, at the end, we created some network between this library from Arusha and the other libraries in Rwanda, and also with other libraries around the world. Normally, the mandate of the library, it was just to provide information and documentation to support the trials. We provided information to the trial chambers. We provided the information to the office of the registrar, to the office of the prosecutor, but also to all staff who needed information just to carry out their activities. But also, the library receives information really about from Rwanda, but also from the sub-region. And you will see also that we were also receiving information from outside. I think we were receiving between 15 and 20 requests from outside. And I think the bibliography just we have compiled about ICTR can show how people from worldwide have been inspired by the work of the tribunal. And you will see every year, this is the new version compiled by MICT Library. We have seen that normally from 2012 and 2014, we added more than 200 publications, including books, articles, and other materials. I can also say that on this point of presentation, that this library, the library which is based in here in Arusha, it became the prompt library regarding as a reference library when people are looking information regarding information criminal law, genocide, human rights, and other related fields. Before conducting this program of capacity building, training in online legal research, just we had consultation with Rwandan institution just to let us know what they need. We met universities, we met the judicial sector, and we met also the Bar Association, just to hear from them what they need and what we can bring. And from there, we have then elaborated our program, and we started the training program. As part of the component, we had this information research. This is a module of online legal research where we were teaching the methodology and show also the tools people can use to have access to the information. I think you agree with me that all of these databases, legal databases and other commercial databases, it's not easy to search them. I think people need to be trained just to be aware how they can search and how they can retrieve information. We also promoted the ICTR judicial databases, the databases which in also CD-ROM, but also we showed people how they can search also the public judicial record databases, but also they were also aware about the other UN databases, how, for example, they can access the United Nations official documents, and also to have access to United Treaty database. And people really, they were all able to just to search by themselves. But also, as Laura said about the mini Umusanzu, when the mini Umusanzu were established, we conducted also training just to let people know how they can manage those libraries for the benefits of the High Court, but also for the benefits of all institutions based in those provinces. But also what is important, we shared also the documentation between the two libraries, between this library here in Arusha and the Outreach Library. And even now, when we publish at the end of the month the list of new acquisition, they are aware that those resources are available, and we can also deliver electronic documents where they are needed. But also, as I said, we went also beyond Rwanda. We have, I think we were called by the ECOWAS to conduct also the same training and to assess how they can also have access to all electronic resources. But also recently, I think the president also received another request, and he redirected it to the MICT just when it was this induction of new judges at the African Court on Human Rights and People Rights. And there we conducted also some trainings. And I think there are also requests from the Tanzanian judiciary. I think the registrar know that this time I think we are preparing also to do the same. As benefits, I can say that at the end of the training, at the end of the program, people were able to carry out the research themselves. They were able to search all the databases and also to retrieve documents. But also, from this, we had that the possibility to have access to more resources. Those resources accessible via INASP. INASP is a program which allows access to developing countries, and from there they have access to resources from Cambridge, from Oxford, and people were trained how they can do that. And we helped also institutions in Rwanda how they can register and have access to those resources, but also they had also access to other available free resources which now are you can find from internet. But also what was very, very important as another accomplishment is this course of internet research methodology has been integrated in the curriculum in Rwanda. Many institutes, many schools, they have integrated this program, and now, for example, when they are teaching this course called the research methodology, the same program is inside. And also, they were also the increasing usage of library materials. We received really a lot of requests from Rwanda, from outside, because of the training. And also, we met other librarians in Rwanda, and we discussed with them how, for example, they can also try to promote those resources. Now, by concluding that, I said that the ICTR Legal Library has been transferred to the MICT, and MICT, I think, had the same program, and we will continue. I know that there are some things we did not do, the training of trainers, but I think when we receive other requests with MICT, I think we will accomplish other duties in Rwanda and worldwide. Thank you very much.
Thank you very much, Jonas. So now, according to the program, we have a 15-minute break, so please make sure that we be here on time to start at 3:20.
15 minutes is always a bit
Yeah.
ambitious.
You're right. I was saying 15 minutes is always ambitious, you know, to have a 15-minute break, but I think we should really start. So, colleagues, we start the second leg of our program with the discussant. We have 3 of them around the table, and I will be starting with Manjai Nyang, ICTR judge. Manjai.
Thank you very much, Adama. I will try and use the very limited time allocated to me to give a testimony, to pay tribute to the registry and his staff for the very ungrateful work they do. I have worked in other sections of the tribunal, so literally I can say that I have almost been everywhere apart from the Defense Council section. And what I know is that from the vantage point of those sections, many people often wonder what registries people are doing if they are not busy impeding the good work of other people or traveling the world for doubtful purposes. Registry staff are these very unfortunate people who everybody turns to for their operational needs and who almost nobody is satisfied with. They are often the punching bag. There is this common belief that the registry must see to it that legal and support staff are hired on time and their different administrative needs satisfied, regardless of the defect in planning, the budgetary constraints, and other impediments stemming from the UN rules. Witnesses must be in court when their presence is required, of course, irrespective of their location. Lawyers must be flown from every continent. The courtroom must be functional in every aspect. The security of people attended to, the minutes of proceeding taken properly, the record of the court well kept, the accused person well guarded. I can just go on and on. The list, I think that the registry's to-do list is just endless, and the challenges are so many. And I will not list these challenges. Suffice it to say that most of them have been overcome over time. And novel practices have been developed that will serve now as a useful blueprint for future operations. I would like at this point just to highlight 2 series of developed practices. The first batch would be those that illustrate the necessary adaptability of an international court in a difficult environment, while the second batch would be the practices rather symptomatic of a bloated body and which might require jettisoning with no place in the record of good practices. The exclusive criterion to determine a registry's efficiency is whether it serves adequately the needs of the judicial process. In this regard, ICTR registry, I can say, has not done a bad job at all. Even in the most unexpected situations, it has been present. And I remember, for example, during the first acquittal pronounced by ICTR, the judges, in a burst of creativity, so I'm not provoking you, Judge Moss. In a burst of creativity, they decided that despite the prosecution appeal, Ignace Bagilicema would not be held in detention, as a plain reading of the rule at the time would suggest. So then the judges requested the registry to immediately devise a new regime of accommodation that would not amount to detention without equating to total freedom of movement. So there was, of course, no legal regime, nor was there any budgetary line to that effect. So the regime of safe house for acquitted person was born. The registry's creativity was equally put to test when, to patch up a judicial disaster, the judges decided that the accused person whose right would have been violated in the course of proceedings would now be awarded financial compensation following their acquittal. So when this so-called now Barayagwiza jurisprudence was first applied in the Rwamakuba case, so the registrar was asked to pay up a few $1,000s without, of course, anyone bothering to identify where the money would come from. So innovation was also required to come to the rescue of African states that have accepted to receive ICTR convicts. Those states should normally be totally responsible of the management of the condition of imprisonment as per their domestic legal framework. ICTR should step in only in the limited occurrence of granting early release or parole. And when the task has proved to be too much for those countries, ICTR registry had to craft a sui generis system of remote management of the enforcement of sentences. Of course, in cooperation with UNDP system and the domestic correctional services. ICTR was prepared to take on this new endeavor because it was already running a detention center on its own, the first of its kind in the UN system. And of course, the management of acquitted person has also turned ICTR into this strange animal grazing in the meadows of the UNHCR. I'm of course not sure that ICTR should be doing this, and surely it should not be doing it alone. But there are so many other things giving rise to the same interrogation. When ICTR started in operation in Kigali and in Arusha in the mid-90s, the conditions were very difficult. The tribunal had to be self-reliant to get started. ICTR staff were pretty much dependent on the ICTR administration for almost everything, with no meaningful contact or expectation from the local authorities. In trying to meet those needs, the registry has literally turned into a small state within the state. ICTR has been delivering passport and driving licenses, providing basic health care to staff and their families, generator for electricity, and even water in jerry cans when the local water supply was not working. In the early days, a cashier would pay directly the local portion of their salary. And when facing a break-in or a robbery at their residence, when involved in a car accident or a fight in the market, staff would call the ICTR security, not the police. Conversely, when...
Please conclude.
Yes. Mm-hmm. Okay. 2 more minutes.
I have already exceeded.
So, conversely, when action are directed against ICTR staff member, the preferred avenue would not be the local authorities, but the registry, be it for child support, spouse alimony, domestic violence, mending broken relationship, unpaid rent, labor issue. The registry has been regularly called upon to intervene And more often than not, it has intervened. In this process, of course, the boundary between amicable conciliation and legitimate jurisdiction have at times been blurred. And the intricate legal regime of immunity UN staff enjoy would appear as a powerful inhibitor to intervene for local authorities. So I'm very considerate of the time, so I cannot just go on, but there is just one highlight, if you allow me, because I think that it's very important that I really want just to mention, is this the treasure of imagination deployed by the registry, particularly the witness protection section, to bring defense witness to Arusha. ICTR would have failed if it did not manage to ensure the appearance of defense witnesses. And many of those witnesses live abroad, often in the hiding, because of their illegal residential status, combined sometimes with the fact that they are wanted in Rwanda for possible involvement in the genocide. It took courage and strong dedication to justice to approach the state and get them to agree to provide provisional travel document to those witnesses and allow them into the country despite their illegal status. This operational scheme will remain, in my view, the most memorable achievement in ICTR registry. So now, just as I conclude, lastly, the image I have is just this image of after 20 years, ICTR now, like this singer, facing the final curtain, like this singer of the famous song, My Way. So, and we can say, like him, that we've lived a life that's full. We've traveled each and every highway, and we did it our way. Thank you very much.
Thank you very much, Judge Nyang. I mean, I'm glad this symposium is not broadcast to New York, but only to Arusha. Otherwise, next year I'll be in travel with the ambassadors in New York, because I'm very tough with them. Whenever I moderate 3 minutes, we move to the next speaker. So now I invite Don Dea, and please, Dea, don't imitate Manjai.
Thank you very much, Adama. I will limit myself to 3 words: capacity building, outreach in the context of legacy. And I also note that Naftali and I are the only non-ICTR people on this panel, so I think that places an extra burden on us to either confirm, contest, or vary the version given by the ICTRs. And I'm happy to say that we are able to, at least I am able to confirm most of it. Working with the East African legal profession over the last 15 years or so, I can say that we shared a very strong relationship with the ICTR. The initial outreach that the ICTR did, I think I was in the Law Society of Kenya then, was to come and impress upon local lawyers in the region the importance of applying to be staff of the ICTR or to be on the Defense Council list and so on. Judges, the prosecutor, the registrar, and their office have undertaken substantial training of the local legal profession, of governments, and of civil society, both at their own initiative and at our request. You know, I can easily think of possibly close to 100 sittings that I've had in meetings with Hassan Jallo and Adama Dieng only, without counting the rest of the other colleagues of the last dozen years. We did partner as the East Africa Law Society with the ICTR and with the Brandeis University to hold, I think then it was the first symposium on the legacy of international criminal tribunals for Africa, with a focus on the jurisprudence of the ICTR. That was in late November and early December of 2007. And again, bringing us on board enabled us to bring very many local lawyers and legal scholars into the room. And at least one of them then published an issue of a journal. He was the dean of the law school at Ruaha, just based on the proceedings of that conference. So did Brandeis University. They published a book. One of the ones that I'd like to speak about most, in 2008 in August, we as the East Africa Law Society were in campaign mode when we had the rumor that there was a possibility that the archives of the ICTR would be shipped off to The Hague. And we held a meeting and invited colleagues from the ICTR. And what was meant to start out as a campaign stump speech ended up as a very thorough capacity building of East African lawyers, librarians, information scientists, and so on just what it takes to set up and manage an archive. And we actually came up with a very good communique out of that, which addressed a lot of issues of detail. I remember spending hours with Isaac Endeley, Louis Njai, Angeline Jampu, and so on. And I know that one of your latest projects now is a manual on the prosecution of sexual and gender-based violence crimes in the Great Lakes region. And again, my office now has partnered with you on that. I have used, or we have gotten to use, a number of ICTR lawyers, defense lawyers, Ken Ogeto, Gasho Motachi, in one of the first and very phenomenal cases that we did at the East African Court of Justice, the Peter Nyang' Nyong'o case. And even now at the African Court of Human and People's Rights, one of the local pro bono counsel that we rely on a lot is another of your members, Rashid. In a couple of weeks, we'll actually be engaging in capacity building for the African Commission on Trial Advocacy, and we'll be using him along. I think the African Court is happy to have with it Nuhu Jallo, whom you loaned to him. I think the Tanzanian judiciary is happy to have with it Othman Chande, after passing some time with you. It would be interesting to note that about 2 years ago, the government of Mali filed an application at the African Court requesting for an advisory opinion precisely on what it should do in terms of its state obligation for human and people's rights with convicts who had served their sentence in Mali and could now not go home and nobody else wanted them. Unfortunately, with the changes of government, they withdrew that advisory opinion, so we missed the opportunity, but I think that can be recreated in the future with a bit of innovation. I would also point out that one of your veteran counsel, Charles Taku, is also, alongside Palu, one of the most prolific litigators at the African Court. I'd like to spend my last 1 minute talking about some of the softer issues of the legacy of the ICTR. As a person who has lived in Arusha for 13 years now, various officers of the ICTR have been our neighbors. Our kids have gone to the same school. We have gone to the same churches. We have dined and wined together. And on those days when we still used to party, also partied together. And it's been quite an impact on the city. I think Sarah Kilemi had mentioned that. But I would say, as a human rights lawyer in Africa, it's also been quite an impact on my personal life. The mentoring that I've received from Hassan, from Adama, from others, the lifelong friendships made between the ICTR community and the rest of the legal community here. And I think that's a legacy indeed. Thank you.
Thank you very much, Don. And I invite Vivian Dietrich.
Thank you very much, Mr. Undersecretary General. Thank you very much also to President Jensen and Prosecutor Jallo. I'm delighted and honored to have been invited to this important occasion and to make an active contribution. Today, in my remaining 5 minutes, I'd like to invite you to take a step back, if you like, and go behind the scenes a little bit of what it actually means to leave a legacy as an organization. So in other words, I suggest a more conceptual approach, which very much complements the fine-grained legal analyses and very rich and in-depth kind of inside accounts in terms of operational and practical procedures and activities that tribunal staff members have been sharing here today. The paper I wrote is based on my ongoing research that I've been conducting over the past few years about the institutional developments of the international tribunals in light of completion, closure, and the whole notion of legacy towards devising or looking at the tribunal's role in legacy building against the backdrop of theorizing the construction of legacies. And it's a great pleasure to be here today and be in a room of so many assembled tribunal officials, staff members, and actors who I've had the pleasure to interact with over the past few years and who generously shared their experiences and perspectives. Now, 20 years after the establishment of the ICTR, it seems timely to really theoretically accompany the tribunal's developments, impacts, and effects. And my remarks will focus on three select aspects. First of all, a brief mention or brief word on the notion of legacy itself. Obviously, the tribunals, in light of the upcoming closure, have faced three separate yet related elements, being the completion of mandate, residual functions, ongoing legal obligations, and the notion of legacy. And for a good decade now, the notion of legacy has become a buzzword, so to speak. The notion that tribunals should leave a lasting legacy beyond prosecuting a select number of individuals has become omnipresent. And this does not seem coincidental, as obviously the ICTR, together with the ICTY, are in the final throes of their respective completion strategies. Now, talk of legacy often arises in a valedictory setting, very much reflecting upon the meaning of being, meaning of doing. And yet it seems that in the context also of discussions here, the notion of legacy seems engulfed in a paradoxical situation. It seems understudied, yet rhetorically overused, and by that I by no means mean to suggest to dwarf any achievements or contributions, but to suggest that there have been very few kind of robust, systematic empirical studies of the legacy, and I think that's an area of research that's going to go forward to provide more systematic studies beyond kind of anecdotal evidence. In my research, I've very much looked at the notion of legacy, and very much a plural notion of legacy that I advocate, in order to highlight the multiplicity of legacies that arise and the multifaceted nature of the legacy of the tribunals, that there's no one single kind of objective legacy. Also developed an actors framework, and I think that has been very illustrated here at the tribunal, with many actors present and many very interesting discussions taking place about many of the judicial aspects, but also the non-judicial aspects of an organization. Next, allow me to direct attention to the tribunal as a legacy lever through the prism of what I've termed the institutionalization of legacy. So the ICTR, together with its fellow tribunals, has developed a heightened sense of a self-understanding of a legacy lever that by no means occurred overnight or just recently with the upcoming Legacy Symposium, but actually has been in the making for a long time, and since a decade the tribunals have been grappling with their own role as legacy levers. And I argue that there's been a discernible trend across the tribunals towards institutionalization of legacy on three levels. So first of all, rhetorically speaking, legacy is recognized as an issue, and certain legacy vision is developed. And I think very much the Legacy Symposium can be seen as a kind of coming to fruition of that process. And second, structurally, institutional bodies and professional positions dedicated to legacy have been established. At the ICTR, already a committee was established in 2005 and then reconstituted in August 2012 by the registrar, and also a legacy project coordinator was appointed in 2013. Practically speaking, then, the third level has been very much efforts of designing and implementing so-called legacy projects, and I think we've heard a number of these projects being discussed here, and providing some details such as the just mentioned Legacy Symposium already back in 2007, the various best practices manuals that have been mentioned, and also the new legacy website, which I understand will be launched tomorrow. With that being said, facing the pending closure, the ICTR has moved towards legacy consolidation on many fronts, and we've heard again lots of illustrations of this over the past 2 days. And often, however, it is neglected to recognize that legacies are not just shaped or constructed towards the end of a lifespan with particular legacy projects, but actually emerge throughout the history. And as Kofi Annan remarkably foreshadowed in his Rule of Law report in 2004, and I quote, "And it is essential that for the moment any future international hybrid tribunal is established, consideration be given as a priority to the ultimate exit strategy and intended legacy in the country concerned." End of quote. Now, to conclude, while the ICTR has become very proactive in recent years on the kind of explicit theme of legacy, it appears no tribunal can build its own kind of authoritative legacy, as collective interaction and multiplicity of voices very much part and parcel of the construction of legacies. Certainly, the tribunal is a very central actor in that process, albeit there are a panoply of actors. And it would appear erroneous to assume any monolithic kind of perception or perspective on legacy, both within the institutions and outside. So this leads to the last but not least point then today, that the tribunals do not operate, obviously, in an apolitical vacuum, and legacies are object, if you like, over debates over the power of interpretation, struggles over contestation or control over legacies, and I think we've had some flavor of that in this very room over the past
Thank
days.
you very much, Viviane. I think your conclusion is getting too long. So that we can allow few questions for the floor. Would like to start. So 1, 2. I'm just counting because of the concern of time. We have only 15 minutes left. The other 15 minutes have been eaten by the panelists and discussants. So we have 4 speakers. So I give each of you 5. Each of you not more than 2 minutes. Not more than 2 minutes, and I'll be very strict. You know, please start first. Yeah.
Merci, Vincent Dehilde, procureur au Cambodge. Tout le monde reconnaît ici la richesse de la jurisprudence et du travail et de l'héritage du TPIR, mais n'y a-t-il pas au moins 2 vices fondamentaux de conception que sont d'une part la place des victimes devant le TPIR, pas de partie civile, pas de réparation, pas de place spécifique pour les victimes, à part comme témoins, qui sont soumis à la difficile expérience de l'examen des parties. Deuxième élément, on sait pourquoi le TPIR s'est installé à Arusha, sans doute pour des raisons de sécurité, des raisons politiques, mais si ce n'était pas possible de se rapprocher de la population rwandaise par le siège, n'était-il pas possible d'organiser des procès ou des audiences à Kigali ou ailleurs au Rwanda pour qu'il y ait un sens d'appropriation de ce qui s'est passé ici par la population rwandaise et pas seulement par la communauté internationale. Merci.
François Roux.
Oui, merci. C'est plus une motion. Je pense que dans l'héritage du TPIR, nous ne pourrons pas vanter le respect de la diversité culturelle et linguistique, ni le respect des minorités. Alors, au nom de la minorité francophone dans cette salle, puis-je demander à nos amis anglophones de faire l'effort de parler lentement pour le bien-être non seulement de ceux qui vous écoutent dans une autre langue, mais aussi pour le bien-être de nos interprètes. J'ai entendu tout à l'heure que l'on est sensible au bien-être des staffs. Je ne sais pas comment nos interprètes vont pouvoir continuer à travailler dans de telles conditions, et pour ma part, je les remercie.
Merci. Je pense que ta motion est acceptée et nos amis anglophones feront cet effort. Next speaker on my left.
Thank you. I'm quite disappointed that Viviane has not had more time to speak, because as I pointed out yesterday, this conference was missing the conceptual discussion of what legacy actually means. So this is, she did not pay me, but this is a question to her, asking her to develop more what legacy actually means. And I'd like to take the example of discussion of outreach about the work of the tribunal in terms of what the judgment said. I think that we've taken too much at face value that the tribunal tells the truth, tells a story, and this can be received. We heard from a defense lawyer this morning that the acquittals were strongly criticized in Rwanda. So I'm just wondering if we're not deluding ourselves that this is just confirmation bias, that some judgments just confirm what people want to hear, and the judgments that go against it are rejected. And I don't see that as legacy. And it's the same with ICTY judgments when you look at studies done in the Balkans, etc. So I'm wondering if we shouldn't take a more critical approach
to the idea of truth and narratives produced, especially in the case of the ICTR, which did not prosecute any Tutsis. Thank you.
Thank you. So whatever that lady.
ICTR staff member spouses has been contributing to local community of Tanzania. In fact, they've built a borehole, and we want to know how this is going to be kept alive after ICTR goes.
Thank you. Now I would invite, oh, sorry, Upendra.
Yeah, just I want to know, because one of the ICTR legacies should be on the preventive efforts. And Mr. Adamadyang, as you are on that prevention side, can you say, confirm, like with surety, that there will not be any more genocide in the world? And if so, what should be the threshold? Thank you.
Very difficult. You know, unfortunately, never again, we keep saying that, and it looks like it's really finally. But what we need is to be all of us committed and dedicated, because at the end of the day, when it comes to prevention, it cannot be the work for one office. That's the work of every and each of us. And there is no doubt that the important work, the important achievement of ICTR have contributed, even in the reflection we have had recently in my office, when I decided to amend our framework of analysis regarding the atrocity crimes. Because at the end of the day, to my view, prevention is key. And I'm glad to report that the Security Council, in the course of this year, has adopted 2 resolutions reiterating the importance of the mandate of the prevention of genocide. So if we all get together, I'm sure we can make a difference. I was saying to my good friend Eric Moss that in the near future, I'm bringing together religious leaders from all parts of the world, Jews, Muslim, Christian, to reflect on what could be their contribution in the prevention of atrocity crimes. And when I said atrocity crimes, I'm referring to genocide, crimes against humanity, war crimes, and ethnic cleansing. Now I would like to invite the panelists and discussants to consider the questions which have been raised. First, la place des victimes devant le TPIR. Who would like to answer that question? Amusuga.
En effet, je suis d'accord avec. Sorry. Je voudrais vous dire que, en ce qui concerne la place des victimes, il est vrai que le statut n'a pas accordé cette place prépondérante qu'on aurait souhaité avoir comme dans nos systèmes, dans certains systèmes. Mais le tribunal, à ma connaissance, en 1998, Madame Pilet, qui était la présidente du TPIR, a essayé de saisir le Conseil de sécurité de cette question et a demandé à ce que le Conseil de sécurité puisse réfléchir à la question, mais malheureusement, aucune suite n'a été réservée à cette demande. C'est dire que, de notre côté, en ce qui concerne la gestion de la situation des témoins et des victimes, nous avons introduit énormément de réformes pour prendre en compte la situation des victimes. Et ici, je parle sous le contrôle de M. Dieng, puisque moi-même, j'ai été celui qui a créé le département chargé de la protection des témoins et de l'assistance aux victimes. Nous avions conçu un programme d'assistance aux victimes qui allait au-delà
de ce qui était demandé. Et nous sommes sortis de notre réserve pour essayer de mettre en place un programme qui prenait en compte la situation des victimes qui souffraient. C'est ainsi que les victimes qui étaient atteintes de sida recevaient une contribution du TPIR par le biais d'un système qui a été organisé au Rwanda à travers un système médical qui prenait en charge ces victimes. Le TPIR a essayé de concevoir, avec une certaine innovation, des projets qui ont été renforcés la situation des victimes et qui ont fait que les victimes étaient du TPIR. Je parle aussi bien des victimes qui venaient dans le cadre du témoignage pour la défense que pour le procureur. Parce que le greffe a essayé d'apporter des solutions impartiales à la situation qui se présentait au greffe par rapport à la prise en charge de ces victimes. Donc, je vous dis tout simplement que bien que le statut n'ait pas reconnu une place ou un rôle en dehors du fait que la victime peut être appelée à témoigner, le TPIR, à travers le greffe, a mis au point un programme d'assistance qui a été effectif et qui a aidé les victimes à être réellement prises en compte par le TPIR. Merci.
Merci beaucoup. Oui.
Le petit commentaire que je voulais ajouter par rapport à cette question, c'est que d'un point de vue strictement juridique aussi, M. Dieng l'a indiqué dans son propos liminaire, nous avons un statut qui emprunte dans une très très large mesure la démarche de common law. Et dans cette démarche-là, il y a une dissociation entre le procès pénal et le procès civil. Bon, une raison pratique aussi, bon, je n'étais pas dans la tête de ceux qui ont adopté le statut, mais en fait, à l'épreuve de la pratique, on se rend compte aussi que le mécanisme de constitution de partie civile tel que pratiqué dans la civil law n'est pas toujours très praticable quand on a des centaines de milliers de victimes. Donc, ce débat-là a eu lieu au niveau de la CPI, mais comme vous le voyez, en fait, le modèle qui est retenu par la CPI n'est pas un modèle d'ailleurs qui est strictement conforme au mécanisme de constitution de partie civile tel que c'est vraiment connu. Vous avez aussi posé une question par rapport aux audiences à Kigali, et peut-être là, c'est Roland qui va me compléter, parce que je crois que même s'il n'y a pas eu des audiences, en fait, il y a eu des activités qui ont eu lieu à Kigali, en fait, y compris dans nos locaux à ICTR, où des mécanismes ont été mis en place pour diffuser en live les audiences de ICTR et puis à un moment aussi au niveau de Oumousanzo. Sans parler maintenant des audiences que je pourrais appeler presque à la limite d'audiences foraines, de petites audiences où des gens ont été délégués pour recueillir des témoignages à Kigali.
Nous avons des contraintes de temps. Il est déjà 16 heures, donc théoriquement, nous aurions dû interrompre la session, mais on va continuer peut-être avec la permission des organisateurs, encore 5 minutes. Je donne la parole à Valérie pour répondre à la question « What legacy means ».
Yes, thank you. Thank you for that question. I mean, I'd essentially say two things again for sake of brevity. First of all, I'd say that obviously some thinking has gone on behind the scenes, even if not necessarily visible on any of the particular panels. But as I mentioned, the tribunal itself has been very active kind of in this area in terms of internal discussions that have been going on. Also, there is obviously indication of some constructive introspection. Again, we've had examples and illustrations of this in terms of the best practices manuals to critically reflect upon one's own work. So I think there has, that work has started, at least at the tribunal. The second point I would make on this that, I mean, obviously you're kind of in the academic debate, there has been a lot of debate in legal scholarship and even beyond on the work of any of the tribunals. So I think that's definitely something with passage of time that will continue. But thinking about the legacies of the Nuremberg Tribunal now, 60 years later, if that's any indication to go by, that will obviously remain an ongoing discussion. And finally, I think obviously the topic of legacy is so significant and so sensitive in a way as well, since it touches upon constructions of meaning, of ownership, of legitimacy, of raison d'être, purpose. And in these areas, obviously, there has been debate also that has been ongoing. So I think going forward, for the tribunals, there are obviously some themes or challenges that the institutions will be facing, as long as they are kind of still as legacy leavers and even beyond in terms of sustainability of these legacies, in terms of capturing institutional memory, in terms of preservation of the legacy and activation of that legacy. And I think there was a brilliant discussion at the Prosecutors Colloquium in terms of active reception of these legacies at the national domestic jurisdictional levels, and how that kind of active reception of the jurisprudence and law and procedures is going to be carried forward. Thank you.
Viviane, and now I invite Sarah to respond to the question raised by the lady behind on what will happen to the work of ASA, the Spouses Association. Sarah, briefly.
Thank you, Mr. Ndiaye. The question was what to do with the ASA projects. ASA is Association of ICTR Spouses. It is led by the wife of the prosecutor, Madam Yalo, and they have a lot of projects. They are building hospitals, they are building schools, they have put water projects, they're educating orphans, and they are also empowering communities to be able to generate their own income. We have had discussions with them on what will happen to these projects, and they are currently trying to empower the local leaders so as for them to take over the projects. And so far, they have managed to bring a lot of leadership from the local community to be able to continue with the projects. So this is a legacy that will remain long after ICTR is gone. And I know all ICTR staff members have contributed to the equipment we have brought to the hospitals. We built a maternity ward at the Mount Meru. So these are some of the things that people never see, but which communities will always remember ICTR was here sometimes back. Thank you.
Sarah, John Hawking.
Thank you, Adama. And I'd just like to touch on a couple of points that have been raised. And first, following on from Sarah Kalami's point regarding the clinic, regarding the Staff Association. As I said in my presentation, the mechanism has been all about trying to take the best practices of the two tribunals. And this is actually one of what we have seen is best practice. We're very fortunate to have the same prosecutor as the prosecutor of the mechanism, and he has brought his spouse with him, of course. And I'd like to say we have funded, the mechanism has continued and has actually raised funds for the digging, the construction of a well here in Arusha, and in fact the President, the prosecutor and I put forward half of the funds, and the staff, the rest of the funds came from the staff. So a very great initiative that the ICTR set up. Another one relates to the clinic, and there was both Amasuga and Judge Young have referred to the clinic. I'm sorry, I must talk more slowly. I apologize for the interpreters. A great initiative that was set up by Adama Dieng when he was registrar of the ICTR. I referred to it in my presentation, how the Rwandan Minister of Justice himself complimented the work and talked about how it spreads way beyond the assistance just provided to the individual patients, who now number approximately 2,000. And just one final point, talking about diversity. The mechanism in its recruitment drive over the last 2 years has of course been very mindful of the importance of diversity. We have about 130 staff coming from close to 50 different states, to 50 odd nationalities. And I'm very proud that almost 60% of our professional staff are women, and the vast majority, 80 odd percent, come with some experience either with the ICTR or the ICTY. Thank you.
Thank you very much, John. Roland, 1 minute, and 1 minute to each of the panelists and or discussion if they wish. If not, we will close.
I just want to add that as part of the ICTR outreach program, we have been extremely careful in crafting what could help us to reach out to the people of Rwanda. In such, we were able for each and every event to move in journalists from Rwanda. We have feed also the Rwanda television with live pictures of events that are occurring here, and we organize in a way that our team that is on the ground go and organize town halls in each and every communes of Rwanda about what is happening in Arusha. We bridged the information gap in Rwanda, and we were even able to conduct, with the help of the University of Butare and the Research Center, a survey that helped us to identify the level of satisfaction of the grassroots people in Rwanda. And they expressed appreciation for what ICTR was doing to bridge the gap, because we were working from here, but we managed, with the help of our office in Kigali, to reach out to all the communes. Thank you.
Thank you very much. Any other? Yes.
Thank you, Adama. I think with regard to the questions of legacy asked, I have a question for Vivian, which I think we can take on after the room, and that's around continuum. I think you can try and isolate what each tribunal did by itself as part of its legacy, but I think we can also compute what has been the progressive development of the law and the progressive development of the practice around accountability that has been contributed to by the continuum of the various ad hocs, hybrids, and ICC. 2 weeks ago, actually last week in Burkina Faso, one of the reasons why Blaise Compaoré stepped down without letting his soldiers shoot the citizens was because he didn't want the fate that befell Laurent Gbagbo to befall him. Lives were saved. That's been achieved by the continuum. But I have one more for ICTR. The African Court Protocol that I spoke about the other day, in its definition of genocide, explicitly legislates genocidal rape. It we were trying to achieve by explicit legislation the path that ICTR had blazed by jurisprudence. That's something that ICTR contributed. Thank you.
Very much, Don, and I think I'm glad that you refer to the legacy, not only the legal aspect, but also the non-legal aspect of the legacy of the tribunal, which have been brought to our attention. And I can say that referring to the legal aspect of the legacy, the media trial judgment, for instance, is an important legacy for the entire world. And I can say that this judgment is as much important as it was those days than it is today, particularly in light of the hate speech which is growing in some part of the world. And I can simply refer, for instance, to the psychopaths who are committing atrocities today in Iraq, I mean those so-called ISIS, and you can refer also to the numerous dangerous speeches which are being circulated through the social media. I mean, you all have in mind what happened in Brussels when this crazy, I would say this psychopath went to kill people at the temple. So we have really to go again and again through that judgment and to draw lessons from it. And I could say that in summary, if we have to really discuss about what has been the capacity building, outreach, etc., if we can simply say the ICTR legacy in this area has been marked by creativity, flexibility, concern for respecting legality, but most importantly, embracing humanity. Because I think at the end of the day, if there is something which each and all of us really is keeping as a legacy, that is to say that what we have faced in this tribunal, what we have seen. And I remember my first visit to Kigali in the early days, speaking with the interpreters who were repeating what they were hearing from the victims, particularly those who were raped, for instance. And I was so shocked that I decided upon my return that we need to have a special session on trauma for those staff, and we decided to extend those training to the representative of the survivors group, including Ibuka, the Widows and Orphans Association, etc. So to say that, dear friends, we can be proud. We can be proud of the achievement of the ICTR. And this has been made possible thanks to the commitment of each and every of us, starting from the judges, the prosecutors, members of the staff within the registry, and not to forget an extremely important part of this tribunal, that is the defense. And I think we all owe a tribute to the courageous defense lawyers who have been working in this tribunal. The registry has had time to time problem with them, but at the end of the day, we were carrying the same message, that means making sure that fair trial be really the mark of this tribunal. And I can say that we are happy that we were able in these last 20 years to come to the end of the work of this tribunal. And we simply hope that never again we will face such a tragedy, not only in this continent, but throughout the world. And with these words, I would like once again to say happy birthday to the ICTR, and to say to all of you, let's join hands to make the prevention of genocide something very special. Each of you in your respective countries, each of you in your respective offices, bear in mind that you are an actor for the prevention of genocide. And I thank you very much, and I seize this opportunity to thank those governments who all this year have been extremely supportive of the ICTR, and those also who are continuing to support my office. And I would like to thank personally a former ICTR staff, Steve Rapp, to whom I'm going to sit now for the next session. And once again, thank you very much. And sorry for the interpreters, but you have been really an important part of the legacy of this tribunal. You have been here from the beginning, and you will be finally at the end, mostly the last to be leaving the Arusha. And I congratulate you for your excellent work, which has been praised recently by the ECOWAS Court of Justice in Abuja, which benefited from the experience of this tribunal. And we hope that we will continue even beyond the ICTR closure to provide that assistance. And here I'm referring to John, and I hope the MICT will be able also to make that same contribution. And in this regard, Umusanzu should be certainly revisited, because it will be certainly a disaster if Umusanzu is simply given to the government of Rwanda. It is not that I deny the capacity of the government of Rwanda, but I think at the end of the day, we need to come with a new maybe setup to make sure that Umusanzu can become what the Ibuka Executive Secretary said, a kind of a center for the prevention of genocide. And therefore, my office will be extremely delighted to work closely with ICTR and particularly with MICT to see what we can do to make Umusanzu remaining for life in this continent. I thank all of you.
Our sincere thanks to Mr. Adama Dieng, Special Advisor to the United Nations Secretary General of the United Nations Secretary General, on the prevention of genocide. And as he said, we're now giving the floor to our sixth panel that would deal with the theme of evolution of defense systems in international tribunals. And while they're joining their seats, I would like to make some housekeeping announcements. The first announcement would be that tomorrow morning, buses will leave here at 10 a.m. to take you to the ICTR for the events of the day. There will be departure from this hotel tomorrow at 10 a.m. Moreover, we would be very grateful if you could reconfirm your travel intentions for the benefit of our Legacy Committee to ensure that all arrangements are made. Thank you very much. At this point, I do give the floor to His Excellency, the Ambassador Stephen Rapp, U.S. Office of Global Criminal Justice. Thank you.
Well, thank you very much. We have one representative of the defense here. We need 5 more. So let's take our seats and move the panel through and finish on time. Well, ladies and gentlemen, we're now at the final panel of this conference, panel 6, and it should be an exciting session. When I was invited to moderate this panel, I was put in mind of the Legacy Conference at the ICTY that was held about 3 years ago. And I appeared as a representative of my government, as ambassador at large. And I noted at that point there had been no mention at that conference of the role that the prosecutor had in making arrests and ensuring that that year the 160th and 161st individuals, indeed all of the people sought by that tribunal, had been brought to justice. And so I began talking about that. Well, I might have revealed too much my former role as a prosecutor because as I was speaking, suddenly down the middle of the aisle came a person with a microphone who began chanting, "Où est la défense? Où est la défense? Où est la défense?" And it was my friend Francois Roux, and raising the question, indeed, that at that conference there was not a session for the prosecutor, there wasn't one for the defense either. Well, we've resolved that problem here. We've got a rich panel discussion of extremely experienced people involved in the defense and involved in the work of the tribunals to ensure equality of arms, to ensure that the processes that take place are just and equitable, and that they serve, at the end of the day, the interest of justice. The first speaker is Francois Roux, and when it comes to the Special Tribunal of Lebanon, where he now works, one does not need to ask the question, où est la défense? Where is the defense? Because the defense there is an independent organ. Indeed, has been noted in the official agenda, referring to it as the defense section is not correct. It is an independent organ, the first defense office in any of these courts, which is not part of the registry, and stands as an equal organ to the chambers and to the prosecution and to the registry.
And obviously, as we talk about evolution, not that things have moved in that direction in every tribunal or even in the ICC, in dealing with Francois Roux, we're talking about someone who's following this new model and in a court with great challenges. I know him well from negotiating plea agreements with him. I know him well. I think the day I arrived, he won the first acquittal at the ICTR in the Bagalashima case, and a great advocate as well in the extraordinary chambers in Cambodia. So it's great to see him lead off. And so, Francois, if you'll take the parole.
Merci beaucoup, Stéphane, et merci aux organisateurs de m'avoir invité et de donner ainsi la parole à la défense. Et je vais permettre un peu de repos aux interprètes français et donner un peu de travail aux interprètes en anglais. Permettez-moi au début de mon propos d'avoir une pensée pour feu le président Laïti Kama, dont tout le monde sait ici la contribution exceptionnelle qu'il a apportée à ce tribunal. Son décès avait été pour nous un choc qui n'a eu d'équivalent que le choc que nous avons ressenti au décès soudain de notre grand président, le président du tribunal spécial pour le Liban, Antonio Cassese. La seule chose qui m'apaise quand je pense à ces deux grands présidents, c'est que je me dis qu'ils sont forcément montés au paradis et qu'en arrivant là-haut, ils ont dit à Dieu, le jugement dernier, on s'en occupe, laissez-nous, on va travailler. Et je suis sûr qu'ils travaillent tous les deux. Et je pense évidemment à tous les autres amis qui ont disparu pendant ces 20 années. Permettez-moi encore de citer le bâtonnier de Kigali, Jean Agouma, qui était mon co-conseil dans un des dossiers que nous avons traités avec Stéphane, un dossier de plaidoyer de culpabilité. Voilà, je voudrais vous rappeler que quand nous sommes arrivés ici au début, la défense n'avait pas d'existence institutionnelle propre. Le président Moz l'a rappelé hier matin, la défense n'était par exemple pas présente au comité de coordination mis en place pour rationaliser les procédures. Quel manque, quel dommage, quel temps nous aurions gagné. C'est le greffe qui parlait à la place de la défense. C'est cette situation que je découvre en avril 1999, quand j'arrive pour défendre Ignace Baguilichema. En mai 2014, 15 ans plus tard, grâce au soutien du conseiller pour les affaires juridiques ici présent, Miguel de Serpa Soares, que je remercie, j'obtiens en ma qualité de chef du bureau de la défense du tribunal spécial pour le Liban une audience auprès du secrétaire général des Nations Unies. Et j'avais fait valoir, pour obtenir cette audience, que le secrétaire général avait jusque-là reçu les présidents des tribunaux internationaux, les procureurs, mais jamais la défense. Et c'est en effet le premier mot que m'a dit le secrétaire général. Je n'ai jamais entendu la défense. Maître, vous avez la parole. Entre ces deux dates, 1999-2014, une longue et lente évolution pour que la défense soit enfin reconnue institutionnellement. Merci beaucoup. Et pourtant, le procureur Goldstone avait dit très tôt
il ne peut pas y avoir de justice pénale internationale sans une défense forte. Et j'ai été très sensible à ce qu'a dit le procureur Diallo au 7e Symposium des procureurs internationaux ces derniers jours, et je l'en remercie. Sans une défense bien équipée, on ne peut pas avoir de procès équitable. Nous en sommes aujourd'hui heureusement tous convaincus. Mais à cause d'un péché originel qui était la seule mise en avant de la lutte contre l'impunité, plutôt que la lutte pour la justice, tous les regards étaient au début tournés vers l'accusation et la défense n'était que tolérée avec cette question récurrente, mais comment pouvez-vous défendre des génocidaires? Telle était la question qui nous était chaque fois posée. Hélas, il suffit de regarder la banderole qui est derrière nous pour voir que l'on n'en a pas tout à fait fini avec ce péché originel. Et je dis toujours que si la communauté internationale était bien fondée à créer ces juridictions pour mettre fin à l'impunité après des horribles tragédies, ces juridictions, une fois mises en place, ne devraient se concentrer que sur une seule tâche, rendre la justice. Ce qui veut dire que si l'on crée des postes de procureurs, dont la mission est en effet de lutter contre l'impunité, si l'on crée des postes de juges, dont la mission sera de juger, alors il faut bien des avocats pour défendre. Que serait un procès sans avocat de la défense? Et je cite souvent un confrère français, maître Jean Boudot, qui disait « Défendre, c'est ne rien accepter comme acquis qui n'ait été soumis au crible de la critique. » C'est ça le travail de la défense. Et un autre avocat, devenu ambassadeur de la France pour les droits de l'homme, a cette formule très belle. Le paradoxe des droits de l'homme, c'est qu'au début, ils sont créés pour protéger les victimes, droit à la vie, droit à l'intégrité, mais ils prennent tout leur sens dans la défense des accusés et de leur droit à un procès équitable. Voilà donc le travail indispensable de la défense, et merci à Adama Dieng de l'avoir rappelé tout à l'heure. Si nous fêtons aujourd'hui les succès, et il y en a, du tribunal pénal international pour le Rwanda, vous devez, nous devons y associer le travail de la défense. Alors donc au tribunal Liban, enfin, après un long processus que je décris dans le papier que vous trouverez, on a créé en effet un bureau de la défense comme organe. C'est-à-dire qu'on vous a présenté encore tout à l'heure et dans plusieurs panels les 3 organes du tribunal sur le Rwanda, les chambres avec la présidence, le greffier et le procureur. Où est la défense? Eh bien, au tribunal spécial pour le Liban, on a créé le 4e pilier, le bureau de la défense, et nous avons maintenant un tribunal qui marche sur 4 pattes. C'est quand même mieux, non? Alors, je ne vais pas vous présenter le bureau de la défense, je dirais seulement que beaucoup de personnes qui y travaillent sont des anciens du TPIR. Permettez-moi de citer à ceux qui les connaissent, Hélène... on peut... Non, oui. Et Hélène Uniac, qui a travaillé dans le procès Baghili-Shema, Laurent Vastelin, que vous connaissez tous, qui est mon chef de cabinet, et bien d'autres, Johan Soufi, que beaucoup d'entre vous connaissent ici, Marie-Pierre Barbeau. C'est toute une petite équipe qui est totalement dédiée au travail du Bureau de la Défense et à qui je veux publiquement rendre hommage ici. Parmi notre travail, nous interviewons les avocats, c'est une nouveauté, avant de les inscrire sur la liste, et ensuite nous leur assurons des formations, et comme nous sommes dans des procès par défaut au tribunal pour le Liban, c'est nous qui avons nommé les avocats. Et nous avons pris soin de nommer des avocats en tenant compte de la diversité des origines géographiques, culturelles, sur le plan juridique et sur le plan linguistique. Et permettez-moi, puisque je suis au TPIR, de dire combien je suis heureux d'avoir dans le Bureau de la Défense l'un des plus anciens avocats du TPIR, maître Mohamed Aouini, de Tunisie, qui fut un des tout premiers avocats, et notamment dans le procès Roudiou, ici au TPIR. Voilà. Parmi ce que je fais dans le cadre de mes fonctions, je me rends très souvent au Liban pour rencontrer les barreaux d'avocats et aussi les plus hautes autorités politiques. Alors, avant de conclure, c'est aux victimes que je veux passer la parole. En effet, quand j'ai été nommé pour la première fois à ce poste, je suis allé au Liban, c'était en 2009. J'ai rencontré le Premier ministre, qui était à l'époque le fils du Premier ministre Rafik Hariri, dont l'assassinat est à l'origine de la création de notre tribunal. J'ai expliqué le rôle du Bureau de la Défense au Premier ministre Saad Hariri et le travail que ferait la Défense, notamment des enquêtes au Liban, ce qui est nouveau pour un pays qui, lui, a des juges d'instruction. Après m'avoir écouté, Monsieur le Premier ministre m'a dit « Maître Roux, en tant que victime, j'apprécie le travail du Bureau de la Défense car il donne de la crédibilité à ce tribunal et c'est important pour les victimes et pour l'ensemble des Libanais. Y a-t-il meilleure définition du rôle du Bureau de la Défense et à travers lui de la Défense? Ainsi, je dirais, paradoxalement, l'héritage du TPIR en matière de défense aura été de montrer qu'il fallait d'urgence corriger les manques cruels du début des tribunaux pénaux internationaux dans ce domaine. Je vous remercie.
Well, thank you very much for those great remarks. Now on the program, we turn to Chief Taku, who has represented multiple accused at the ICTR, also represented victims at the ICC, I believe, and recently, putting in mind the participation in these last days of Andras Ramos Goldman of Justice Rapid Response. He recently participated in training in Washington that we conducted and is now a deployable expert of Justice Rapid Response. So don't presume that the people that are being deployed are all prosecutors or prosecution investigators or judicial police. Chief Taku may be coming to a site near you, but let's hear from him now. There we are.
Thank you so much, Ambassador Raab. And, surely we're together in Sierra Leone, and I was defending the Revolutionary United Front of Sierra Leone. You were prosecuting. And I also thank Mr. Jallo. The relationship was very professional. My registrar here is here, Binta Mansouri, Mr. Dieng, the current registrar of the court. That said, let me quickly, not to waste my time, get to my paper, my script. But you are all aware that the defense had organized 3 legacy conferences on the perspective of the defense in this tribunal in Montreal, in collaboration with the Laval University, also in The Hague and in Brussels. I'm in contact with most of my friends, and they instructed me to raise certain issues which they consider very, very crucial, not only for this court, but also for the ICC and also other international criminal tribunals. The preamble of the United Nations Charter establishes conditions, and I quote, which justice and respect for the obligations arising from treaties and other sources of international law can be maintained for, again, quote, promoting social progress and better standards of life in larger freedom. To underscore this commitment, Article 1 of the United Nations Charter specifies that collective peaceful measures required for the prevention and removal of threat to peace, the maintenance of international peace and security should conform to, quote, the principle of justice and international law. The right to defense and legal assistance of choice before competent, independent, and impartial tribunals established by law constitute one of the minimum guarantees afforded by the UN system, multilateral and bilateral treaties for the attainment of this goal. The trials that were organized after World War II were a major test of the collective resolve of the civilized world to attain this goal. Was this goal attained? If it did, why then is the recognition of the defense as an independent organ of international tribunals and courts still elusive almost 75 years after this stated goal? The main function of criminal trials is to establish the guilt or innocence of accused persons through faith processes. According to Professor Genia Ayushita Tunia in the Virginia Journal of International Law, even the innumerable proceedings were expected to comply with notions of fairness and individual criminal responsibility. However, the tribunals established for that purpose, like all other tribunals, and this includes the ICTR, whose legacy we are celebrating, had a mandate to establish enduring standards for future trials. It is in so doing that these tribunals could validly be said to present clear alternatives to international criminality, impunity, and the scourge of war that threaten and still threatens humanity, jeopardizing our common destiny. To fulfill this purpose, the tribunals had legitimately to be seen as platforms of fairness, independence, and equality from which to assert and proclaim the primacy of the rule of law over impunity and international criminality. Fairness, independence, and equality in this context required institutional independence of judges, the registry, the prosecutor, and the defense. The intendment of Article 1 of the UN Charter is discernible in Article 14 of the International Covenant on Civil and Political Rights, 1966, which laid down the minimum standards for the guarantee of fair trials. The Security Council, through this remarkable recognition of the defense as an independent organ, together with the government of Lebanon in establishing the Tribunal of Lebanon, led by example in the fulfillment of this pledge, and indisputably set the standard for all international court and tribunals to follow. The statute of the ICTR, Article 20, ICTY, Article 21, Special Court of Sierra Leone, Article 17, ICC, Article 67, East Timor Regulation 2000/3, as amended, recognize the minimum fair trial guarantees afforded accused persons under Article 14 of the International Covenant for Civil and Political Rights, but not the institutional independence of the defense for the effective enforcement of these rights. This omission does not accord with the principles of justice and international law enshrined in Article 1 and the preamble of the U.S. Charter and the minimum fair trial guarantees contained in the respective statutes. Okay, sorry. The evolution of the defense, yes. The evolution of the defense cannot be separated from the implementation of all fair trial guarantees to an accused under these provisions which I've cited. It is desirable that a criminal trial process for a criminal trial process to be fair and seen to be fair, establish values that serve the interests of humanity must be promoted and protected. To attain this goal, the principal participants in the trial process, and the defense is one, must be accorded equal recognition, independence, and equal institutional status within which to function. The evolution of the defense from Nuremberg to the Special Court for Sierra Leone has been remarkable in some respects. Robert Gatley, in his introduction to the Nuremberg interviews by Leon Godison, states that the main proceedings containing prosecution and defense presentations lasted over 9 months, and that there were 4 judges, 4 prosecutors who alternate, each with a team of his own, all drawn from the victorious powers, the United States, Great Britain, Soviet Union, along with France. The defense at Nuremberg was only recognized for its participation and presentation during the trials and not for its institutional independence, relevance, and the resources provided for an effective defense. Despite the paucity of resources and the lack of recognition as an independent organ of the tribunal, the defense team managed to secure 3 significant acquittals, an impressive result in such circumstances. Administrative and supervisory role of the registrar. Lacking institutional recognition, the administration of the defense, international criminal tribunals, and court is placed under the authority of the registrars of the respective courts. In defining the function of the registrar in the statute, nothing is mentioned about the functions with regard to administration of the defense. However, the rules of procedure and evidence of international criminal tribunals give the registrar the power to assign counsel, appoint counsel, misconduct of counsel, appointment of duty counsel, and the directives regulate the activity of counsel, roster of competent counsel. The registrars of different courts and tribunals have been fairly successful in attracting pools of very competent and professional lawyers from the major legal traditions of the world. Inadequate resources. One of the most significant factors inhibiting the independence and effectiveness of the defense is lack of resources, despite the fair guarantees enshrined in the statutes. The ICTY appeal chambers in the Tadic case held that equality of arms does not per se mean equality of resources. However, the issue was not about the question of resources as such, but institutional independence for the defense. Security of counsel. Despite the protections and functional immunity provided lawyers in the performance of their duties, provided by the basic principles on the role of lawyers adopted by the 8th United Nations Congress on the Prevention of Crime and Treatment of Offenders, Havana, Cuba, 27 August to 7 September 1960. 1990, Defense Counsel at some international tribunals, including this, were humiliated, arrested. However, in the case of the ICTR, and thanks to Mr. Adama Dieng and the judges of this court, measures were taken to release these lawyers and to explain to the authorities of these countries that the material available to the lawyers as a result of the performance of their mandate before the court was protected, it was privileged and should be protected, and that the lawyers enjoyed functional immunity when they appear before the court. At the at the Special Court of Sierra Leone, the correspondence, the sessions, the preparatory session of Mr. Charles Taylor were being monitored in the detention center in The Hague, and the president of this Special Court of Sierra Leone, along with the registrar, took remedial actions and put that practice to an end. One of the legacies and the greater legacy that we celebrate about the SCRO is the lump sum system of payment, in which it will be recommended that other tribunals should copy this method, because lawyers were widely consulted and before that system was put in place. Now, before I conclude, let me say that at the time that we were hoping that the president, the wise decision, the celebrated decision by the Security Council of the government of Lebanon should be emulated for all tribunals, I regret that the ICC registrar has put in motion a process by which he intends completely to take back the limited right that the defense enjoyed before that court. And indeed, it is surprising because the amendment of the rules can only be done by the judges. But in this particular case, as I speak, the registrar is trying to put in place an amendment that completely threw the defense out of the process. The limited rights that were granted by the judges in the rules of the ICC, that process, I regret, if it is implemented, it is going to create a lot of chaos. And he sent out a questionnaire, and only 15 lawyers have responded, and all of them protesting. And we're thinking about summoning an urgent meeting of lawyers in order to make representations to the judges, in order to put an end to that attempt. Thanks.
Thank you very much, Chief Taku. Our next speaker represents the Defense Office, heads the Defense Office in the first international permanent court, the International Criminal Court, Xavier Jean Keita, who's here, and his formal title is Principal Consul of the Office of Public Counsel for the Defense, and a challenging job in a new tribunal. I know engaged with it when one of its attorneys, Ms. Taylor, was taken prisoner, detained illegally in Libya, together with 3 other ICC employees in June of 2012, and went there with our ambassador, Chris Stevens, late ambassador, and other diplomatic representatives and representatives of the ICC, and was happy after a horrible period of detention that they were freed. But working for the defense and working within a defense office can be a challenging job. And so I yield to him to describe how this is developing at the ICC and meeting the challenges ahead. Thank you.
Thank you, Mr. Ambassador, for the sweet words. I will switch in French for the balance. And my original text is in English, so you will get it by the organizers. Monsieur le ministre de la Justice du Mali, messieurs les sous-secrétaires des Nations Unies, secrétaires généraux des Nations Unies, honorables juges, magistrats, ambassadeurs, chers collègues, confrères, interprètes, chers partenaires de justice. Je voudrais vous raconter quelques petites histoires. C'est par les petites histoires que nous avons grandi. Et il y a toujours un enfant qui sommeille en nous. Après tout, ce sont les enfants qui héritent. Et on parle d'héritage aujourd'hui, de legacy. Merci François pour les mots que tu as prononcés à propos de l'ITKMA. C'est mon fils qui a hérité. La dernière fois que j'ai vu l'ITKMA, c'était il y a plus de 24 ans. Je venais de lui annoncer, parce que j'avais plaidé la première affaire d'assises devant lui, j'avais prêté serment juste un mois avant, c'était en février 85, il y a 30 ans. Il m'avait traumatisé, j'avais résisté, il m'avait félicité, et c'était un de mes mentors. Donc la dernière fois que je l'ai vu, nous avons pleuré ensemble, et à l'africaine, je venais de lui annoncer que mon fils, unique fils, j'ai 2 autres filles, s'appellent Laïti Hussein Keïta, portant le nom de Laïti. Et donc nous avons pleuré ensemble. Donc voilà une part d'héritage qui vient d'ICTR, pardon, et du Sénégal aussi. En Bambara, en Malinké, Donkadjan, à Sébalité. Ça veut dire que le jour a beau être loin, ça ne l'empêchera pas d'arriver. Et on peut dire ça pour la défense et rester optimiste malgré le tableau un peu sombre que je m'apprête à tracer. Et au titre évolution des bureaux de la défense, j'ai rajouté celui de révolution. Parce que quand on évolue, on a tendance à monter et à progresser. Et quand on retourne en arrière, on peut dire mais on fait un tour en arrière, donc c'est une forme de révolution. Pourquoi la défense, si nécessaire, indispensable pour rendre la justice, est-elle toujours le parent pauvre, le mal-aimé, en particulier au niveau international? Comment on peut nous confondre avec nos clients qu'on appelle criminels, alors que vous, comme moi, nous avons la présomption d'innocence jusqu'à ce que nous soyons, un jour peut-être, définitivement condamnés. Question de culture? Peut-être. Force est de constater que la défense n'est pas tellement sexy. De Nuremberg à Tokyo, en passant par les tribunaux ad hoc, à l'heure des mécanismes résiduels, l'heure du bilan a sonné. Quel héritage, côté défense, nous offre 20 années de tribunal spécial pour le Rwanda? Force est encore de constater, et peut-être de regretter, que nous n'avons pas encore tiré toutes les leçons riches de nos précédents et prestigieux devanciers. Nous n'avons pas encore réussi à hériter. L'héritage des tribunaux ad hoc, experts, diplomates, politiciens ont tous réfléchi avec la société civile pour chercher les meilleures formules pour mettre en place les meilleurs moyens d'assister les suspects et les accusés. Mais pour les bureaux du procureur, il n'y a jamais eu besoin de réflexion et d'experts. Le bureau du procureur doit toujours être à l'intérieur de la juridiction. Donc ça, c'est un fait établi. Tokyo et Nuremberg, la défense ne fut pas vraiment gâtée. Bien que les droits des accusés étaient textuellement établis, le procès équitable n'était qu'un objectif, bien garni par une série de droits qui, en pratique, pouvaient prêter à sourire au sein des audiences. Heureusement, ICTR, ICTY, Special Code pour Sierra Leone, s'inspirant du Pacte international sur les droits civils et politiques, doteront la défense de privilèges, de principes désormais inscrits dans le marbre. Ils ont pour nom, parce qu'ils sont indispensables au procès équitable. Égalité des personnes comparaissant, droit à un procès équitable et public, présomption d'innocence, droit d'être informé promptement des charges qui pèsent contre nous, le temps suffisant et des moyens et des conditions adéquates pour préparer sa défense, le libre choix de son conseil et le droit de librement communiquer avec ce dernier, le droit d'être jugé sans retard indu, l'aide juridictionnelle pour les indigents, le droit de contester les preuves par contre-examen, la libre assistance d'un interprète, le droit au silence sans qu'il puisse nous être opposé, la Convention européenne des droits de l'homme et le pacte international pour les droits civils et politiques à les convoler en justes noces et donner naissance à l'égalité des armes. Ce magnifique bébé que tout le monde admire, cajole, embrasse, mais que personne ne souhaite héberger dans la semaine, même pas le week-end. Le procureur contre Tadic sera le parrain en phase d'appel, 15 juin 1999. Les oncles protecteurs seront le procureur contre Kaishema et Ruzindana. Égalité des armes comme composante essentielle du procès. Nous sommes en juin 2001. L'adolescence fut turbulente, celle d'un enfant tantôt hébergé, tantôt juste accueilli, nourri, toujours étranger, comme un enfant non désiré. ICTR, ICTY consacreront les chambres, le bureau du procureur et le greffe comme des organes, mais la défense restera un peu à l'extérieur, toujours hébergée, un peu SDF. Alors il faudra attendre l'âge adulte, comme un jeune adolescent, sans moyens, sans bourse, sans argent de poche. Voilà 2005 qui arrive, Special Court for Sierra Leone, arrivée du Principal Defender, mais on y est, le 4e pilier. Non, 4e pilier. La majorité, pas encore. C'est pas encore le temps d'être un organe. Le grand espoir arrive. La création de la CPI, je vous l'ai dit, Don Kadjan, à Sébalité, le jour est loin. Il arrive à la CPI, première juridiction permanente, créée sui generis, il nous fallait les plus hauts standards, nous les avons pour le procès équitable. Mais comme un enfant, comme un adulte qui voyage pour la première fois, la défense a raté le train du statut de Rome. Heureusement, les juges veillent au grain. Nous arriverons à bon port par le règlement de la Cour qui créera le bureau du Conseil public pour la défense. Ce bureau du Conseil public pour la défense que j'ai l'honneur de diriger depuis bientôt 8 ans est pleinement indépendant au sein du greffe, à l'ombre du greffe, relié comme un cordon ombilical par ce qu'on a de plus cher, le budget et peut-être les missions. Mais les équipes sont là pour vous dire que nous faisons ensemble un travail extraordinaire. Et là, l'égalité des armes, la présomption d'innocence, nous pouvons dire que nous avons réussi sur ce plan-là. Alors, l'enfant ne deviendra majeur réellement qu'avec le tribunal spécial pour le Liban, et François vous en a parlé, et grâce aux œuvres combinées de Kofi Annan et du président KCC, feu le président KCC, enfin, voilà une juridiction qui dote la défense d'un modèle digne de son nom. Je terminerai en disant, avant qu'on ne me menace des 2 minutes restantes, qu'il y a 2 jours, le père fondateur, Lord Fulford, le père fondateur de ces enfants, a commis un article dans le Guardian. Il s'inquiète de ce qu'il arrive, non pas à ces 2 enfants, les bureaux des victimes ou le bureau de la défense, il s'inquiète pour ce que deviendra la crédibilité de la Cour pénale internationale si par extraordinaire on osait toucher à ces belles créations. Alors, dans sa sagesse, dans leur sagesse, les juges avaient déjà réformé le bureau et les dernières réformes sont entrées en vigueur le 29 juin 2012. Alors pourquoi réformer? Pourquoi réformer encore? Surtout quand on veut marier de force un bureau qui s'occupe de logistique avec notre bureau qui partage avec la défense confidentialité, secret professionnel, la même éthique. mais ce mariage ne tiendra jamais. La défense, les équipes de défense ne nous feront plus confiance. Et il n'y a aucun motif réel pour une quelconque économie. Non, l'héritage est balancé. Quand je regarde cette juridiction qui fête ses 20 ans, elle est pour moi comme un arbre. Nous sommes une partie des racines et qui fondent ce que la justice a de plus essentiel. Si un jour cet enfant devenu adulte, qui s'appelle la défense, qui s'appelle l'égalité des armes, frappe à votre porte, ouvrez, donnez-lui à manger, mais élevez-le au rang le plus haut, celui qui fait de notre héritage commun notre seul patrimoine qui fonde une justice dont nous serons tous fiers. Donc, Adjan, à Sébalité.
Thank you, Maître. We now go to the discussants, and obviously I think everyone could have had equal time, but it's the way the program works. We have great representatives of defense offices and the defense of cases before international tribunals among the group. And the first is Pascal Besnier, who was actually acting registrar of the ICTR for a period of time after Dama Dieng went to the position in New York and served as head of the defense counsel and detention section and in other positions here, now dealing with judicial and legal affairs. So, and before that had been a defense counsel in the cases in the ICTR. So let's turn to Pascal Besnier.
Merci beaucoup. Ça va être assez difficile de discuter de ce qui vient d'être dit, parce que je suis d'accord avec toutes les déclarations qui ont été faites jusqu'à présent, et que je peux difficilement les réfuter. C'est vrai que, comme le dit François Roux, l'indépendance des bureaux de la défense, c'est une évolution très positive. Et il est vrai aussi qu'en 1996 ou 1997, la défense et la justice internationale a perdu du temps parce qu'elle n'était pas associée aux décisions managériales, pardon François, aux décisions administratives qui étaient prises par le tribunal. Mais je crois qu'il y a une raison pour ça à l'époque. C'est qu'on s'attendait que les accusés payent leurs avocats, tout simplement, comme partout et comme toujours. On s'attendait à ce que les accusés qui étaient d'anciens ministres ou des hommes de pouvoir au Rwanda puissent dans leur poche pour payer eux-mêmes les avocats et faire leur propre affaire de leur propre défense. Et donc plus besoin d'associer les avocats, de mettre en place un système d'aide judiciaire qui allait être onéreux et compliqué, parce que ça a été une surprise pour les Nations Unies d'observer que tous ces gens qui étaient mis en accusation étaient tous indigents. Ensuite, l'autre raison, c'est qu'on s'attendait à des procès beaucoup plus rapides qu'ils n'étaient. En 1996, 97 ou même en 99, François, on n'aurait jamais pensé qu'on se retrouverait ici pour fêter le 20e anniversaire du TPIR. C'était absolument impossible à imaginer. On pouvait même s'attendre que, comme le disait le président Meron ce matin à propos de Nuremberg, on juge les gens de la même manière qu'on les a jugés à Nuremberg. C'est-à-dire que tout le monde se retrouvait derrière une vitre blindée et était jugé en même temps. D'ailleurs, à l'époque, en 1996 et 1997, il n'y avait qu'un seul système de défense. Et d'ailleurs, il n'y avait même qu'un seul avocat. L'histoire du TPIR, c'est d'abord l'histoire d'un seul avocat qui avait tous les mandats de représentation de tous les accusés et qui ne voulait parler que d'un seul système de défense, qui était celui de la négation du génocide. Voilà comment l'affaire a commencé du point de vue de la défense. Et ce sont les clients de cet avocat qui, en réfléchissant, se sont aperçus qu'ils avaient une meilleure carte à jouer en se défendant sur le plan individuel. Comme quoi, c'est souvent le client qui conseille l'avocat, ou qui est de meilleurs conseils. Alors, il faut se réjouir que cette évolution soit si positive. que l'indépendance des cabinets, l'indépendance des systèmes de défense soit maintenant établie et reconnue par le secrétaire général des Nations Unies. Il faut se réjouir qu'on soit passé d'un système compliqué de paiement des avocats à l'acte vers un système de lump sum system, de forfait. Et je crois que cette évolution, elle va se poursuivre grâce à la CPI et grâce aux tribunaux qui vont continuer à exister après le TPIR. Des erreurs, bien sûr, ont été commises, mais comme le disait le grand Oscar Wilde, l'expérience, c'est le nom que nous donnons à nos erreurs. Voilà, donc bon anniversaire TPIR et longue vie aux autres tribunaux internationaux et longue vie à la défense. Merci.
Thank you very much, Pascal. Let's turn to Karim Khan, who presently representing the Deputy President Ruto in the ICC. I remember him well from his representation in the first part of let's see, we've got you hiding there. Charles, when he represented Charles Taylor, remember well June 4th, 2007, where we began with him in the courtroom and ended with him outside the courtroom, and Charles Jallow representing the defense for the presentation of our opening argument and the prosecution of Charles Taylor, Charles Jallow, our friend who represented the office of the principal defender at the Special Court for Sierra Leone. But we have great respect for Karim Khan and his work, and he's also an individual that previously served in the office of the prosecutor at the ICTY and is an experienced member of the bar of England and Wales. So Karim, you have the floor.
Ambassador Rapp, today I know which doors are open if I do leave. It is a great pleasure to be here. I think in 5 minutes, I will not be saying anything profound. Maybe they realized even if I was given 50 minutes, there wouldn't be much chance of that. So I'll just give a few random thoughts in relation to the topic under discussion. My own view is, when looking at the evolution of defense systems, an historical narrative can be given to look at the differences between the ICTY and ICTR, the Defense Office in the Special Panels for Serious Crimes in Timor, the OPD in the Special Court for Sierra Leone, or OPCD in the ICC. But it doesn't, in my view, take us too far. It's informative. I'm really not doctrinal by nature, and in looking at structures, the key for me really is delivery of results. A discussion about which structure is better may take us as far as whether or not the common law system is better than the civil law system, or vice versa. I think in looking at the evolution of defense systems, one needs to look away from just the pure structure and try to glean certain important imperatives, certain preconditions, which are fundamentals if the rights of the defense are to be given voice. And in looking at the landscape of the different hybrid international and internationalized courts, there are, of course, many differences. I must say that all the various systems that I've worked in have their advantages and their disadvantages. The ICTY and ICTR really is the paradigm example in many respects of leave the defense alone, an independent defense counsel that will be responsible, according to the Code of Professional Conduct for Counsel, to properly and ethically represent an accused. With the OLAD and the equivalent in the ICTR, financing those duties of the defense. Now, there's a lot of merit in that system, in fact. It's worked quite well. It's got a massive disadvantage, of course, which is the disadvantage that my friends Francois Roux and Keita have touched upon, that whilst the defense can work and focus on the job of looking at the evidence, the charges that a client faces, and trying to push forward defense investigations and pleadings in court, the defense does maintain, inevitably, an adopted child in the court itself, because there's no institutional voice, really, of the defense, at least not in the early days before the ADC, ICTY, was created. But even then, the role of the Association of Defense Counsel of the ICTY perhaps is not as effective as the Defense Office for the Special Tribunal for Lebanon, because it makes a huge difference in reality to have defense views, defense difficulties actually, understood by the key decision makers, the President of the Court, the Registrar of the Court. Because very often it's very easy for defense to say, well, the institution is against us, and it's almost a form of paranoia. And very often defense do say that we get the short end of the stick. But very often when we do, it's not because of malafides, it's not because of any ulterior motive that's nefarious. It's because the interests of the defense, the difficulties of the defense on everyday levels haven't been properly ventilated and put to the table of the decision maker. The role of the registrar becomes exceptionally powerful, and when the main conduit of information is a registrar to the President of the Court, to a management committee, to an assembly of state parties, of course a gloss can be put on the impact upon certain decisions on the defense that may or may not hold true. So I think there is scope for a variety of different systems. I was really one of the very few lucky ones that worked as an independent defense counsel in East Timor. Now, in East Timor, they did have eventually effectively a public defender system. And there was a very brilliant young Zimbabwean lawyer, Symposium Malunga, that headed it up and really did fantastic work with other individuals paid for effectively by the United Nations. But really, I think that system worked pretty well in that environment. It may have been difficult without that system to get defense counsel from all over the world coming in for small little cases. There were not massive cases that take 1 year, 1.5 years. So actually that system had a lot of merit. The ICTY system as well. Now, Kate has touched upon something quite important, which was the vision that led to the judges of the ICC deciding that there should be an Office of the Public Counsel for Defense and its compatriot OPCV. Now, that is really under jeopardy. That is in jeopardy as we speak. It's subject to a revision project which runs the risks of diluting effectively in important particulars the role of an independent OPCD. And the most important characteristic of the OPCD, founded by the judges of the ICC, was that functionally, administratively, of course, it's part of the registry, but functionally, it would independently represent the interests of the defense. And that, of course, is important in a system when very often in the real world, the defense is confronted as fait accompli by a registry OTP protocol on witness protection without consultation with the defense and without a similar paper in place. So the more the defense can be brought in, I think the better the quality of justice. When it comes to the STL, I think Francois, of course, has done a fantastic job. One notes immediately, even when you enter the building, the defense is on the top floor, on the 7th floor, and you think, wow, something's automatically very, very different. The facilities, of course, are very good. And from my small experience in the STL, it does seem that the resources, the facilities are really a step forward from that we have in other courts. Now, whether or not that is purely because of the structure of the Defence Office, or whether also it's a function of the court itself and the caseload it has, is a matter that can be discussed. But certainly, having the head of the Defence Office, having equivalent standing to the prosecutor of the court, and being a member of the senior management committee to be involved in all key decisions of the court can only be a good thing. And I think that is something that really is one of the core aspects. It's to make sure, not just for the appearance, but in discussions that the voice of the defense is heard. I'm not somebody personally that thinks a defense association of counsel in private practice creating by themselves, voted, is necessarily the best way forward. Because, and this is something Judge Fulford mentioned in his speech on the 29th of October, the Sir Richard May Memorial Lecture in London, that very often, unfortunately, associations can become cliques, they can become clubs, in which people involved put up a wall to keep others out. And I think that needs to be, one needs to be alive to that and try to make the defense bar as inclusive as possible. And in reality, that means eschewing dogma and eschewing any one type of approach. And what Lord Justice Adrian Fulford put forward in his vision in the OPCD was effectively a menu option that in some cases, for example, a small, perhaps a legally aided case or in another case, OPCD counsel could represent an accused if the accused wanted it. In other cases, of course, it would be open to an accused or a suspect to engage private counsel. And in a third option, and in fact that is a lot to commend it, it may well be the case that an accused would want to mix and match. He'd have a counsel of his or her own choice, but working in a very collaborative way. Sorry. Very polite.
Assertive on that question. You're very interesting, but I think we're going to have to wrap it up in maybe 30 seconds. So we'll yield you that much.
So I think there's progress that's been made. I think as far as the legacy of the ICTR is concerned, it's not only by the number of acquittals. It's by the fact that today, for example, as Ambassador Rapp has mentioned, the defense has an opportunity to give whatever thoughts it can put. And certainly on the international landscape, the rule of law of international justice is very much established, and that is in part of all players in the court proceedings. Thank you.
Thank you very much. Thank you, Karim. And last but not least is Isaac Andele, who's chief of the Defense Support Section of the ECCC. We've heard a fair amount about the ECCC during these meetings. This is a challenging job, I know, at the moment, because two of the accused and their attorneys are refusing to come to court in case 2-2 until there's a ruling on the disqualification of the judges, and we also have the cases 3 and 4 where the suspects are publicly undisclosed, but they're in position now to have legal counsel and the process of concluding that investigation and obtaining their cooperation in efforts to ensure that evidence, as they say, evidence prove à décharge, exculpatory evidence is found by the co-investigating judges is challenging as well. So I'd like to turn to Isaac for his remarks.
With your permission, sir, I'd like to stand up for the defense. Thank you, Ambassador Rapp. Distinguished delegates, former colleagues, dear friends, it's good to be back here again. It's good to see all these lovely faces. In the course of the last 2 days, we've heard a lot about the evolution of the international justice system, the criminal justice system. But one thing certainly hasn't changed. The defense is still last. You can tell by the positioning of this panel, it's placed last. That's the way the defense has always been viewed.
I always want to speak last, Isaac.
We're hoping that as the system evolves, there will be greater consideration given to defense issues in the future. I'd like to talk to you today about the extraordinary chambers in the courts of Cambodia. I think Mr. Sire Ali Ba, in his excellent expose yesterday and in answer to a few questions this morning, presented a very, very accurate picture of the court. So instead of going into those details, I'll focus on the defense issues and perhaps highlight some of the differences, the key differences between the ICTR defense system and the ECCC defense system. First of all, I should point out right away that the ECCC is not an international court. It is a Cambodian court. It's a court within the system, the Cambodian court system. The name, the Extraordinary Chambers in the Courts of Cambodia, says that very clearly. The difference, though, is that the court was set up with strong participation from the United Nations. So the UN provides technical assistance, and for that purpose, the United Nations has set up the United Nations Assistance to the Khmer Rouge Trials, UNACART. That's the name of the mission that represents the United Nations in Cambodia. As part of the undertaking, the United Nations agreed with the government of Cambodia to bring to trial senior leaders of the former Khmer Rouge regime and those most responsible for crimes that were committed in Cambodia during the period from April of 1975 to January of 1979. So that's almost 4 years ago that these crimes allegedly occurred. Now, as part of the UN's contribution to the courts, it provides personnel. Mr. Barr told us yesterday and today that all the substantive bodies are composed of national and international staff. You have, first of all, the Office of the Co-Prosecutors. There is one national prosecutor and one international co-prosecutor. And we have here, indeed, my colleague Vincent, who represents the Office of the Co-Prosecutors. Then there is also the Co-Investigating Judge's Office, one national, one international. Similarly, there's a pre-trial chamber made up of 5 judges, 3 national, 2 international. There's also a trial chamber of 5 judges, 3 national, 2 international. And finally, the highest body, the appellate body, the Supreme Court chamber, is made up of 7 judges, 4 national, 3 international. In all of these judicial bodies, there has to be a decision by consensus, but if that is not possible, then they go to a vote. And the system is what's called a supermajority that's required. An affirmative vote of 4 out of 5 judges in the trial chamber or the pre-trial chamber, or an affirmative vote of 5 out of the 7 judges of the Supreme Court chamber. There is no registry at the ECCC. Instead, there is an Office of Administration. The office is headed by a director who is a Cambodian national and a deputy director who's a UN staff. The big difference there is that the defense office alone is the one that doesn't have this duality. The entire defense budget is provided by the United Nations. I'd just like to talk to you briefly about the legal basis of the defense office. First of all, in the agreement between the UN and the government of Cambodia, in Article 13, the texts of the International Covenant on Civil and Political Rights are integrated. All those fundamental rights that we have in all major tribunals are integrated in that. Article 17 does say very clearly that the UN shall be responsible for the defense budget. So the UN is responsible for paying all the defense lawyers' costs. The defense lawyers are given immunity from prosecution, from arrest, from seizure of personal baggage, from search of their personal work product. They cannot be prosecuted for things that they say or do as part of their job. Another important legal basis is the law on the establishment of the court. It's the equivalent of the ICTR statute, for example. That law goes on to describe some of the functions that the defense lawyers have. It also guarantees their immunity. Finally, there is the internal rules of the court, which is similar to the rules of procedure here. Just to conclude, I'll tell you a little bit about the composition of defense teams. Each defendant at the court is entitled to have one Cambodian lawyer and one foreign co-lawyer. They work in harmony to represent the interests of the defense. They also are entitled to have support staff, legal assistants, consultants, case managers, and so on, who assist them in monitoring developments in the case. We have a unique situation in Cambodia where we have a number of people who have not been charged, they've not been indicted, they're still suspects under investigation, but we've assigned counsel to them to represent their interests, and the UN is paying for that as well. As Ambassador Rapp mentioned, there has been a lot of talk lately about defense issues, and perhaps later on I'll get a chance to clarify, but I would just like to leave you with one clarification here. I don't think it is accurate to say that the defense are boycotting the proceedings. It's not the defense that are boycotting, but maybe I'll get a chance to clarify that later if the opportunity comes on. Do I have one more minute? Thanks. 1 minute, thank you. Now, in terms of outreach that was mentioned earlier today, we have had some problems with our relations with the public. The ECC is different from the other courts because the trials are taking place right there in Cambodia. The alleged victims, witnesses are able to participate. I even saw one of our civil party lawyers here earlier today. The civil parties do sit in court alongside the prosecutor, and they are like a second panel of prosecutors, so the defense are really, really seriously challenged in that sense. But also when we go out to the public, people ask me, why do you spend all this money paying for genocidaires, for people who committed murder? The simple question I ask them back is this: if you were accused of all these serious crimes, wouldn't you like to have the opportunity to defend yourself? And they all say, yeah, we would. And that's the issue. But some of our defense counsel, I think Ms. Taru may have a personal example to give. They have serious security concerns when they go out into the public because they're perceived as representing those who may or may not have killed their family. So there are big problems for the defense, but it's not as easy or as glamorous as it looks, but we're doing our best. I'll stop here for now. Thank you.
Well, thank you very much, Isaac, and an extremely important point because we know the challenges in many of these settings in distinguishing the client who's been accused of serious crimes and the attorney, the defense counsel who's in there to see that the law is followed and that innocence does not suffer, and that the prosecution is required to prove its case beyond a reasonable doubt. I know in some settings, I'm recently dealing in Bangladesh, and people become very angry at these accused and blame their defense attorneys, almost as if to say some crimes are so serious that innocence isn't a defense. And so it takes a lot of work constantly, I think, by all of us to remind everyone that it's fundamental, as it would be to any of ourselves or our families, that individuals are presumed innocent and are entitled to the most vigorous and zealous defense within the bounds of the law. And without that, there's no justice. And without that, the legacy of these tribunals is not one that will stand the test of time. I did want to exercise the privilege of the moderator, and I don't intend to ask a leading or unfriendly question of my colleagues here, but taking up on Karim Khan's point about looking for what kind of systems deliver the best results. And certainly the best result is the most effective defense in court for each of these accused persons. I just wanted to note, and I know because of the limitation of resources, there's always going to be challenges and conflicts, and one can often be concerned that the amount budgeted for these for defense and for indigent persons, which are the vast majority of people in these that are accused in these cases, is insufficient. But I know in the prosecution at the ICTR and then at the Special Court for Sierra Leone, and having a lot of friendly social relations and discussions with defense teams, defense lawyers in the evening who were my colleagues and the equals, in my view, of anybody in the prosecution, was that they often related their own difficulties with the regulation by defense offices, that missions were denied, that they weren't being paid for things that they needed to be paid for, and sometimes expressed anger. And I remember at the Special Court for Sierra Leone, where we had a more independent office, a principal defender, one particular attorney who remained nameless, no one represented here, would say, why don't they just close that office and take those resources and spread those out between the defense teams, and we could do more in court. And so one has that challenge in terms of establishing these offices and putting resources into them, is how do you avoid that conflict? How do you have a win-win with defense counsel? And I know from dealing with Francois Roux in his office that he's found particular solutions. But how do we overcome that and make sure that the resources that are available to the defense are spent in a way that will assure the most effective advocacy for these clients in court? You who want to respond, go ahead.
Plutôt que de répondre moi-même, je vous renvoie à une analyse très intéressante que vous trouverez sur le site du tribunal spécial pour le Liban. C'est le commentaire fait par le président Kassezé du règlement de procédure et de preuve. Et vous verrez qu'il indique au paragraphe 3 et 4, je les connais un peu par cœur, qu'on aurait pu faire un progrès à la procédure en mariant les deux systèmes de civil law et de common law et en prenant le meilleur dans chacun des deux systèmes. C'est un texte très intéressant que je vous recommande parce qu'il y a là toute la philosophie des progrès que, j'allais dire, que nous sommes condamnés à faire à la justice pénale internationale de demain. C'est le défi majeur qui est devant nous, notamment pour la Cour pénale internationale pour les années qui viennent. Nous devons améliorer les procédures pour qu'elles prennent moins de temps, qu'elles soient plus efficaces et donc moins coûteuses. Voilà ma réponse pour l'instant.
Tucker?
Let me say something quickly about what you said about the Special Court for Sierra Leone. The Office of the Public Defender was an improvement on most of the systems at the time because it was difficult getting to Sierra Leone. Most of the time, if we were not in the court or counsel was not present for any reason, the proceedings continued because these professional lawyers were always there to assist the court, to help counsel, and also to get immigration facilities. It was fairly independent, as you know. We had those problems, there's no doubt, but I think it was fairly effective. And the registrar had very little intervention, only intervened in the case that there was an appeal or some special design. I think the Special Court of Sierra Leone, I can say, was very, very effective. Back here in the ICTR, I can also say the registrar, in the lump sum system I talk about, got the input from all the lawyers. In fact, we worked together on that. I think it was a major improvement. We held a meeting at the ICC where the registry staff came there to explain exactly what happened, and all the tribunals that were present, all the lawyers present said that was a major improvement. It was one of the greatest legacies that the ICTR has brought into international criminal justice in regard to the right of the defense. Yes, it's true, to get lawyers from different legal traditions over the world into the same proceedings in the particular court is not very easy, but I think with some from independence, having someone, some office that will deal with defense issues, especially with matters of confidentiality, as you said. We take them very, very, very serious. Matters of security, somebody, also matter of policy, somebody who can be there to bring a defense perspective to the rules, amendment of the rules, to get the defense involved in that conversation for the improvement of international criminal justice. I think that is the best contribution we can have, the lawyers can bring on board.
Anybody else want to respond to that?
Well, I don't know if it adds anything, but the issue of funding is often a function of well your voice has been put across. And there may be a correlation between having, for example, Francois Roux as the head of a defence office and the resources available to the defence in that court with the far poorer resources given to the defence, for example, in the ICC. So that it may be a function, but the defence complaints are not only on issues of money in the pocket. A lot of difficulties are things like office space or even court calendars. And it's just on day-to-day matters having an institutional voice. And I think that's the big advantage that having a permanent defence office or having even somebody like Keita as a principal defender, if they had an ability to engage institutionally with the court to a greater extent, they would bring something that defence counsel in private practice don't bring, which is a continuity in all the cases and an overarching understanding of the challenges faced.
Ce que je voudrais dire, c'est que je crois que c'est un problème de culture. Il est certain que le greffier à la Cour pénale internationale a des responsabilités, y compris positives, vis-à-vis de la défense. Mais quand on est greffier, on est chef d'un organe neutre. So, j'allais dire, he cannot advocate. When you are neutral, you cannot advocate. Donc il y a des points sur lesquels le greffier n'est pas le mieux placé pour se battre pour la défense, alors que le procureur aura, lui, la possibilité de le faire. Et avec beaucoup de finesse tout à l'heure, James Stewart nous dit « Je ne suis pas neutre, je suis une partie, mais je ne suis pas partisan. » Eh bien moi, en tant qu'avocat, je suis partisan. Et si je prépare mon budget en tant que manager et que je le présente au greffier, si le greffier décide de m'enlever un P3, que j'ai demandé un P4, eh bien, je n'ai pas accès aux états parties pour aller le discuter moi-même. Donc je suis le mieux placé pour savoir ce dont j'ai besoin. Et c'est ça le problème. Au haut niveau, les décisions sont prises et la défense n'a même pas un strapontin. Et je leur ai proposé déjà de m'inviter, même à titre consultatif, juste pour les éclairer sur les questions de défense. Mais bon, je pense que c'est une question de culture ou de volonté contre la défense. Je crois que c'est plus optimiste de dire que c'est une question de culture.
Who said he had 2 words to add, so we'll yield for those words.
Oui, sur un plan un peu fondamental, sur le travail de l'avocat. J'entendais l'autre jour le président de la Croix-Rouge internationale nous dire, pour nous, la Croix-Rouge, quand un ennemi est blessé, ça n'est plus un ennemi, c'est un être humain à soigner. Eh bien, voyez-vous, pour la défense, c'est la même chose. Quand quelqu'un est accusé, qu'il est menotté, qu'il est emprisonné, l'avocat regarde toujours l'humanité de celui qui est emprisonné. Et c'est l'humanité de celui qui est emprisonné que l'avocat va défendre. Je vous remercie.
No one else? Let's hear. Let's take some questions. We've got roughly 15 more minutes, and then we'll be proceeding to the last part of the program. So, who wishes to raise a question? Yes. Monsieur.
Merci. Je vais continuer à contribuer à la diversité linguistique en posant mes questions en français. Comme mes remarques depuis 2 jours l'ont montré, j'ai un biais pour la défense, évidemment, et je pense que l'équilibre n'a toujours pas été trouvé, notamment à la Cour pénale internationale, et notamment par rapport à la participation des victimes. Mais dans l'esprit de la défense, j'aimerais faire l'avocat du diable une seconde et considérer les erreurs de la défense, parce qu'on passe beaucoup de temps à critiquer les procureurs et les juges à juste titre. Mais je voudrais rebondir sur un commentaire qui a été fait sur les stratégies de défense. Et il me semble qu'en lisant des requêtes de la défense, on s'est tous dit que c'était des mauvaises stratégies, c'était de l'incompétence. Et je sais que dans certains systèmes juridiques, c'est même un moyen d'appel. Une personne peut dire en appel, j'ai été mal défendu. Donc je voudrais savoir si vous aviez des réflexions sur les erreurs qu'ont fait la défense depuis 20 ans dans les tribunaux internationaux et les mesures qui peuvent être prises, notamment en termes d'incompétence. Merci.
So we'll take 2 or 3 more questions. We have others? Yes. Siri?
Je vous remercie, Steven. C'est simplement pour apporter une précision à la suite de ce que Isaac vient de dire. Je constate que pour les chambres extraordinaires cambodgiennes, tous les magistrats, tous les juges sont nommés par le Conseil supérieur cambodgien. Bon, chez nous, c'est différent parce que tous les juges et les procureurs sont nommés par la présidente de la Commission de l'Union africaine. Donc, bien que ce soit les chambres africaines au sein des juridictions sénégalaises, elles ont un caractère international et c'est affirmé à l'article 1, paragraphe 4 de l'accord du 22 août. Il y a donc une légère différence peut-être entre nos deux structures. Voilà.
Well, thank you for that clarification. Other questions or comments? Yeah. Julie. Yes.
Well, thank you, Mr. Chair. Mine goes to Chief Charles Taku, on the issue of confidentiality between the client and Defense Counsel. You highlighted, if I recall, an issue to do with eavesdropping on the communications during the Taylor trial, in its detention. Now, where was he detained and who was taking this information and for whose benefit?
We'll have a chance to respond to that anymore because this will be the last round. I understand we'll take a 10-minute break after our session before we go to the last part. Yes, over there.
Ma question, c'est en fait c'est pour Maître Roux, mais en même temps un peu pour Xavier et peut-être aussi même Pascal Besnier. Je voudrais juste quelques clarifications sur la notion assez floue de la défense. Quand je dis la notion assez floue, ce n'est pas pour faire de la provocation. Je voudrais juste qu'on sache de quelle défense on parle quand on parle des droits de la défense, parce que j'ai entendu avec intérêt tout ce que vous avez dit sur la notion de défense en tant qu'organe. Bon, et j'ai aussi écouté avec intérêt ce que Pascal Besnier a dit, c'est que, indépendamment du système judiciaire que l'on considère, enfin, les avocats de la défense, ou parfois même des parties civiles, c'est des professions libérales. Donc, ils sont organisés autour d'une profession libérale. Mais au niveau maintenant du forum international, il y a cette volonté de l'ériger en organe, mais ça crée une sorte d'illusion optique. Quand je regarde, par exemple, Maître Roux, je suis sûr que dans votre position actuelle, vous êtes auréolé de toute cette pratique antérieure en tant que défense. Mais moi, quand je vous regarde, j'ai aussi tendance à voir un administrateur. Je suis en train de me demander si votre titre n'était pas chef de la défense, mais greffier adjoint, par exemple, est-ce que ça changerait quelque chose à la substance? Parce que de quelle défense on parle? Est-ce que c'est des avocats ou bien de l'administrateur? Donc la question que je vous pose, c'est que est-ce qu'il y a une chose, donc que si votre titre avait changé, est-ce que la substance de vos fonctions en serait affectée? Et à Xavier Keita et peut-être aux autres, la question que je vous pose, c'est que même si maintenant le tribunal pour la Sierra Leone et un peu plutôt du Liban est considéré comme un modèle achevé en termes d'organes, est-ce que vous concevez que dans vos rôles respectifs, il y a quelque chose que Maître Roux peut faire et que vous, peut-être avec même ce statut du minier, vous ne pouvez pas faire pour assurer une défense efficace?
Let's end the questions at this point and just yield to each member of the panel in the order to respond to the various questions. They don't have to take any time if they don't want, but let's try to wrap this up in the next 8 to 10 minutes. So, François?
Merci beaucoup. Les deux questions qui ont été posées ici se répondent et donc je réponds très rapidement. Le modèle du tribunal spécial pour le Liban n'est pas encore un modèle achevé. Il y a encore des progrès à faire. Nous allons pour notre part y travailler dès l'année prochaine et je suis certain que quand il y aura un organe indépendant à la Cour pénale internationale, ils feront encore mieux qu'au tribunal pour le Liban. Mais en ce qui nous concerne, oui, nous avons tous noté dans le passé des difficultés dans certaines équipes de défense. Et un des mandats qui a été donné au bureau de la défense, c'est précisément d'assurer un recrutement d'avocats compétents et sérieux, et c'est pour ça que nous organisons des interviews. Nous interviewons pendant 1 heure chaque candidat pour vérifier ses compétences. Et une fois qu'ils sont inscrits sur la liste, nous leur assurons des formations, et des formations permanentes. Et puis, si nous sommes alertés par quelques difficultés de l'un ou l'autre des membres d'une équipe de défense, nous avons le mandat de mettre en place un monitoring. Ça veut dire par là que c'est ça qu'on a recherché aussi en créant un bureau de la défense, c'est améliorer l'effectivité des avocats de la défense. Voilà. Et j'invite à ce que la même chose soit faite chez le bureau du procureur, puisque ce sont aussi des avocats. Nous nous occupons des avocats et nous avons constaté qu'il faut en effet améliorer l'effectivité et les performances des avocats. Et pour répondre très rapidement aussi à la question, est-ce que si j'étais greffier adjoint, j'aurais les mêmes pouvoirs? Non, absolument pas. Et je pense que parmi les choses à déterminer de manière claire, il faut qu'à la tête des bureaux de la défense, il y ait des professionnels de la défense qui prennent en charge ces bureaux et qui soient un petit peu comme dans nos pays de tradition civiliste, des bâtonniers. Un bâtonnier n'est pas un greffier. C'est quelqu'un qui a une expérience de la profession d'avocat et qui peut, comme on dit le terme, le bâton, c'est-à-dire qu'à la fois il défend les avocats, il défend la défense, mais en même temps il a un bâton. Et ça veut dire qu'il est aussi en charge de la discipline des avocats. C'est ça le rôle d'un bâtonnier, c'est ça le rôle d'un bureau de la défense, avoir dans les mains les deux éléments pour, oui, une fois encore, la discipline des avocats, mais aussi la défense de la défense. Pour que les avocats fassent le plus correctement possible leur métier à eux, qui est le métier de défendre des accusés. Nous ne sommes pas impliqués dans la défense des accusés. Le bureau de la défense n'est pas impliqué. Nous sommes le soutien des équipes de défense pour les rendre le plus efficaces. Si vous voulez juste une image, nous sommes un peu l'équipe qui est à terre et qui apporte son assistance à la course du monde à la voile, mais nous ne sommes pas les capitaines des bateaux. Nous sommes les assistants et nous sommes là pour que tout se passe le mieux possible, dans l'intérêt des accusés et bien entendu dans l'intérêt finalement de la justice. Merci.
Thank you. I posed as well. Charles?
Thank you for that question. I had the opportunity of writing about this particular case and other issues in the special, from the Special Court of Sierra Leone. In the book was published about a year ago, and another book, collective volume, published by a number of international lawyers in Quebec. I published 2 articles on the Special Court of Sierra Leone, and I came back to this issue. Now, nobody authorized this illegal recording in the detention center, ICC detention center, where Mr. Taylor was kept. The reason is because from the motion of the registrar, the representation of the registrar, that conduct was against the detention rules. That communication between the lawyer and Mr. Taylor or any other client, any other accused for that matter, should never be recorded. They were privileged communication. And Mr. Taylor complained. The registrar wrote very forcefully, and the president of the court wrote that the communication in all circumstances between the lawyer, Mr. Taylor, and all other lawyers with their client are privileged unless there is an order from a chamber or from a judge. And I think that answers the question.
Si. Xavier Jean.
Oui, François Roux a été assez complet, notamment sur la formation, ce qui couvre la question sur les erreurs stratégiques. Mais je compléterai en disant qu'une erreur stratégique ou une incompétence d'un avocat ne peut pas justifier le fait que dans une juridiction pénale internationale, la défense n'ait pas la place qu'elle mérite. Il y a des incompétents partout et il y a des sanctions déontologiques et disciplinaires pour leur incompétence. Et la compétence, c'est un devoir éthique et déontologique. Je voudrais compléter par la question du juge Mandiagnan. Qu'est-ce que je ne peux pas faire et que François, par exemple, peut faire? François peut négocier directement avec les États et représenter directement les intérêts de la défense avec les États. Je ne peux pas. Et mes collègues de la défense, lorsqu'ils ont besoin d'une question de coopération, ils sont obligés de passer par le greffe. Mais par moment, il y a des questions de stratégie, ils n'ont pas envie de partager leur stratégie. Autre exemple, il y a 4 ans, avant la conférence de révision de Kampala, mon bureau a préparé un modèle de contrat de mise en liberté, d'acquittement, mais la Cour m'a refusé que je le remette aux États. Il fallait que ça circule entre organes. Résultat, on a déplacé des virgules pendant 3 ans, et le résultat, c'est seulement récemment qu'un accord de mise en liberté provisoire possible vient d'être signé avec la Belgique. Entre-temps, il y a eu des mises en liberté qui ont été ordonnées. Il y a même un acquittement qui a été prononcé. Moi, j'aurais négocié il y a 4 ans directement avec les États. Et j'aurais mis en place une shortlist d'États prêts à accueillir toute mise en liberté ou tout acquittement. Parce qu'au-delà des questions de défense, c'est l'image de la Cour qui en pâtit. Quand une décision d'acquittement, comme dans le cas de Ngucholo, a été rendue, le seul acquittement de la Cour, il a été libéré des prisons de la Cour, mais il a été mis en détention pendant 3 mois à La Haye, parce que dans son procès, Ngucholo avait témoigné contre Kabila, et c'est un ancien militaire, il pouvait partir partout, sauf en RDC. Et les Hollandais disent, non, non, il va en RDC, c'est son pays d'origine. Il a passé 3 mois en détention. Et là, maintenant, il erre dans la ville parce que nous n'avons pas su anticiper un acquittement. Ben, quand on juge, ben, il faut prévoir peut-être de condamner, peut-être d'acquitter. Et ça, un organe peut négocier dans l'intérêt de la défense et une cour n'a pas forcément cette culture côté défense.
Pascal.
Oui, moi j'aime beaucoup la question des erreurs commises par l'avocat, parce que je vois bien où vous voulez en venir. Hein. Le procureur, il relève d'une hiérarchie. Donc finalement, les erreurs, s'il en commet trop, il finira par plus être en cours. Tandis que l'avocat, il relève uniquement des instructions de son client. Mais d'abord, c'est très difficile de qualifier une erreur commise par un avocat. Je vous donne un exemple. Il y a quelques années, jusqu'à il y a quelques années, on considérait que c'était une erreur de ne pas déposer d'exception préjudicielle. Et puis, on s'est rendu compte que les exceptions préjudicielles, ça permettait au procureur d'améliorer l'acte d'accusation. Et donc, en fait, ce n'est pas du tout une erreur de ne pas déposer d'exception préjudicielle sur certaines questions. C'est ce qui s'est passé dans le dossier du gouvernement. Il y a tout de même 2 garde-fous. C'est que, comme tout le monde l'a dit, on désigne des avocats qualifiés, ça c'est la première chose, et ensuite c'est l'appréciation du client. Seul le client, le bénéficiaire des services, peut ultimement à la fin juger quelle est la compétence de l'avocat. Et moi je trouve que la question de Mandiagnan est pertinente aussi. Je ne suis pas du tout sûr d'avoir un avis très tranché sur la question. Qu'est-ce que la défense et est-ce que dans le fond cette question d'indépendance ne va pas heurter la question de l'organisation, soit d'association, soit d'un barreau. Je sais qu'on va parler de ces questions au moment de la deuxième conférence de la défense à La Haye, et I'm looking forward to discuss this issue, et aussi la question du bâtonnier. Merci.
Karim?
I think, of course, all of us make mistakes, all of us make errors, and defense are not immune. We make mistakes on a daily basis. But if one was to talk in general terms, I think the mistakes, if one was to make a very generalized comment, I think in the early days in particular, but even today, a typical mistake that defense make is putting on politicized defenses. Somehow viewing that, of course, the world is not fair. There is no absolute justice in the world. There is a form of justice for certain countries, and not for others. I mean, the fact of Chapter 7 referrals speaks eloquently to that reality. But very often in the early days, the defense and accused that came before the court thought they were a witch hunt, the judges couldn't be trusted, and then they put on really nationalist defenses. They were continuing wars, in some respects at least, in the courtroom. And I think with maturity, practitioners have realized, and particularly the ones that have been more successful have realized, that the judges actually can be trusted. And if you put forward defenses based upon the evidence, looking at affirmative defenses, looking at what the prosecution have done or have not done, that is actually the best recipe for an effective defense. So that's about mistakes for the past. It's political defenses, I think, generally. In relation to the Charles Taylor case, in fact, I filed a motion regarding the video camera in the consultation room reserved for legal consultations. Such an order was also made, or such a camera was in operation in the Labanga case. It was ordered to be turned off. It was a decision, in fact, of the registrar of the special court, and there was a delay why it wasn't turned off. But there's no suggestion at all, even by the defense, that anything from those conference rooms leaked out to the prosecution or to the judges. So there's no suggestion that would somehow call into question the fairness of the process before independent and impartial judges, and I think the judgment speaks for itself. In relation to the last point, and this is why I said I'm not a big believer in just the structure being a safeguard, because history has told us, even in constitutions, it's the spirit that's breathed into the structure that's all important. Now, whilst I'm content that we're very fortunate in having Francois Roux as head of the Defence Office of the STL, maybe I would not be so sanguine if it was somebody else. Because under the minute you have a omnipotent or overarching Defence Office, the Rule 57 of the STL allows the head of the Defence Office pro moto to intervene in your own proceedings, where there's a Defence Counsel, to make submissions that may or may not be in accordance with the Defence Counsel. Now, wisdom has shown, of course, that hasn't taken place so far. But what if it does? And so the best recipe is good judgment, and the structures, of course, seek to reduce and minimize the mistakes that can take place.
Thank you. Karim, Isaac, you have the last word.
Thank you, Ambassador. I'd like to respond, first of all, to the question posed by Judge Mandiaye-Nyang about perhaps the role that the Defense Office should have. I think that in these international tribunals, the defense has generally been treated almost as an afterthought. It's as if the people who set up the tribunals decide they're going to judge people. They set up a prosecutor's office and create trial chambers. Then, as an afterthought, they throw in the defense. And the defense is not usually consulted when major decisions are taken, either procedurally or in other matters. So yes, it would be nice if they could be included, if they could be given a more prominent role. But I also feel that it's dangerous if you make the defense office too much of an administrative organ. The lawyer's profession is essentially a liberal one. The lawyers ought to be free to go as they wish without having too much of a bureaucracy imposed on them. We tried to do that in the Cambodia Tribunal, where the lawyers really have a lot of freedom to do what they would like to do, and we represent them. For example, about a month ago, we had a plenary session of the judges, and the defense lawyers are not allowed into that meeting room. I had to represent their views. So before the meeting, I got from them all the different things that they wanted articulated to the judges and presented those. I'd also like, finally, Ambassador, to come back to the issue that you raised earlier regarding the alleged boycott of proceedings by the defense lawyers in Cambodia. The reality is that the trial chamber judges in this particular case, case 002, decided about 3 years ago to sever the indictment, not by separating the defendants from each other, but rather by breaking the huge indictment into several manageable parts, as they call them. Each part would constitute a separate judgment coming to finality when they render a verdict. The first such trial, case 002/01, as it's called, ended on the 7th of August. Ambassador Rapp, you were there in Phnom Penh on the 7th of August when the judgment was pronounced. And both defendants were sentenced to life imprisonment. They were found guilty and sentenced. They're appealing that judgment, and their appeal briefs are to be filed on the 29th of December. Meanwhile, the trial chamber wants to start the second trial. In fact, opening statements were heard on the 17th of October. Now, the accused, one of them, Mr. Q. Sampan, says, hold on a minute. You've sentenced me to life. I am trying to appeal this. My one chance to get this corrected is an appeal. I cannot possibly start a second trial right away. So please wait 2 months. Let me file my appeal brief. He said, at my age, he is 83 years old. He says, I want to participate, but I'm too old to do both things simultaneously. So he ordered his lawyers not to participate in the second trial until they have filed their appeal brief. So it's not the lawyers that are boycotting. It's the client who instructs his lawyers to do one thing at a time. The second defendant in the case, Mr. Nguyen Chia, alleges that the trial chamber in its judgment committed very, very many errors. In its notice of appeal, the defense team listed 228 grounds of appeal committed by the trial chamber. Mr. Nguyen Chia has filed a motion for the disqualification of the trial chamber judges. The first panel that judged him and sentenced him to life is going to try him in a second case under the same indictment. That's quite unusual. So he has said he instructed his lawyers not to participate in the second trial, but to focus on his appeal until the special panel set up to rule on the disqualification motion has made a decision. As of today, that decision hasn't come. So it's not the lawyers that are boycotting, it's the clients that have instructed their lawyers to focus on one procedure at a time. Thank you.
Thank you for those final words and clarification. And let's thank the panel for their great presentations and take a 10-minute break.
Thank you very much, Ambassador Rapp, and thanks to the panelists again. And on the program, you would see that between panel 5 and panel 6, there were no breaks, and I was told it would be cruel and unusual not to concede a 5-minute break at this time. So it will be done, and I would be most grateful if you could come back very promptly. Thank you. ICTR for the wrap-up that will be followed by closing address by Mr. Suarez. Thank you.
Good evening, distinguished colleagues and friends. It is indeed a great pleasure interacting in the course of the past 4 days with so many of you, from my two co-musketeers, Adam and Eric Moser, with whom we formed a triumvirate COCO to manage the affairs of the tribunal at the peak of its operations during the years when Eric was president of the tribunal, with Presidents Van and Meron here, respectively presidents of the ICTR and also of the ICTY MICT. Mr. Suarez, our distinguished visitor legal advisor to the United Nations and Under Secretary General for Legal Affairs, my colleague prosecutors who were attending the colloquium on Tuesday and Wednesday of this week, registrars, current and former staff, and all the other champions for global justice who are present here. I thank you all for your presence and your participation over the past 4 days in this series of events which have been organized to commemorate the 20th anniversary of the ICTR. We are now about to reach the end of this symposium on the legacy of the ICTR, and the past 2 days have given us a good opportunity for a useful dialogue to start evaluating the performance of the tribunal. It is only, of course, the end of the conference, but a very preliminary effort, a very preliminary beginning at assessment of the legacy of the ICTR. That process will continue for a considerable period of time into the future and will be carried out by others other than us as well. My good friend, Professor Bazwini, likes to say that the consequences of that the jury is still out on the consequences of the Napoleonic invasion of Europe. But I don't think we will have to wait 2 centuries for evaluation of the work of the ICTR. Ours should take a much shorter period. So we hope for an early return by the jury in the case of the ICTR. But nonetheless, the process of assessment and evaluation must begin now, particularly when the principal actors are still of sound mind and memory. And the symposium is Act 2 in a 3-stage process of commemoration, which commenced earlier this week, as I mentioned, with a colloquium of prosecutors focusing on the theme, the local prosecution of international crimes, challenges and prospects. And that first act brought together the international prosecutors or their representatives. And I'm pleased to see some of them still here, among them Brenda Hollis, the prosecutor of the residual mechanism for the Special Court for Sierra Leone, and some 20 other national prosecutors as well. It brought us all together to consider the ways in which the local jurisdictions can be sufficiently empowered to discharge their primary responsibility to investigate and prosecute international crimes. And this, as President Meron indicated earlier today, is one of the major challenges facing accountability today, given the limitations of the international system. The future of the system of international criminal justice should not be held hostage by, on the one hand, an undoubtedly efficient, competent, but limited international process, and on the other hand, by a field of unable or unwilling states which are unable or willing to discharge their primary responsibility. The gulf between those two provides ample ground for impunity to grow and to flourish, and we must struggle to make sure that that does not happen. And that is why, as prosecutors, in the 2 days of the colloquium, we devoted considerable time to identifying what states, each state can do on its own to discharge its responsibility, what each state can do together in partnership with other states towards that end, and what the rest of the international community also should do to assist those states which are able but not willing, which are willing but not able to take on that responsibility. And we have tried to capture our positions in a brief resolution on this issue, which is a public document. Any assessment of the ICTR, its successes, its challenges, its difficulties, must, of course, look at, amongst other things, the following issues. Has the tribunal accomplished its mandate of prosecuting those who committed serious violations, in the words of the statute, in Rwanda and in neighboring countries from 1st January 1994 to 31st December 1994? Have we carried out effective and fair trials of such persons? Has the tribunal had any impact on Rwanda, the community that was most directly affected by the genocide? Has it had an impact on neighboring countries or even wider afield on other countries? Has it affected the lives? Has it touched the lives of the people of Rwanda and peoples elsewhere? John Hawking, the registrar of the MICT, spoke very eloquently and gave us 2 examples today, this morning, on aspects in which the tribunal has touched the lives of people. We also heard from Sarah Kilemi on a different aspect of touching of lives, the work of the Spouses Association, which has devoted considerable time and resources to providing humanitarian assistance, not only in Arusha, but also in Kigali, to medical facilities, to schools, to orphanages, and also to providing safe drinking water to deprived communities here. That is one thing also that the ICTR will be remembered for. The other question will be, has the tribunal had any impact on the current and future global struggle for justice and accountability? Does the legacy of the ICTR provide any useful lessons for local and international prosecution of international crimes? Anyone who wishes to embark on finding answers to these questions, I take it will do so very objectively and fairly, and with the interests of promoting justice uppermost in their considerations. But for me, the answers are evident. The answers to these questions are evident, and I need not enter into that debate. We've touched on various aspects of the work of the ICTR which relate to these issues, including case and trial management, assessment of evidence, prosecution of sexual violence, management and protection of witnesses, cooperation and relationship with states, with civil society, with international organizations. We've looked at fair trial issues, administrative challenges, etc. It's been a very diverse and wide-ranging discussion, and each of those subjects, I think, it merits more in-depth examination and could benefit from more in-depth examination. I think this forum has been very useful in providing us with a bird's-eye view, a global view of the work of the ICTR and doing a preliminary global assessment. It would be very useful in the next stage for us in this evaluation to focus on each of these issues or groups of issues and look at them more in depth. And I think that would be a very useful way to proceed in this evaluation process. But for now, I would like to highlight some aspects of the work of the Office of the Prosecutor, which in my view do impact on the legacy of the tribunal. The office, the OTP we call it, as you may be aware, is responsible for the investigation of and prosecution of the cases, and more particularly the selection of targets for investigation, the collection of evidence, the presentation of indictments to the chambers for confirmation, the tracking and arrest of fugitives, the presentation of the case against the accused before the judges, the filing of requests for transfers of cases, prosecution of appeals, etc. So it is thus evident that the performance of the OTP in these diverse areas impacts on the legacy of the ICTR. Either way, any deficiencies on the part of the OTP would impact on the legacy of the ICTR, and any positive aspects of the OTP's performance would similarly also impact positively. And so also do prosecutorial policies and strategies. So any consideration of measures of case management, for instance, in the context of legacy, does need also a consideration of prosecutorial strategies, policies, and internal working methods which have had an impact, positively or otherwise, on the overall attainment of the ICTR mandate, and more particularly on the attainment of fair and effective trials of the accused within a reasonable time. And in this context, I believe it is important to note that despite numerous challenges, and without the assistance of conditionalities which have benefited, for instance, the ICTY in its tracking of fugitives, the OTP was able to track and secure the arrest of 83 of the 93 fugitives. The conditionalities for relations with the European Union assisted the ICTY tremendously in ensuring that it has a 100% success rate in tracking and arrest of fugitives. No such conditionalities are available, have been available to the ICTR. And so it's been left essentially to the skills of the tracking team, to the diplomatic efforts of the prosecutors, the president, the leadership of the tribunal, and also the influence of other member states, the pressures that other member states bring to bear on non-cooperating states. So we haven't had that benefit of conditionalities, but nonetheless, it's been a pretty good record. 83 out of 93 is not a bad record at all. These arrests, of course, are particularly important, and not just important, but necessary, because the work of the tribunal cannot commence, could not have commenced without any arrest, given that the rules do not allow trials in absentia. That was the first major hurdle which had to be overcome. And if I may add, the experience of the OTP in tracking has now been compiled in a lessons learned manual, which is now used by the Interpol for its capacity building and tracking program. Various aspects of the new indictment policy of the office adopted in 2004 also impacted on the management of individual cases, respect for the rights of the accused, and overall on the implementation of the completion strategy. I'll cite a number of instances. The decision of the office, for instance, to shift from multiple accused to single accused cases from 2004 saw the more expeditious trial of individual cases. It saw the completion of more cases, more trials, and greater advances in the implementation of the completion strategy. Clearly, the shift from multiple to single enabled the chambers, enabled everybody concerned to be better placed to manage the trials than in these multiple accused cases. The successful negotiation and conclusion of guilty pleas, I believe there were 7 of them, also reduced the workload and saved the tribunal considerable time and resources. The indictment policy also enabled us to reduce the counts charged in any particular indictment to a selection of what we thought was best supported by the evidence. It helped focus the cases on the most important allegations and expedite trial. The use of judicial notice, for instance, in the case of Caramera, had a tremendous impact in the management of the cases. It almost halved the burden of the prosecution, in that from 2006, when the appeals chamber under Judge Meron decided that judicial notice should be taken of the occurrence of the genocide and that it needed no longer to be proved by evidence, it almost halved the size of the cases for the prosecution, we dispensed with calling evidence to establish the occurrence of the genocide, a process which had been repeated in every case between 1994 and 2006, when this decision was taken. That was a tremendous decision by the appeals chamber. So it expedited the cases, but it also had the effect, I believe, of closing the door to negationism of the genocide. It had that effect. So the size of cases following that momentous decision was significantly reduced, with the focus being only on the role or otherwise of the accused in the genocide. Again, I think the persistence of the Office of the Prosecutor with the strategy for referral of cases to national jurisdictions enabled the tribunal not only to transfer cases to Rwanda, but enabled us as a tribunal working with Rwanda to contribute to the rebuilding of its legal system through various law reform initiatives, through capacity building, training of staff, and institutional reforms. Frankly, until the ICTR got involved in this strategy of referrals of cases to Rwanda, there was really very little interaction between the tribunal and the Rwandan legal system. There was hardly anything. It was when it was decided that we will go for this transfer that the tribunal itself as a whole, chambers, registry, prosecution, got involved. So in that way, the tribunal began to have an impact on the legal system of that country. The referral was important for many reasons. Number one, it reduced again our workload. We've sent away 10 of our cases, 8 to Rwanda and 2 to France. It was important also because it was the avenue for the tribunal to really assist Rwanda rebuild the legal system. But thirdly, it was important also because once the tribunal decided to send cases to Rwanda, in other words, it gave a stamp of judicial approval to the legal system of Rwanda, that opened the door for other countries in Europe, in the Americas, in Canada, to now extradite their cases back to Rwanda for trial there. And in that way, the tribunal itself then closed what had been really a gap, a bottleneck in the struggle against impunity. Because you had many suspected genocidaires in countries, residing in countries which lacked jurisdiction to prosecute them, but we were reluctant to extradite people to Rwanda also, given concerns about the fairness and efficiency of the system. But the international judicial approval given by the judges of the ICTR, I think cleared away those concerns and so really promoted overall this struggle for accountability and against impunity. More recently, the office has been focusing significantly on its own and in partnership with the counterparts in other tribunals on the identification and compilation of best practices or lessons learned on various aspects of the prosecutorial mandate and function. We have been doing this in the belief that such a program can provide useful guidance to succeeding generations of local and international prosecutors. Together with the other tribunals and prosecutors, we have now published a joint compendium of lessons in the investigation and prosecution of international crimes. The OTP of the ICTR has also published its manual on tracking and arrest, which I mentioned earlier, as well as a manual on the investigation and prosecution of sexual violence. Now, all these 3 publications are now used for training and capacity building by various international institutions. Work is ongoing now on Rule 11-based referrals experience and its lessons for implementing the principle of complementarity. There is also work going on the preparation of the genocide story, a narrative of the genocide based on adjudicated and judicially determined facts. The volume will thus be an uncontrovertible account of the cause of the genocide during those days, as it is based exclusively on facts as found by the judges in decisions of the trial chambers and the appeals chambers of the ICTR. Internal measures were also taken within the office in order to promote quality control and assist in timely, fair, and effective prosecutions. And among such measures instituted under the new indictment policy since 2004 were the indictment review of all new indictments, the trial readiness review of cases prior to the commencement of trial, a serious attempt to comply with our OTP disclosure obligations, which Mr. Robinson has spoken about extensively. I must say there was nobody contributed to making the OTP more alert to its disclosure obligations than Peter Robinson. Is he still here? He was very persistent in filing motions for relief based on alleged disclosure violations. But he helped us. He helped keep us on our toes in this respect. And one of the innovations we carried out was to create an electronic disclosure system through which the database would be available to all defense counsel. But its architecture, of course, came in for some criticism, and we've had to redraw it and redesign it. Disclosure, of course, is a major issue relating to fair trial, and our work on it is still ongoing. Even though the trials have been completed, we have a disclosure project being run by the Appeals Division, which focuses on reviewing all the cases to confirm that all the disclosure obligations in respect of each case have been complied with. And where we find that there has been a lapse, even at this stage, we make sure that we do carry out the disclosures that are necessary. All these measures were undertaken not only to improve efficiency in the office, but also in that way to contribute to the effectiveness and fairness of the trials. We've always been in the OTP concerned with effective and expeditious prosecutions. But not only with that, we've also equally been concerned that this should take place with full respect for the fair trial rights of the accused. Unless that is done, of course, at the end of the day, we will face the Court of Appeal, which will set aside the decisions where these fair trial rights have not been complied with, and we are then back to the drawing board. So it's been in our own interest to make sure that the trials are conducted properly and with due regard to all the fair trial rights of the accused. Our office has, in the context of the ICTR, tried to ensure that all these concerns are satisfied through the various policies and strategies I have referred to. Bon anniversaire. Thank you very much for your attention. I have now the pleasure to invite my colleague, Mr. Suarez, the legal advisor to the United Nations, Under Secretary General for Legal Affairs, who is representing the Secretary General here in Arusha on the occasion of the commemoration of the 20th anniversary. I've always said that we all owe a great debt to the United Nations generally, but more particularly to the Office of Legal Affairs of the United Nations. The struggle for global justice through the establishment of tribunals, ad hoc and international, has really been led by the Office of Legal Affairs. They have been responsible for conceiving and creating these tribunals, drafting the statutes, establishing them, nurturing them, nursing them, midwifing them up to maturity. And we owe them a great debt, not only us, but the rest of the global community as well. Mr. Suarez.
Thank you very much. Well, to start with, and contrary to some voices from the defense, I do consider it a great honor to speak last. So I do thank you for inviting me, and I do thank you for giving me the honor of speaking last. And aussi, au préalable, je vais m'excuser auprès des non-anglophones. J'avais préparé les quelques lignes de mon intervention exclusivement en anglais, mais je voudrais vous rassurer de mon grand rattachement à la diversité linguistique et de culture juridique et aussi à la francophonie. Excellencies, ladies and gentlemen, Karibuni. It is a pleasure to address you today to bring to a close the symposium marking the 20th anniversary of the establishment of the International Criminal Tribunal for Rwanda. It is fitting that in closing these events, we look back to some of the principal contributions of the ICTR over the past 2 decades. Indeed, at this point, the ICTR's judicial work is almost complete, with but one remaining appeal case still awaiting decision. We thus have the advantage of surveying the legacy of an almost fully complete corpus of case law. However, I intend also to look forward to consider the momentous impact which the work of the ICTR will continue to have on the future of international criminal justice. Over the past 2 days, we have discussed a wide range of issues. From the discussion panels have emerged thoughtful reflections on the work of the ICTR, lessons learned from its operation, and views on how its work can and should shape the future of international criminal justice. This past April, together with the Secretary General, I attended the commemorative events in Rwanda to mark the 20th anniversary of the 1994 genocide against the Tutsi in Rwanda, during which also Hutu and others who opposed the genocide were killed. The international community must never forget those horrendous events. I echo the message of the Secretary General that we must learn every lesson from the horrors of 1994 to ensure that genocide is never repeated. And here, allow me just a very personal comment. It always makes my special assistant very nervous when I stop reading my written materials and I go spontaneous. But I promise not to go too spontaneous, or at least as spontaneous as a UN high official should be. Now, I had, in fact, the privilege of accompanying the Secretary General to Kigali this April to participate in the Kwibuka ceremonies. This word that means simply remember, but that the government from Rwanda are very cleverly associated also with the words renew and unite, that being the essence of reconciliation. And of course, you understand it was a highly emotional moment to participate in the main event in the stadium together with thousands of people, this sort of a collective catharsis. And you feel that not every wound is still healed. And within the program, I had the opportunity to visit the Genocide Memorial. It was actually closed, it was a bank holiday, but the staff in charge was very generous to open it for me. I visited together with a Rwandese colleague. And you start the visit going through a very beautiful rose garden. I mean, the ones amidst you who have visited the place know what I mean. And then you are told that underneath these beautiful rose gardens, there are thousands of people buried. And in the museum itself, at some stage you go into a room and you just have photos of children with small little stories attached, but small stories of their personal life, like here is Jean or Antoine, he wanted to be a pilot or a police, you know, the usual children talk. And his favorite dish was steak et frites or steak and mayonnaise, all the things that you remember. And then these little stories finish. He was stabbed in the head together with his grandmother. He was 6 years old or 7 years old. And I think it was important to say this because this very much gives a sense of purpose to my work in the United Nations. And it should give a sense of purpose to the work of everyone involved in international criminal justice. This being just about the ordinary lives of ordinary people that at some stage were terminated, that at some stage was slaughtered without compassion. and trying to make it more and more unlikely and more difficult to happen again. Now, I have to remember these while dealing with some of the political and diplomatic complexities around international criminal justice, and in dealing with some of the skepticals about international criminal justice. Now, the establishment of the ICTR in November 1994 was a key response on the part of the international community to the atrocities which had been perpetrated in Rwanda. There was a demand for accountability for those who were responsible for the genocide and other serious international crimes carried out during 100 days of horror and grievous suffering. The establishment of the ICTR and the year prior of the International Criminal Tribunal for the former Yugoslavia marked the beginning of 2 decades which have seen the most profound change in dialogue within the international community when atrocity crimes are perpetrated. Before the early 90s, international criminal justice was a lofty but in large part theoretical ideal with little practical impact since Nuremberg. However, over the past 20 years, we have witnessed a sea change in realizing accountability, not just in rhetoric, but in action and in deed. We have seen the development of a deep and broad body of both substantive and procedural international criminal law. And this has led to the creation of a framework of international criminal justice which has the power, in complement with effective action at the national level, to ensure real accountability across the whole range of perpetrators of international crimes. It is now axiomatic that those who hold the highest echelons of power can no longer consider themselves above the reach of law and expect to commit serious international crimes with impunity. At the time the ICTR was established, such a notion was still a radical view in international discourse. Yet the ICTR has shown reach extending to the highest ranks of political and military power, with the conviction of the Prime Minister of Rwanda for genocide in the Kambanda case. Many ministers, military leaders, and prefects have been brought to justice before the tribunal. Just this past September, the Appeals Chamber upheld the convictions for former Minister Karemera and National Party Chairman Ngiru Mpatse for genocide and crimes against humanity. The jurisprudence of the ICTR has contributed in many other important respects to the development of international criminal law. One area of law in which its jurisprudence has been of enormous significance is the area of accountability for crimes of sexual violence in armed conflict. Such crimes are often perpetrated against those most vulnerable in society. In its seminal judgment in the Akayasu case, the ICTR was the first international tribunal to find someone guilty of rape as a crime of genocide. The impact of this jurisprudence is readily apparent from the frequency with which other courts and practitioners around the world have cited this law of the ICTR. A cornerstone of the international criminal justice system has developed over the past 2 decades, namely the principle of complementarity. This principle is elaborated most fully in the preamble to the Statute of the International Criminal Court. However, it has also become key to the work of the ICTR, ICTY, and the other international and United Nations-assisted criminal tribunals. The principle of complementarity reaffirms an elementary principle. States are primarily responsible for prosecuting those who have perpetrated serious international crimes. An international court or tribunal has a subsidiary role to play, engaging only where states are unable or unwilling to genuinely investigate and prosecute. The international criminal tribunals could not be, and were not intended to be, the fora before which all perpetrators of the crimes within their jurisdictions would be tried. As we know, very large numbers of people perpetrated the atrocities which led to the genocide in Rwanda. This was also the case in the former Yugoslavia and in other states where mass atrocities were committed. International tribunals are not endowed with the financial and other resources all the time which would be necessary to bring to justice in full the very large numbers of persons bearing responsibility. Indeed, in examining the evolution of the mandates of the international and United Nations assisted criminal tribunals, we can discern a trend towards narrower jurisdictions conferred upon them. This re-emphasizes the original point that the focus of prosecutions at the international level is, as it must be, on bringing to justice those most responsible for the most serious crimes. National courts and domestic reconciliation mechanisms therefore have a vital and essential role in ensuring that there is no accountability gap where an international jurisdiction no longer has a role to play. In the context of the ICTR, the principle of complementarity has additionally found specific expression through the referral of cases pursuant to Rule 11b of the Rules of Procedure from the ICTR to Rwanda for prosecution at the national level. These cases are monitored both by the prosecutor through an independent monitor as well as by the residual mechanism and the tribunal. Within the Office of Legal Affairs, we have a clear starting point for considering the future of international criminal justice. We begin with the firm conviction of the United Nations that justice delivered according to law is an essential precondition to sustainable, lasting peace within and between communities. The legacy of the ICTR includes not only its many important and groundbreaking judgments which have advanced international criminal law. Its legacy includes the record of the judicial process itself. Legal proceedings are somewhat unique in the way in which they create a historical record. The judicial process is the culmination of painstaking and detailed investigation and research. The accused have the opportunity to present their case on both the facts and the merits. Victims and witnesses of serious international crimes, often the most marginalized and underrepresented sectors of society, can come to tell their story. Indeed, the progress made over the past 20 years in the field of international criminal justice owes a great deal to the courage of those individuals who have come forward to testify about the horrendous events which they have endured. One of the most significant decisions of the ICTR, having heard the voices of many of these victims and witnesses, was to take judicial notice of the fact that between the 6th April 1994 and the 17th July 1994, there was a genocide in Rwanda against the Tutsi group. As this audience is well aware, genocide has a specific, tightly defined legal meaning. It has been called the crime of crimes. Its prohibition is a norm of jus cogens status, and it is an obligation owed erga omnes to all states. The fight against genocide was again recalled by the Security Council in April this year, when it unanimously adopted the landmark resolution 2150. That resolution called upon states to recommit to prevent and fight against genocide and other serious crimes under international law. The Council underscored, and I quote, the importance of taking into account lessons learned from the 1994 genocide against the Tutsi in Rwanda during which Hutu and others who opposed the genocide were also killed, end of quote. Of course, the nature of the judicial process can and must be able to render acquittals as well as convictions. It is essential that acquittals are not understood as denials of the commission of a crime. Rather, the important principle is to maintain respect for the judicial process in assigning individual criminal responsibility. As we mark the 20th anniversary of the ICTR, we note that it is scheduled to complete its work next year and to conclude the transition to the residual mechanism for international criminal tribunals. I am very pleased to note that the transition has gone smoothly, and I have full confidence that will continue to be the case in the coming months. I have touched upon the various aspects of the tribunal's legacy, its strong body of jurisprudence, its contribution to the development of international procedural law, its judgments which have brought about accountability for heinous international crimes. Building upon all of these achievements, however, I return to the principle that reconciliation and justice must go hand in hand. We have seen this time and again. Unfortunately, today, we continue to see situations in which atrocity crimes are perpetrated. Individuals continue to abuse positions of political and military power, with civilian populations the subject of targeting. However, when those atrocities are committed today, there is a clamor for accountability. People and civil society demand justice, and upon that justice, communities, nations, and societies can move to build a collective future protective of the rights of all. It may take time before perpetrators of serious international crimes will find themselves before the bench, but they must know that impunity is no longer an option. Impunity is no longer an option. Just this year, judgments rendered in Cambodia in respect of crimes committed by political leaders almost 40 years ago are testament to that fact. The ICTR, for its part, has played a fundamental role in this regard. It is an integral part of the international justice landscape. Those who prosecute serious international crimes in the future, at national level as much as at an international level, will find wisdom and guidance in the work of the ICTR, both in its substantive contributions to the law and to the fabric of accountability it has woven alongside other courts and tribunals. The discussions of the last 2 days have highlighted many aspects of the rich legacy of the ICTR. Humanity, both in Rwanda and globally, is the stronger for the ICTR's work. On behalf of the Secretary General and on my own behalf, I wish to congratulate all of you who have contributed to the ICTR's work to fight impunity and to bring about an age of accountability, in particular the judges, the prosecutors, the defense lawyers, and their respective staff. Their collective accomplishments have guaranteed such an enduring legacy. Thank you very much.
Thank you, Prosecutor Diallo. Obrigado, Senor Soares.
Very good.
These will be our final announcements for the day, so I beg your indulgence. First of all, I am to reiterate the need for you to confirm your travel arrangements. Our Legacy Committee members are looking forward to hearing from you. Then, an amendment to our previous announcement this morning. Shuttles from the hotel to the ICTR will run tomorrow from 9 a.m. to 10. Therefore, the last shuttle will leave here at 10. And these black rimmed glasses were found in the room yesterday. They're yours. Kindly claim them. Thank you. And finally, the ICTR and the MICT principals together with Mr. Dieng and Mr. Suarez, are invited to remain in the room to meet the press. I thank you for your attention. Bye.